Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, and thanks for joining us. Our coverage begins in Broward County, Florida today with the double murder trial of Jamell Demons, better known as rapper YNW Melly. The 24-year-old is facing the death penalty for the 2018 shooting deaths of his two friends, Anthony Williams and Christopher Thomas Jr. The Murder on My Mind rapper was in a vehicle with the two victims and his co-defendant, Cortlen Henry, when the shooting occurred. Now, Demons and Henry claim that the rappers were targeted in a hit-and-run drive-by shooting, but authorities later discovered evidence to suggest the shooting came from inside the vehicle. And of course, this left Demons and Henry the main suspects to the crime and accused of staging this as a drive-by shooting. Now, as we wait for day 14 of the state's case to start up, and I'm keeping a careful eye on that courtroom feed, I'm joined right now by our boots on the ground, Law and Crime's very own Terry Austin, who has been our eyes and our ears. She is inside that Broward County courthouse for us, and she joins us today. Good morning, Terry.
Good morning, Jesse.
So when the day ended yesterday, the state said that they still had about 2 more hours of questioning lead detective Mark Moretti. So he's been on the stand for a while now. What more can he testify about today?
Well, I think the entire audience was wondering the same thing, and perhaps the jury. He's been on the stand since Monday afternoon, and he's gone over cell data, and he's also gone over various videos, Facebook entries, and Instagram entries. And I do think the prosecution is trying to establish a couple of points here, although I think they belabored the issue, and the jury at the end of the day was very tired. I think they're trying to establish that that 9807 number belongs to YNW Melly. And so they went through hundreds probably of Instagram messages where he's giving his telephone number out. But I think the jury is already aware that if it's not his phone, it's registered in his mother's name. He uses the phone. Maybe other people use the phone, but they painstakingly went through all of that data. They also showed a couple of videos. Some of the videos I'm not sure are really relevant. They had Melly showing his teeth. They had, videos of him with the two victims, Christopher Thomas and Anthony Williams. And frankly, I think those videos were a bit endearing, showing their friendship and their longtime close alliance with that YNW collaborative.
Okay, I want to get to those videos in a minute, but I want to go back to the phone number. Why is it important for the prosecution to establish that that phone number is associated with YNW Melly? Why do they want him to have that phone?
Well, that's a great question. I mean, they don't have, to my knowledge, any evidence like a smoking gun saying, okay, I did it. And they don't really have any longitude or latitude saying he was right there at the time. The phone is there in the area at the crime scene, but they don't really have him holding the phone at that time. So I'm not really sure why they're spending so much time trying to show that it is his phone. I don't really think that's a big issue at this point, and I think the jury is getting really tired of all of these tedious messages that the witness is reading. Mark Moretti is reading all of these messages and who it's from and who it's to and what time it came in, and I think the jury is thinking, okay, it's his phone. They don't really care.
What makes you say that? Are you looking at the jury and they're displaying some signs of frustration or maybe being tired?
Absolutely. At the end of the day, it was really hard for any of us, all of us. And I will say even it looked as though like the judge, we were all sort of in a glaze because there were just so many messages being read. And yes, some of those jurors, I think, were very tired. Now, I won't say any of them fell asleep because they've tried to be very attentive, and they were for most of the day. But at the end of the day, Jesse, there's no question everybody in that courtroom was exhausted.
Mm-hmm. Okay, let's talk about the documentary. We saw it here when I was hosting in the morning. I couldn't make sense of what it was, what the documentary was, and what the significance of it was. What can you talk to us about that? What can you tell us about that?
Well, it's a documentary that was made by his record label about him, trying to show, I think, that, he has a human side and what he went through growing up is in terms of how he got to where he is. And it started out with him saying, boasting about himself and y'all are here because I'm here. And it was kind of funny, kind of interesting. I think the reason the prosecution showed it is because he was there with the two victims. He was there with Sakchaser and Juvy. But frankly, I believe it helped as far as the defense was concerned, because it showed how close they were. It showed how intimate their relationship was. And at the very end of that documentary, it showed a sort of memorial for the two victims, saying that shortly after this was filmed, they had been, shot and killed. So I definitely think it was a moving video. And frankly, Melly's mom had to get up at that point. It was just too emotional for her.
I wonder if it could also mean, as you said, some of the language he was using, this is my show, I did this, if they're trying to establish some motive why he felt threatened by his friends or felt the need to get rid of them. I'm not sure, I'm speculating. But talk to me about what we saw a little bit later on, because they showed a video of Melly at a music video shoot on the day that Thomas and Williams were killed, on the day of the murders. What was the significance of that?
It's an excellent question, Jesse. I'm not sure. Maybe they're trying to show that he didn't have any feelings as far as their deaths were concerned, or business as usual. But I didn't take anything away from that video. I think in this world, it's very hard to say. They see a lot of deaths all the time.
Let's just be clear. Was that video, was that video taken after the killings?
I don't know, Jesse. That's an excellent question. I don't know if it was right before or right after. My assumption was that it was before. I did not hear the time. And if it was before, then what is the relevance? I'm assuming that the prosecution showed it because it was after, and that perhaps he just went on with life like nothing ever happened. If it was before, what is the point? They were all working together. They were in the studio. There's no question about that they are in the same collaborative. Of course, they're working on music together. So it's unclear to me, Jesse, why it was shown and whether it was before or after the murder. But yes, to your point, it's the same day.
If it's before, it makes me wonder, if he's showing absolutely no signs of committing a double homicide later that day, that's a questionable thing to say in and of itself, but I don't know. Talking about the defense...
I think it's before, Jesse.
So it was before. Again, it's odd, because if he's about to commit double murder, it's weird. It's a little strange. I want to talk to you about the defense, though. So we believe this is going to be the last witness for the prosecution, right? And if that's the case, it's going to be really up to the defense to cross-examine him thoroughly before they begin their case. Did you see any openings where the defense is going to jump on Mark Moretti?
Yes, in fact, I think that they are ready and willing and able to go after him on cross-examination. First of all, we already know Stuart Adelson did a voir dire of Mark Moretti when he was first put on the stand, saying that he doesn't have the background for those cell data records and that he can't talk about longitude and latitude. He didn't put them together. T-Mobile put them together, and the only way he can talk about them is if it is introduced by someone who was the sender or the receiver or T-Mobile who engineered it. So I know they're going to go after that point. I think they're also going to go after, remember, he's the lead investigator. He is the one who didn't follow up on certain leads. And during the direct, the prosecution did say, look, why didn't you follow up on this person? Why didn't you follow up on that one? Wasn't that a good alibi? Is that why you didn't follow up? And I'm certain that the defense is going to go after that and talk about why they didn't go after these leads that could have led to something, and why they simply believed everything that they were told. There's some indication, if you recall, from the defense opening that there are possible other suspects, people who have on social media said, yes, I was involved. So I definitely think that those are certain areas that the defense is going to pursue with this witness.
And yesterday, the defense also mentioned that they want to call FBI agent Brendan Collins, who testified for the state earlier in the case. But as a defense witness, why would they want him back?
Well, I think he is the person who is the cellular expert. I think they want him back to question some of those longitude, latitudes, and to really establish the fact that you cannot pinpoint exactly where those phones were at the time of the crime. And so I think that's why they want to call him back. It's interesting because the judge said, well, you all said he was finished. We let him go. Then apparently he left the country. Now he's back, and they're having a hard time getting him. And the judge did order the prosecution to assist the defense in getting him into this courtroom. So we'll see if it actually happens, but they have been asking for a couple of days to get him back in here.
Interesting. And then in terms of predictions for today, do we think that the state is going to officially rest and then there's going to be the cross-examination already and then we're immediately moving into the defense's case? Or is there going to be an argument for the defense for a motion to dismiss this?
Well, we've already had sort of a preview. We will get an argument to dismiss the case. I mean, I think that's pro forma. I think the defense has to do that. But I think for today, we're going to see the end of that direct by the prosecution of Mark Moretti. She said last night, Christine Bradley, that is, that it will be 2 more hours. And I think the courtroom and the judge were a little bit disappointed by that because it's a long time. But the judge has been very patient in allowing the state to put on its case. I definitely think that the cross-examination will last. If it starts, for instance, after lunch, I think it'll last at least the rest of the afternoon, the rest of the day. And then perhaps we will see closings tomorrow. Today's Wednesday, so I expect maybe we'll see closings on Thursday. The court is usually quiet on Friday, so I think that's why they're anticipating, quote unquote, the end of July, because I'm pretty certain we'll go into next week with those jury charges that have to be reviewed, obviously, and then given to the jury.
What's YNW Melly doing? I mean, there's times that our cameras can capture him, but mostly we're focused on the witnesses and the evidence presented. How's he responding to what we're seeing in court?
Well, actually, I saw him yesterday lean over and say something to the attorney when Mark was up on the stand. Mark Moretti was up on the stand. He's paying close attention. I'm listening to, every little thing I possibly can hear. Obviously, you don't want to hear any attorney-client privilege, but it does seem as though he is watching what is going on that stand. He's looking at the records, and when the messages are being read, I see that he's taking note of that. And I think he's probably, this is a speculation on my part, I think he's probably explaining what's going on in those messages. One thing I'll say, Jesse, is when the prosecution is reading some of these messages, they are totally out of context. So it's very difficult to understand why she's putting them in. They really don't mean much to anyone other than the messages saying, yes, hit me back. Here's my number, and he's giving the number. But as I mentioned before, I don't think the jury is really concerned about that at this point.
And the atmosphere in the courtroom, the high-profile case, people supporting YNW Melly. There's also people who are supporting the victims through all this, and we're, I imagine, looking for a conviction against YNW Melly. What is the atmosphere in that courtroom and outside the courthouse?
Well, Jesse, if I had one word to describe the atmosphere, it would be tense. Yesterday, it was more tense than normal because Jamie King, who is the mother of Melly, she had a threat against her by one of the victim's sisters. And so it was a little tense. She has a bodyguard who's with her at all times now. I think the sheriff's office is paying closer attention to her. I noticed yesterday they walked her to and from the restroom along with the bodyguard. So I think it's a bit tense. The parties are definitely opposing to each other, and it's a very difficult situation. There's loss of life here and there, family members, and it's just a tense situation.
Tough case. Terry Austin, that's all I have for you right now. I know you have to get settled into that courtroom. Thank you so much.
Thanks, Jesse.
All right, for us, we're going to have a special report from our very own Sierra Gillespie, and then we'll take a break. And when we come back, we have a lot more to cover in the YNW Melly trial.
The kids' room right here.
Good morning. Good morning.
Yes, Judge.
You're ready to go?
Yeah, I'll check on them. I know a couple of them were using the restroom.
I think we have a few things to discuss first. Good morning.
All right, let's get on the record, please. In the state of Florida versus Demons, President and the defendant, his counsel, and assistant state attorneys. Jury's in the jury. Yes, sir.
With respect to, there is. Did you label it? Not quite sure what label is reflected in the record. State proposed exhibit. But it is what appears to be a 121-page document reflecting extractions from the 9807 phone that are purportedly the discussions between that phone and Jamie King. We have already interposed our objection with respect to laying an adequate foundation for the introduction of this or any such exchange of text communications. We think that the state has not laid the adequate foundation. However, we also want to renew our objection to the fact that of this 121-page document, I think the state intends to assert relevancy as to a few of the pages, which renders all the other pages irrelevant and therefore inadmissible. There are instances in which the state has indicated that they believe their exchanges which provide context for that which they want to refer to, which is fine. That would make them relevant for context. But everything else coming in for the jury to just peruse through 120 pages of an exchange between the 9807 number and Jamie King is irrelevant, it's prejudicial, it's inadmissible. Beyond that, at page 52 of the exhibit, the court yesterday had indicated that the state should get rid of the reference to what purports to be a request from the 9807 number of Ms. King that said previously, "Get me a Glock."
That was after the murder in question, my recollection.
That is correct.
Do you want to show the judge so he can see in context?
Yes, I'll hand it up in a second.
Here, we can put it on the screen. So they can know.
It's on that.
So if you recall, there was, after this, it included trips that Ms. King made to a gun store to purchase firearms. She sent pictures of various firearms to the defendant. Here, and I remind you, he was 19 years old at the time and an adjudicated delinquent for a firearms-related offense, so he was not allowed to possess any weapons.
Okay. That being neither here nor there. With respect to the argument that we're making now and the objection we're making, if the court sees right above that it says bring Mariah, and then it says okay, and then that previously said get me a Glock, like go now. If it's going to be out, then everything is out. But now it's saying get me, which is an entirely different thing. Now it's saying come and pick me up. And in the same way that messages might be included in order to give context, messages have to be excluded as to not give improper context. This is now saying, representing to the jury that he's asking to be picked up here. And we think that's inadmissible. The very next page, his next statement is, it's get me, and then his next statement is like now, then it says I'll pay you, which is demonstrating some necessary urgency for him to be picked up and the fact that he'll pay for it to be done. I'm not sure how that'll be conflated, misunderstood by the jury, the context of the incident, notwithstanding the date involved. But we object to any redaction which will give a direct misunderstanding to the jury, a misimpression as to the communication that took place. You can't turn it from get me to a Glock to get me. It's turning from get me a gun to pick me up. It should all be gone if it's out. We can't deliberately mislead the jury.
Madam State?
Your Honor, I complied with your Honor's request or order to take out references to any firearms on that in the possession or at the request of the defendant. In terms of the messages, that is what he said. It doesn't say what it was a gun or anything of that. They can say, they can put in get me item, whatever they want in terms of to make it clear in context. He's asking her to buy something, but does not say what it is.
Thank you. All done.
Yes, Your Honor.
Take it out, just believe it. I mean, it's a firearm after the alleged incident in question, which the defendant's charged with. There's no connection with this element of the case. I'm allowing a lot of these text messages in just to show care, custody, control, and ownership of the phone. That's what it has always been about, and why I let leave a message in. You can look at the message in its context, circumstantial evidence as to who owns the phone, all right, and who's using the phone, who's controlling the phone. And therefore, I allowed him in. But this is something talking about guns that happened after it. It shouldn't be there. I sustain the objection. Take it out.
Introductive additional message on
I didn't hear you. I didn't hear you. I'm sorry.
So, in light of the fact that I'm losing my voice, my intention is to publish this in its entirety. So I would ask that with the permission of the court and the grace of the defense to let Ms. Smith help with the publishing of this.
Sure. So, no issue. You don't have this objection, do you?
No, sir.
That's fine. Set up there.
For the sake of scheduling and efficiency, Your Honor, I'm not quite sure. I'm of the impression that this pedometer evidence that we object to, and to which my motion to exclude pertains, is about to come up in this session. And so I'm not sure if the court has had a chance to review the motion and the law that has been cited in support of it, but it might be time to have that discussion. Either that, or I'd like the state to be admonished not to seek to introduce that information until the matter is resolved.
I guess why is the motion filed July 9th? We're 2-3 months into trial already, and you filed July 9th.
As opposed to when?
Prior to trial starting.
Well,
hey, Judge, we have a hearing. This is demand for speedy trial. And you're in the middle of trial, the closing portion of the state's case. You're filing a motion saying, you know something, let's take a step back. None of this evidence should be admissible. All this should have been done before trial started.
I understand. But let me refresh the court's recollection as to the actual sequence, because the court also made a reference to at the close of the state's case. This information and this objection was brought to the court's attention 2 weeks ago, at which, and I provided the court with case law. I read the relevant matters into the record, and the court took the material back, came back and said, this is too much for me to read. This should have been a Daubert motion. This is not a Daubert motion. A Daubert motion is precipitated when the state offers opinion testimony through a purported expert, at which time it triggers the defense if they have an objection to the expert's introduction of opinion testimony to file a Daubert challenging that. What this is, and as a matter of fact, when we first saw this information, and the state, we were sitting down in the state attorney's office and they were playing this stuff on a screen, and I told the state, I'm like, you can't introduce information from data that is on the text of a phone without authenticating it. I just made that statement. But it is not incumbent upon the defense to try to prepare the state for the introduction of evidence. I didn't even have to alert her to the fact that I thought it was inadmissible without authentication. But when the state purports to or attempts to introduce evidence, at that time, it becomes right as to whether or not it is properly authenticated. I alerted her probably a year before trial. But beyond that, it is not incumbent upon us to piece through the state's case and try to perfect their deficiencies in providing proper foundation for the admission of evidence. When they admit the evidence, if it's not admissible for lack of foundation, that's when the objection is right. Lack of foundation. Then the court rules on the foundation. And the fact that the state is of the position that they can introduce whatever comes off of a phone from whatever app without any foundation is a burden that they carry, and if they fail to meet it, then the evidence is inadmissible. It's not, well, the defense should have told you that this is how you should have done it, which I did, first of all. And second of all, I did alert to the court, and it does not make it inadmissible. It's not incumbent upon me to say, get an expert so I can determine whether or not that expert is sufficient and thereby file a Daubert motion. This is not a Daubert issue. This is an authentication foundation issue. And if they do not have and if that foundation has to be laid by an expert, it doesn't thereby transpose it and all of a sudden turn it into a Daubert issue. If that's what they need to put it in, that's what they need to put it in. If they don't, they don't. But it's incumbent upon the court to make a ruling at the time that evidence is being introduced. This is not a Daubert motion. This is lack of foundation. The courts are clear. You have to establish foundation for this kind of evidence in order to put it in. You can't just, and as I said in my motion, it should not escape the court's attention that the only case that the state found to rely upon was a case out of Wisconsin, which with all due respect completely misses the point. It says, Fitbit's around for a while and everybody thinks it's reliable. So what? As I said in my motion, horoscopes have been around for a while. A lot of people think they're reliable. It doesn't make it admissible. The question is whether or not their acceptance of reliability is well-founded. And that must be established in order for it to be introduced. The state has failed to do so, and it's inadmissible. Judgment rejected.
You start talking about acceptable reliability. That sounds like a Daubert motion to me. What's the state's position?
Your Honor, this is not a type of information that requires any sort of expert opinion. This is not outside the scope of a regular juror's ability to understand. It shows that there was activity and that the phone was moving around at 4 a.m. It shows that the phone was moving around again at 4:40 a.m. This is corroborated by multiple sources on the phone, and pedometers, I think the first case I cited in this case to the court, pedometers have been used since 1967. This is nothing new or novel that requires any additional testimony whatsoever. Based on the background, the state would submit that the activity data is well within the purview of any juror and would be admissible.
Your Honor, just one retort. There are two components, and we're conflating issues. Expert testimony is admissible, opinion testimony, when it helps to a jury to understand an issue. In this instance, we're talking about authentication, which is this information reliable? It's not a question of whether or not they know how pedometers work. The question is whether or not a pedometer produces reliable information. Their internet is littered with instances where these pedometers have different information that differs from reality when it's tested. As I gave you an anecdote of Larry Daniels, our expert, who says his wife plays piano at church, and when she comes down from there, it says she's taken 20,000 steps because every time she taps, it reflects that there is a step. So in order for the state to advance that and the state, and Your Honor, the case that I provided concerned a static Google map. And the judgment was reversed because the proponent of the Google map did not establish the operability of Google Map and its reliability. A static picture. Here we're talking about the state coming to say he went left and he moved in this direction 70 steps, and then he went 100 steps to that direction and 1,000 in the other direction. clearly the risk of inaccuracy is amplified in that type of situation. And so this notion that, oh yeah, but they know what it is. Yeah, but is it accurate? I want to hear a distinction between that and horoscopes. Everybody knows what a horoscope is. Everybody knows how it's purported to work. It doesn't mean it's accurate. It doesn't mean it's admissible. So the fact that it's been around since 19 whatever date is of no moment. The fact that jurors understand what pedometers are purported to be is of no moment. The fact that they do not have any concept or any basis upon which to predicate an understanding as to its reliability and accuracy is of importance. And that's why it's inadmissible.
And again, Counsel, you keep going back to reliability and accuracy, and that's a Daubert motion. Authentication is it what the state or whoever the proponent is that what they say it is? Boom.
The case that I cited, there was no Daubert motion, and it was a lack of authentication at the time of introduction of trial. I understand the court's conflation of the two issues, and yes, in this instance, what would be needed to authenticate it would be somebody with expertise. But it is not incumbent upon the defense to go and say, go find an expert so that I can object to it. That's not what it's about. The question is whether or not you can introduce the evidence that you bring in here into a jury. That's the issue, and it's not incumbent upon me to go through her file and determine what she needs to authenticate each piece of information and tell her to go file it, go find an expert to do it so that I can file a Daubert motion as to that expert's opinion. But I have stated my opinion, I've filed my objection, Your Honor, and we stand up. And I just note the cases that I've cited where this error was made have all been reversed.
Thank you. Madam State, ready to proceed?
Yes, sir.
How are you going to handle this? I know you're losing your voice. How are you going to handle it?
I'm going to start and I'm going to have Ms. Smith then publish. This was the exhibit that we were speaking about first. Was already offered to the witnesses, state, quadruple, quintuple, and third high. So I was going to have Ms. Smith start and publishing that, and the intent is to publish the entire document.
How many pages is this?
And where's the witness? Do we know where the witness is?
121.
He's here, that's my understanding.
I'm going to get him.
All right, why don't you get the witness and then bring the jury in?
No, it's here.
He's on his way.
Thank you. Are we all set? Everybody ready?
Yes, sir.
Bring jury in, please. Jury entry. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, Mr. Demons, his counsel, the assistant state attorneys, ladies and gentlemen, jury. Ladies and gentlemen, when we left the other day, counsel was still on their case in chief. The witness, Detective Morgan, was still on the stand, and he remains on the stand. Detective, you ready to proceed?
Yes, Your Honor.
Counsel, you may.
Yes, Your Honor. Thank you. Good morning, Detective. How are you?
Well, now, thank you.
I'm showing you what's been marked, previously shown to you as well, as state quintuple high. Do you recognize those messages?
Yes, ma'am.
You had an opportunity to review them before you came into court today.
Yes, ma'am.
Have there been any additions to those messages?
No. No, ma'am.
Did they fairly and accurately represent the conversation between the 772-713-9807 phone number and the other phone number that's listed as Crazy or Brazy Lady in that phone?
Yes, ma'am.
And at this time, the state would submit state's quintuple I as state's next number of exhibit.
Any objection not previously raised?
Same objection.
So ruled. It will be admitted.
States quintuple I will be marked states 112.
Detective Murray, I'm going to ask Ms. Smith to be so kind as to help publish this. If you would read the green portions of the messaging, she will read the blue and read the message, and then the date and time on the sending.
Okay.
Good morning, Detective Moretti.
Good morning, ma'am.
Phone number ending in 6942. Message sent August 28, 2018, 12:38:03 p.m. I love, stay focused, and we need to turn rental in so I can re-rent it at a lower rate and a bigger car. Same phone number, message sent 8/28/2018, 2:06:09. You okay?
From the message from the cell phone number 9807, it was sent 8/28/2018 at 3:52 p.m. The message was, "Yeah, what's up with my phone?"
Message phone number ending 6942, sent 8/28/2018 at 4:11:20 p.m. They off track, never put the money in my account. I'm not paying the bill. Can you see that, Detective?
Yes. It's a little blurry with the smaller font. There you go. The phone message from phone number ending in 9807. The message was sent at 8/28/2018 at 4:11 p.m. I did it.
Phone number ending in 6942, message sent August 28, 2018, 4:11:28 p.m. It's an image. 6942, message sent August 28, 2018, 4:11:34 p.m. Now.
From cell phone number 9807, sent 8/28/2018 at 4:11 p.m. He just did it.
Phone number ending in 6942, August 28, 2018, 4:11:46 p.m. Okay, I will pay the bill now.
From cell phone number 9807, sent 8/28/2018 at 4:11 p.m. I just paid it.
Publishing page 3, ending in phone number 6942, sent August 28, 2018, 4:12:13 p.m. Thank you. Phone number ending in 6942, sent August 28, 2018, 4:13:18 p.m. Everyone, phone been off all day. Sent phone number 6942, sent August 28, 2018, 4:44:54 p.m. I'm on my way down there.
From cell phone number 9807, sent 8/28/2018 at 8:40 p.m. Message, why you texting Sack, mama? 2 question marks. From phone number 9807, sent 8/28/2018 at 8:42 p.m. Bro, what is wrong with you? Leave people alone. Damn, I'm trying to work. You stressing me.
Phone number ending in 6942, sent August 28, 2018 at 9:21 p.m. I changed my name on Egg. I'm done. Be happy. I love you. I love, but I will give you space. Good night. Publishing page 4.
From phone number 9807, sent 8/28/2018 at 9:34 p.m. The message is, why you turning Riri against me?
Phone number ending in 6942, sent August 28, 2018, 9:35 p.m. I'm not she love you. I told her you're just upset. You will be fine. She went to take a shower. Same phone number, sent August 28, 2018, 9:35:26 p.m. Stop saying people against you. I hate that.
From phone number 9807, sent 8/28/2018, 9:35 p.m. Tell her unblock me.
Phone number ending in 6942, sent August 28, 2018 at 9:36 p.m. Okay, don't make her cry anymore. IDK what you said, but she was crying.
From phone number 9807, sent 8/28/2018 at 9:42 p.m. You made her cry. I was talking to you.
Publishing page 5.
From phone number 9807, sent 8/28/2018 at 9:43 p.m. Tell her I wasn't talking to her. She's perfect. She needs to go home with her mama. You just making shit worse with me and her right now. From phone number 9807, sent 8/28/2018 at 9:53 p.m. Tell her to call me ASAP.
Phone number ending in 6942, sent August 28, 2018, 10:33. She texts you, we was eating.
From phone number 9807, sent 8/28/2018 at 10:33 p.m. She eating now? Question mark.
Phone number ending in 6942, sent August 28, 2018, 10:56:08. Image. Publishing page 6. Phone number ending in 6942, sent August 28, 2018, 10:56:28 p.m. Text message of an image. Phone number ending in 6942, sent August 28, 2018 at 10:57 p.m. That is what I text his mom. Not one thing I said bad, but they your family, not me. But you know I carry, so she better think before running up.
From message from phone number 9807, sent 8/30/2018 at 11 a.m. When you going over there? From phone number 9807, sent 8/30/2018 at 11:05 a.m. Why you keep messing with people, bro? What's wrong with you?
Phone number ending in 6942, sent August 30th of 2018, 11:06 a.m. What are you talking about? I'm not even on no social media. That little girl talking about what she going to do to me, I ain't respond or say anything. Phone number ending in 6942, same date, 11:06 a.m. I've been asleep. Publishing, page 7.
From the from phone number 9807, sent 8/30/2018 at 11:07 a.m. Stop texting his mama, bro. Damn.
And phone number ending in 6942, sent August 30th, 2018, 11:08 a.m. I haven't. That was the only day I text her, so I showed you what I said. Nothing bad. I didn't even cuss at her. Same phone number, sent same date, 11:08:33 a.m. I'm done with all of it. Same phone number, sent same date, 11:11 a.m. His sister starting mess. I ain't said nothing. I don't care. I worked last night and tonight I'm sleeping. You act like you don't have sisters who see the crap she posts.
From phone number 9807, sent 8/30/2018, 11:14 a.m.
Excuse me one second.
Can we approach?
We're on page 7.
I think it was my turn.
I was going to say, I think you were right.
Yes.
Go ahead.
Phone number 9807, sent 8/30/2018 at 11:14 a.m. Leave that shit alone. I'm telling you. He's starving shit, mom.
Phone number ending in 6942, sent August 30th, 2018, 11:20 a.m. No, I didn't start anything. Just because you think it's okay for people to call your mom out her name. Publishing, page 8. Phone number ending in 6942, sent August 30th, 2018, 11:32 a.m. Listen, I do care about any of this, but I have not posted anything about Sac, and he jumped in when his sister started making posts about me. That's crazy.
From number 9807, sent 8/30/2018, 11:32 a.m. Leave it alone. From number 9807, sent 8/30/2018 at 11:32 a.m. You started it.
Phone number ending in 6942, sent August 30th, 2018 at 11:33 a.m. I was asleep. Phone number ending in 6942, sent August 30th, 2018, 11:34 a.m. How is his sister going on social media talking about punching me in face, my fault?
Phone number 9807, sent 8/30/2018 at 11:37 a.m. You started it by texting his mama. It's going to be problems. And not even knowing what you talking about. You a grown-ass lady doing childish shit, ain't no one telling you to text her. She minding her business going to work, you fucking with her.
Publishing, page 9, phone number ending in 6942, sent August 30th, 2018 at 11:40 a.m. She could have called me or texted me back, not have you or daughter all on social media talking about fighting me like I cussed at her. I didn't even say one cuss word when I texted her. I said nothing disrespectful and you know it. I wish you took up for me like that when Aunt cussed me out and tried to fight me. Phone number 6942, sent on the same date at 11:41 a.m. I don't know what's all going on, but he making a live video talking about your mother. It's going to make people hate you. That's why I have never and would never do that, because I love you and that's your best friend, and this is not for social media. Same phone number, August 30th, 2018, 11:43 a.m. I told your sister to stop whatever it is they're doing.
From phone number 9807, the sent 8/30/2018 at 11:46 a.m. You telling everybody my business, and you don't even be right. You the reason they hate me. From phone number 9807, sent 8/30/2018 at 11:46 a.m. Got me looking like a bad person.
Phone number ending in 6942, sent August 30th, 2018 at 11:50 a.m. No, I'm not your actions I take up for you. I have people telling me your son doesn't care about you or love you. I always say you just finding your way, and I know you love even though you hurt me and don't see how much I sacrifice for you every day. I argue with people about talking trash about you even though people say he would not take up for you like that. I always have your back. Every time you call, I am there. That's your friend, fine. He ain't going nowhere. I see, but you are not going to say everything is my fault. Publishing, page 10. Phone number ending in 6942. Sent August 30th, 2018 at 11:51 a.m. I know you hurt and looking for someone to blame, but I love you and I would die for you, but you don't see that right now. It's okay. I told you I'm backing off. Same phone number, sent August 30th, 2018, 12:08:07 p.m. I told them to delete whatever they post. It's dead. Same phone number, sent September 11th, 2018 at 10:49 p.m. Your grandma is over. They wanted to see you.
Phone number 9807, sent 9/11/2018 at 11:42 p.m. I'm a call her in a second, working on the second album.
Phone number ending in 6942, sent September 11th, 2018 at 11:51 p.m. Okay, everyone went home. I love you. Keep doing great music. I'm proud of you.
Phone number 9807, sent 9/11/2018 at 11:53 p.m.
Publishing, page 11. Phone number ending in 6942, sent September 11, 2018 at 11:54 p.m. You're my heartbeat. I cry all the time. I miss you so much, but I know I have to let you grow up.
Phone number 9807, sent 9/11/2018, 11:55 p.m. No need to cry. You fit to be a millionaire.
Phone number 6942, sent 9/11/2018, 11:56 p.m. You deserve it. You're so talented. We played your music all night. Same phone number, sent September 14th, 2018 at 6:15 p.m. I love you, kid.
Phone number 9807, sent 9/14/2018. Love you too. I see you be chillin'. I love that. Keep doing you. Phone number 9807, sent 9/14/2018 at 6:15 p.m. Everything gonna be in place.
Publishing, page 12. Phone number ending in 6942, sent September 14th of 2018 at 6:24 p.m. Yes, I'm good, just working. Same phone number, message sent 9/14/2018 at 6:27 p.m. Image. Same phone number, message sent September 15th, 2018 at 3:48 a.m. You okay?
Phone number 98807, sent 9/15/2018 at 3:48 a.m. Just letting you know I got Brandon. I'm in the car with him now. Love you, fool.
Phone number 6942. Message sent September 15th of 2018 at 3:49 a.m. Love you more, kid. Drive safe. Same phone number. Message sent September 15th, 2018 at 3:54 a.m. Did you see how nice the Maxima looks?
Phone number 9807, sent 9/15/2018 at 10:36 a.m. Yes, I can pick it up on my way back home, right back home tonight, question mark. Phone number 9807, sent 9/15/2018 at 10:36 a.m. Needed for a couple weeks.
Phone number 6942, sent September 15, 2018 at 11:43 a.m. I just woke up. I need it. My Benz get painted Monday.
Phone number 9807, sent 9/15/2018 at 11:58 a.m. How long it's going to take? From 9807, sent 9/15/2018 at 11:58 a.m. What about another rental? I got the money.
Phone number ending 6942, message sent September 15, 2018 at 12:53 p.m. When? Publishing, page 14. Phone number ending in 6942, message sent September 15th of 2018 at 3:49 p.m. My car takes 4 days.
From message 9807, sent 9/15/2018 at 3:51 p.m. Okay, so Thursday.
Phone number ending in 6942, message sent September 15, 2018 at 3:51 p.m. Yes. Same phone number, message sent same date at 3:59 p.m. Tell Track, send my money please for the last rental.
From 9807, sent 9/15/2018, 3:52 h.m.
6942, message sent 9/15/2018 at 3:52 p.m. Did you get your passport yet? Publishing, page 15.
From phone number 9807, sent 9/15/2018 at 3:53 p.m. No.
Phone number 6942, message sent September 15th of 2018, 3:54 p.m. Do you know how to do it? Same phone number, message sent same date at 3:54:20 p.m. How is Brandon?
From 9807, sent 9/15/2018 at 2:54 p.m. Hey, good, I got him a haircut.
Phone number ending in 6942, message sent 9/15/2018 at 3:55 p.m. Thank you, Benny. Was about to text you and ask you to get him one. Do you have a show tonight?
From 9807, sent 9/15/2018 at 3:55 p.m. Yeah, we on the way to Jacksonville.
Publishing, page 16. Phone number ending in 6942. Message sent September 15, 2018 at 4:27 p.m. Aunt Dilly doing Grandma Justine's sister. Same phone number, message sent, same date, 4:27:31 p.m. 1-904-200-0534. Same phone number, message sent, same date at 4:28:02 p.m. Call her when you get there. What car are you driving? Or are you in a Sprinter? Same phone number, message sent September 16, 2018 at 12:08 p.m. Your show was awesome. Keep up the good work. Drop Brandon off on the way from Jacksonville. He has school tomorrow. I'm off today, so I will be home.
From 9807, sent 9/16/2018 at 8:06 p.m. Yo.
Phone number ending in 6942. Message sent September 16, 2018 at 8:07 p.m. Yes. Same phone number. Message sent at 8:07:22 p.m. Why you ain't dropped Brandon off? Skipping to page 27. Publishing, phone number 6942, message sent September 19th of 2018 at 7:51 p.m. I'm at work and I go back Friday to Mrs. Spark. Same phone number, same date, message sent 11/13:54 p.m. Do you think you want to go to Ohio for Christmas? I'm planning it. Same phone number, message sent September 23rd of 2018 at 2:42 a.m. How far are you from the club? Answer me. Question mark. People are getting upset. I'm getting calls at work. WTF.
From 9807, sent 9/23/2018, 2:52 a.m. Was getting here done, missed the show. From 9807, 9/23/2018 at 2:52 a.m. Where Beast Line.
Phone number ending in 6942, message sent 9/23/2018 at 2:52 a.m. Call DA now. Publishing page number 28. Phone number ending in 6942, message sent 9/23/2018 at 2:53:01 a.m. Phone number 772-940-4993. Same phone number, message sent same date at 2:53:14 a.m. You owe like 8K.
From 9807, sent 9/23/2018 at 2:53 a.m. No, I don't. From 9807, sent 9/23/2018 at 2:53 a.m. The show was only 5K.
Phone number ending in 6942. Message sent September 23rd, 2018 at 2:54 a.m. This is bad. Call him, please. It looks bad for everybody involved. Same phone number. Message sent September 23rd, 2018 at 2:57 a.m. You put everybody before you, and real friends would have said leave, and they would miss the show, not you, because it's your face. I'm disappointed. Publishing page 29. Phone number ending in 6942, message sent September 23rd, 2018 at 2:59 a.m. You act like you don't care anymore about your career. This is your future, not mine. I have a career. You need to start thinking about you and get your priorities together. I can't do it for you because you don't want me to.
From 9807, sent 9/23/2018 at 2:59 a.m. Man, you don't know what you're talking about. Just stay out of my career, please. From 9807, sent 9/23/2018, 3 a.m. I've been working harder than ever. You don't know the half. From number 9807, sent 9/23/2018 at 3 a.m. I made one mistake. Wow, everyone misses at least one show in their career.
Phone number ending in 6942, message sent September 23rd, 2018 at 3 a.m. They called me at work. I was afraid something happened. You didn't call me.
From 9807, sent 9/23/2018 at 3 a.m. Where Brandon at?
Publishing page 30. Phone number ending in 6942, message sent September 23rd of 2018 at 3:01 a.m. This is the second show that DA promoted for you. It looks bad on him, and people already talk so much stuff. I get put in it regardless because you're my child, Jamell, and I can't take up for you when I don't know. Same phone number, message sent same date at 3:03 a.m. No, I don't know because you act like I did something to you, and I never anything but help you, and it looks bad because tracking everybody there. Why you ain't go with them, question mark. You don't smoke anymore.
From 9807, sent 9/23/2018 at 3:04 a.m. Man, don't worry about my career. I made a mistake. I don't care. The back end was only $1,000. From 9807, sent 9/23/2018 at 3:05 a.m. Where is Brandon at?
Phone number ending in 6942, message sent September 23rd, 2018 at 3:14 a.m. It's not the money, it called being professional, and that I want you to understand. You want a positive image and people to say how great you did. Same phone number, message sent, same date, 3:14:42 a.m. Probably sleep, it's 3 a.m. in the morning. Publishing page 31. Phone number ending in 6942. Message sent September 23rd of 2018 at 3:15 a.m. You're not taking him. Get him next weekend.
From 9807 at 9/23/2018 at 3:21 a.m. Yes, I am. From 9807, 9/23/2018 at 3:21 a.m. He at your house? Question mark. From 9807, sent 9/23/2018 at 3:34 a.m. You all don't know nothing about this music career, so stay out of it. Please, look, every artist, even Michael Jackson, done missed a show. You all leave me alone, trying to make me look irresponsible. If my check would have come in on time, I wouldn't be trying to get right last minute.
Phone number ending in 6942, message sent September 23rd, 2018 at 3:53 a.m. If you needed something, Jamell, all you have to do is ask. I'm still your mom. I'm going to always have your back. What you don't understand, you act like you don't people who love you and care about you. I've been giving your space, but it's okay to need help. You have nothing to prove to me. I'm your mom. I love you regardless.
From 9807, sent 9/23/2018 at 4:01 a.m.
Going backwards, publishing page 45.
From 9807 at 10/15/2018, 9:35 p.m. Stop telling Brandon that is not true.
Phone number 6942, message sent 10/15/2018, 9:40 p.m. I was on the phone. I told him stay out of it. Your grandma is here waiting on you. Jamell, it's your life, son, and I love you. I will always be right here. Same phone number, message sent, same date at 10:13 p.m. Dinner is done. Same phone number, message sent 10/16/2018 at 12:34 a.m. I love you, kid. Same phone number, message sent, same date at 8:09 a.m. Good morning, I love you. Call me when you get up. Trust God, everything will be fine.
From 9807, sent 10/16/2018 at 8:18 a.m. Love you too.
Publishing page 46.
From 9807 at 10/18/2018 at 1:41 p.m. Send wire info.
Phone number 6942. Message sent October 18, 2018, 2:16 p.m. You can do a transfer to my account. It's free. Same phone number, message sent same date at 2:17 p.m. I was asleep. Same phone number, message sent same date at 9:34 p.m. You sent Jasmine money for me, question mark. She hasn't answered the phone. Same phone number, message sent October 20th of 2018 at 2:13 a.m. You did good, love you, be safe, kid.
From 9807 at 10/20/2018 at 2:13 a.m. Thanks, Mom, I love you.
Publishing page 47.
From 9807, sent 10/20/2018 at 2:13 a.m. for everything.
Phone number 6942. Message sent 10/20/2018 at 2:14 a.m. You know I got you forever. Same phone number, message sent same date at 7:12 a.m. Have a safe flight, love you.
From 9807, sent 10/20/2018 at 7:13 a.m. Love you. From phone number 9807, sent 10/20/2018 at 7:13 a.m. Tell Riri that I love her too.
Phone number 6942. Message sent 10/20/2018 at 7:13:57 a.m. I will. She coming over today. Publishing page 50. Phone number 6942. Message sent 10/23/2018 at 11:17 a.m. I will. Same phone number. Message sent same date at 4:09:18 p.m. You look so happy. I love you.
From 9807, sent 10/23/2018, 4:13 p.m. I am Ma, I love you.
Phone number 6942. Sent 10/23/2018, 4:31 p.m. blank message. Same phone number. Sent 10/24/2018, 1:02 a.m. Are you okay?
From 9807, sent 10/24/2018 at 1:02 a.m. Yeah, why though?
Phone number 6942, message sent 10/24/2018, 1:03 a.m. You was wild on your live. Who pissed you off? I don't like seeing you upset. Publishing, page 51. Phone number ending in 6942, sent October 24, 2018 at 1:40:56 a.m. I love you, get some rest. 10/26/2018, 5:16 a.m. Send me your location. Same phone number continues. October 26th at 5:17 a.m. I'm in Stewart. Same phone number continues on the same date at 5:47 a.m. I love you so much.
From 9807, sent 10/27/2018, 3:40 a.m. A location was sent.
Phone number 6942, message sent 10/27/18, 3:40 a.m. Okay. Publishing, page 52. Phone number 6942, message sent 10/27/18 at 3:40 a.m. Love you. Same phone number, message sent same date at 3:23 p.m. I'm at your gate. I'm going to get the trash.
From 9807, sent 10/28/2018, 10:33 a.m. Bring Mariah.
Phone number 6942, message sent October 28, 2018, 11:22 a.m. Okay. Detective, you can skip that next message and move on to the final message on the page.
From 9807, sent 10/28/2018 to 2:09 p.m. Like, go now.
Publishing, page 53. Phone number 6942, message sent on October 28th of 2018, 2:17 p.m. Okay, what's wrong?
From 9807, sent 10/28/2018 to 22 p.m. I'll pay you. From 9807, same date at 2:22 p.m. When you get down here.
Phone number 6942, sent 10/28/18 at 2:22 p.m. Okay. Same phone number, same date. Sent at 2:23 p.m. I'm waiting on track to cash at me the 1,000. Same phone number, same date at 2:23:40 p.m. Is someone threatening you? Publishing, page 54.
From 9807, 10/28/2018 at 2:23 p.m. No harm. Phone number 9807, 10/28/2018 at 2:23 p.m. I'm not scared. From 9807, 10/28/2018, 2:24 p.m. Just listen.
From 6942, October 28, 2018 at 2:24:06 p.m. Okay, I want you safe. Same phone number, same date at 2:24:28 p.m. You're covered.
From 9807, 10/28/2018 at 2:24 p.m. I know.
Publishing, page 55.
From 9807, sent 10/28/2018, 2:24 p.m. Still need to protect myself.
Phone number 6942, sent October 28, 2018 at 2:53 p.m. FaceTime me.
From 9807 at 10/28/2018 at 3:06 p.m. Jay Finn ascended. From 9807, 10/28/2018 at 3:06 p.m. He fit and ascend 500.
Phone number 6942, message sent October 28 at 3:06 p.m. Okay. Same phone number, message sent same date at 3:06:23 p.m. Okay. Publishing, page 56.
From 9807, what's your cash app? Oh, I'm sorry, that was sent 10/28/2018 at 3:06 p.m. What's your cash app?
Phone number 6942, message sent 10/28/2018, 3:07 p.m. Money sign JAMIE YNW. Same phone number continues on the same date at 3:16 p.m. Answer the phone, it's me with trigger. Same phone number, same date at 10:12 a.m. 1132 Southeast 3rd Avenue, Fort Lauderdale, Florida. Same phone number, November 2nd, 2018 at 1:40 p.m. I love you, kid. Publishing, page 57.
From 9807, sent 11/2/2018 at 1:43 p.m. Love you more.
Phone number 6942, message sent 11/2/2018 at 1:53 p.m. Loved, quotation marks, love you more, close quotation marks. Same phone number, 11/3/2018 at 2:39 p.m. Unblock my number, capital letters, right now.
From 9807 at 11/3/2018, 2:41 p.m. I'm good, Foo. You got it. I'ma just stay to myself. I don't want to hurt you, Foo. Just leave me alone.
Phone number 6942, message sent 11/3/2018 at 2:43 p.m. No one blocked me because I'm not finished saying what I'm saying. Same phone number, same date at 2:43:20 p.m. I be trying to be there for you and you push me away like I'm the problem. Publishing, page 58.
From 9807, sent 11/3/2018 at 2:43 p.m. Fuck what everyone gotta say. From 9807, 11/3/2018, 2:43 p.m. Man, I'm not trying to hear that shit. I do shit for you too.
Phone number ending in 6942, message sent 11/3/2018 at 2:43 p.m. You always give me the cold shoulder, but it's cool.
From 9807, 11/3/2018, 2:44 p.m. You better off without me, so just slide, bro. I'ma love you from a distance.
Phone number 6942, message sent 11/3/2018 at 2:44 p.m. I didn't do anything to you.
From 9807, 11/3/2018 at 2:44 p.m. Bitch, you gave me the cold shoulder because I couldn't find the blazer.
Publishing, page 59. Phone number ending in 6942, message sent November 3rd of 2018 at 2:44 p.m. But cool, you wanted to be better off by yourself anyway.
From 9807, 11/3/2018 at 2:44 p.m. I looked in 4 different stores for the shit. From 9807, 11/3/2018, 2:44 p.m. Fuck you mean.
Phone number ending in 6942, message sent 11/3/2008 at 2:45 p.m. So you can F with who you want, LOL, but it's cool, it's done, just remember.
From 9807, 11/3/2018 at 2:45 p.m. Fuck everybody. From 9807, 11/3/2018 at 2:45 p.m. If you don't understand, I know the next bitch won't.
Publishing, page 60. Phone number ending in 6942, message sent 11/3/2018 at 2:46 p.m. KK.
From 9807, sent 11/3/2018, 2:46 p.m. I'm meant to be alone, I'm a monster. From 9807, 11/3/2018, 2:46 p.m. I'm evil. From 9807, 11/3/2018, 2:46 p.m. I'm all dead.
Phone number ending in 6942, message sent 11/3/2018, 2:46 p.m. It's always F people that I'll do anything for you.
From 9807, 11/3/2018, 2:46 p.m. So leave me the fuck alone.
Publishing, page 61. Phone number ending in 6942. Message date 11/3/2018 at 2:46 p.m. But fine.
From 9807, 11/3/2018, 2:46 p.m. Bitch, you did me wrong too.
Phone number 6942, message sent 11/3/2018 at 2:46 p.m. You got it.
Phone 9807, 11/3/2018, 2:46 p.m. I don't want to hear that shit, bro. Phone 9807, 11/3/2018, 2:46, G shit.
Phone number ending in 6942, 11/3/2018 at 2:46 p.m. You don't have to, it's done. Publishing page 62. Phone number ending in 6942, message sent 11/3/2018 at 2:46 p.m. You good?
Phone 9807, 11/3/2018,
It's focusing on it. Go ahead.
2:53 p.m. You just turned me up.
Phone number 6942, 11/3/2018 at 2:54 p.m. Unblock my number. Same phone number, same date at 3:07 p.m. I love you, bipolar ass. Same phone number, same date at 3:13 p.m. Your mom said, where are y'all flying into? In Colorado, like what airport?
Phone 9807, 11/3/2018, 3:13 p.m. I don't know why.
Phone number 6942, 11/3/2018 at 3:57 p.m. IDK, unblock my number though, please. Publishing page number 63, phone number ending in 6942, message sent on 11/3/2018, 3:17 p.m. Thought we wasn't doing that no more. You're being childish.
Phone 9807, 11/3/2018 at 3:18 p.m. Just leave me alone. You don't understand me. Everyone asks for something. Don't even think about my feelings, bro. Fuck everybody. 9807, sent 11/3/2018, 3:18 p.m. Make sure I please you though before everybody. You don't even see that shit.
Phone number 6942, message sent 11/3/2018 at 3:19 p.m., 3:29 p.m. Shut up. Same phone number, same date, sent at 3:34 p.m. You're being a baby.
Turn off your phone, please.
Same phone number, November 3rd, 2018, 3:19:45 p.m. I do understand you. Same phone number, message sent, same date, 3:19:52 p.m. I wouldn't be around if I didn't. Publishing page 64, 6942 phone number, message sent on 11/3/2018 at 3:19 p.m. Now unblock me. Same phone number, message sent, same date at 3:20 p.m. I'm not gonna keep going back and forth with you on your mom phone. Same phone number, November 3rd, 2018 at 4:28 p.m. I love you.
What page was that? I'm sorry.
64.
Page 64. Can we approach again, please?
Yes, sir.
Continuing to publish 64. Was it your turn, Detective?
I believe so, man. Phone 9807, sent 11/3/2018 at 4:29 p.m. Love you too, Mom. Phone 9807, 11/3/2018, 5:27 p.m. Mom.
Phone number 6942, message sent 11/3/2018 at 5:51 p.m. Yes, son. Publishing page 65.
Phone 9807, 11/3/2018 is 6:10 p.m. Never mind, you already going to get it.
Phone number 6942, 11/3/2018 rather, 6:13 p.m. Okay.
Phone 9807, 11/4/2018 at 1:13 a.m. Give Mariah the phone.
69 42 phone number, message sent 11/4/2018 at 1:35 a.m. I just went Jessica House real quick. Everything okay? Question mark. Brandon up. Same phone number, message sent same date at 1:35:54 a.m. How was the show?
From 9807, sent 11/4/2018 at 1:36 a.m. I'm on the way there now.
Publishing, page 74, phone number ending in 6942. Message sent 11/10/2018 at 1:19:56 p.m. It's an image. Same phone number, message sent on same date at 2 p.m. Where? Same phone number, message sent on same date at 2 p.m. 51 seconds. Are you?
From 9807, sent 11/10/2018 at 2:07 p.m. Palm Beach, same number, time 11/10/2018 at 2:07 p.m. Got pulled over.
6942 phone number 11/10/2018 at 2:07 p.m. FaceTiming. Publishing, page 75.
From 9807, sent 11/10/2018 at 3:16 p.m. I'm not going.
Hey, Joan, I need to take short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. And certainly, no research. Anything else passed on the chair. I see your second with the camera crew. Let the record reflect the jury steps down, Counselor Van all with your side. This from you.
From 9807, sent 9/15/2018 at 3:55 p.m. Yeah, we on the way to Jacksonville.
Publishing, page 16. Phone number ending in 6942. Message sent September 15, 2018 at 4:27 p.m. Aunt Dilly doing Grandma Justine's sister. Same phone number, message sent same date, 4:27:31 p.m. 1-904-200-0534. Same phone number, message sent same date at 4:28:02 p.m. Call her when you get there. What car are you driving? Or are you in a Sprinter? Same phone number, message sent September 16, 2018 at 12:08 p.m. Your show was awesome. Keep up the good work. Drop Brandon off on the way from Jacksonville. He has school tomorrow. I'm off today, so I will be home.
From 9807, sent 9/16/2018 at 8:06 p.m. Yo.
Phone number ending in 6942. Message sent September 16, 2018 at 8:07 p.m. Yes. Same phone number. Message sent at 8:07:22 p.m. Why you ain't dropped Brandon off? Skipping to page 27. Publishing, phone number 6942, message sent September 19th of 2018 at 7:51 p.m. I'm at work and I go back Friday to Mrs. Barr. Same phone number, same date, message sent 11/13:54 p.m. Do you think you want to go to Ohio for Christmas? I'm planning it. Same phone number, message sent September 23rd of 2018 at 2:42 a.m. How far are you from the club? Answer me. Question mark. People are getting upset. I'm getting calls at work. WTF.
From 9807, sent 9/23/2018, 2:52 a.m. Was getting here done, missed the show. From 9807, 9/23/2018, at 2:52 a.m. We're Beachline.
Phone number ending in 6942. Message sent 9/23/2018 at 2:52 a.m. Call DA now.
Okay, so we're getting a snapshot of these conversations that happened around that time. We'll take a break. When we come back, I want to get into this with Gene Rossi. He and I were having a little bit of debate about the significance of this and maybe or not, if this is overkill or not. Stay with us. We'll take a quick break. We'll be right back right after this. The defendant. It is a way to ultimately track his location and movements on the night in question. So we're going to go back live again. YNW Melly is facing the death penalty if convicted of murdering his two friends in that car back in 2018. Let's go back and listen more.
Publishing page number 28. Phone number ending in 6942. Message sent 9/23/2018 at 2:53:01 a.m. Phone number 772-940-4993. Same phone number, message sent same date at 2:53:14 a.m. You owe like $8K.
From 9807, sent 9/23/2018 at 2:53 a.m. No, I don't. From 9807, sent 9/23/2018 at 2:53 a.m. The show was only 5K.
Phone number ending in 6942. Message sent September 23rd, 2018 at 2:54 a.m. This is bad. Call him, please. It looks bad for everybody involved. Same phone number. Message sent September 23rd, 2018 at 2:57 a.m. You put everybody before you, and real friends would have said leave, and they would miss the show, not you, because it's your face. I'm disappointed. Publishing page 29. Phone number ending in 6942. Message sent September 23rd, 2018 at 2:59 a.m. You act like you don't care anymore about your career. This is your future, not mine. I have a career. You need to start thinking about you and get your priorities together. I can't do it for you because you don't want me to.
From 9807, sent 9/23/2018 at 2:59 a.m. Man, you don't know what you're talking about. Just stay out of my career, please. From 9807, sent 9/23/2018, 3 a.m. I've been working harder than ever. You don't know the half. From number 9807, sent 9/23/2018 at 3 a.m. I made one mistake. Wow, everyone misses at least one show in their career.
Phone number ending in 6942. Message sent September 23rd, 2018 at 3 a.m. They called me at work. I was afraid something happened. You didn't call me.
From 9807, sent 9/23/2018 at 3 a.m. Where Brandon at?
Publishing page 30. Phone number ending in 6942. Message sent September 23rd of 2018 at 3:01 a.m. This is the second show that DA promoted for you. It looks bad on him, and people already talk so much stuff. I get put in it regardless because you're my child, Jamell, and I can't take up for you when I don't know. Same phone number, message sent same date at 3:03 a.m. No, I don't know because you act like I did something to you, and I never anything but help you, and it looks bad because tracking everybody there. Why you ain't go with that?
Okay, Gene, you and I were disagreeing a little bit about the significance of all these messages coming in. I don't want to put words in your mouth, but I think you were saying that it might be overkill. I'm looking at this and thinking not only is it important to establish this as his phone, but if you think about the content, let's talk about what happened yesterday too. I mean, there were these messages that came out that had made it look like YNW Melly was kind of upset that the victims in this case were getting maybe too much money, maybe they were taking credit for the work that he was doing. So I think it establishes kind of his mindset and what was happening at that time. You might disagree with me.
Well, I don't disagree with that last point because you were referencing testimony from yesterday and I wasn't watching it. So you had the advantage of that. But some of these text messages, and this gets to the defense's objection, some of these messages are not really adding context. They're just surplusage. That's my only point, is that they have established that 9807 is his phone. And there are a few text messages that show his motive and that he's annoyed with Mr. Williams and Mr. Thomas. But some of these don't have anything to do with that. That was my criticism.
Do you think that this is an issue of the judges allowing too much in the sense that if the defendant is convicted, this could be appealed and it could be overturned?
I don't think it'd be enough for reversible error, but it is being very generous in allowing the government to put a whole tranche, a treasure trove of text messages. I would say probably only about a third of these 35 pages they're showing are relevant to what they're trying to do.
And we have about a minute left. See, my theory is the prosecution, they don't have strong DNA evidence tying him to the crime. They don't have the murder weapons. They don't have an eyewitness. The surveillance footage is helpful, but not definitive. It's a circumstantial evidence case. So that's why I think the prosecution is just throwing in as much as they can with what they have.
And that's an argument for the defense to use in closing. Repeat exactly what you just said, and then as a defense attorney, I'm going to say, and members of the jury, you saw those messages read, 2/3 of them had nothing to do with this case. And why? Because the government knows they have a weak case and they have to throw as much spaghetti against the wall as possible to see what sticks.
Or polenta, as some would say, polenta against the wall.
Polenta doesn't really stick to the wall.
It doesn't? I feel, it probably slides now that I'm thinking about it. Also, a thought that I never thought I'd have in my mind and never thought I'd say on the show. But hey, there's a first time for everything. Gene Rossi, thank you so much. Great seeing you. Always appreciate your insight. All right, everybody, we're going to take a quick break. When we come back, we're going to have more for you. Stay with us here on Law and Crime. We'll jump back live into court.
Number of mothers on that jury who may be inclined to convict just because they've heard irrelevant, unrelated conversations between Mr. Demons and his mother where he's calling her the B word and all sorts and manner of disrespect that is clearly off-putting to any mother. And under the pretext that they're trying to prove this phone belongs and is being used by Mr. Demons, the state is offering in reams and reams, tons and tons of inadmissible evidence that is irrelevant to this case. There's a point at which they sat there for 2 hours showing 530-something photographs. They introduced a jail call, and it seems like in the mission of proving that it's his phone, it's a license to put in all manner of evidence that is prejudicial and irrelevant. And we think that Mr. Demons' image, his character has been assassinated and irreparably tainted by the manner in which he's conversing with his mother, and the mothers sitting on that jury are now tainted in their impression of him and the manner in which they will render judgment. So we move for a mistrial on that ground and ask that the court put a stop to this if it is not going to grant that mistrial.
Stage Speaker.
We're going to do that's the section.
Okay, motion to that.
We address the juror issue, Your Honor, and I don't want to put any different approach on that.
42, message sent September 23rd, 2018 at 3:14 a.m. It's not the money, it called being professional, and that I want you to understand. You want a positive image and people to say how great you did. Same phone number, message sent, same date, 3:14:42 a.m. Probably sleep, it's 3 a.m. in the morning. Publishing page 31. Phone number ending in 6942. Message sent September 23rd of 2018 at 3:15 a.m. You're not taking him, get him next weekend.
From 9807 at 9/23/2018 at 3:21 a.m. Yes, I am. From 9807, 9/23/2018 at 3:21 a.m. He at your house, question mark? From 9807, sent 9/23/2018 at 3:34 a.m. You all don't know nothing about this music career, so stay out of it. Please, look, every artist, even Michael Jackson, done missed a show. You all leave me alone, trying to make me look irresponsible. If my check would have come in on time, I wouldn't be.
Very much, thank you. Jury entering. Gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our jury, the defendant, Demons, his counsel, the assistant state attorney, our witness, Detective Mark Murray, who remains on the stand. Counsel, when we work, they're still on your direct proceed.
Yes, Your Honor. Continuing to publish, we're on page 75. Detectives, if you can start with the first message. I can't recall where we were.
9807, sent 11/10/2018 at 3:16 p.m. I'm not going. From 9807, sent 11/10/2018 at 3:16 p.m. Go for me. From 9807 at 11/10/2018 at 3:17 p.m. Damn people out there.
Phone number 6942, message sent 11/10/2018 at 3:17 p.m. Yes, they was at SAC 2. Same phone number, sent same date, 3:17:29 p.m. I seen them, you didn't. Same phone number, same date, sent at 3:18:27 p.m. You have to see Shell. Publishing page 76.
From 9807, I sent 11/10/2018 at 8:07 p.m. I miss her, but I need a break.
Phone number 6942, message sent on November 10, 2018 at 8:08 p.m. We can stay up this way, or I can take her home. Same phone number, same date, 8:08:33 p.m. I was going to get a room out west.
From 9807, sent 11/10/2018 at 8:10 p.m. You got my cash app?
Phone number 6942, message sent November 10, 2018 at 8:10 p.m. OMG, thank you. Same phone number, message sent November 11, 2018 at 9:26 p.m. Trippier performance was lit. Publishing, page 91, message from phone number 6942, message date November 19, 2018, 3:27:40 p.m. Answer your phone. I'm going to end the publishing on page 91. Publishing page 99.
From 9807, sent 12/13/2018, 4:23 p.m. Yeah, I'm down here.
Phone number 6942, message sent 12/13/2018 at 4:24 p.m. Okay, I need get Brandon something to wear, and I had to pawn for $400.
From 9807, sent 12/13/2018 at 4:24 p.m. Why? What the fuck? From 9807, 12/13/2018, 4:24 p.m. Why? Question mark, question mark, question mark. From 9807, 12/13/2018, 4:24 p.m. Would you do that? I got money for you. And, 9807, 12/13/2018, 4:24 p.m. Blank message.
Publishing page 100. Phone number ending in 6942, message sent 12/13/18 at 4:25 p.m. I'm broke, I just started back working, and Shell needed a loan, so I'm going to give it to her. I get paid tomorrow.
From 9807, sent 12/13/2018. From 9807, 12/13/2014 at 4:25 p.m. Come down here.
Phone number 6942, message sent 12/13/2018 at 4:25 p.m. I'm coming now, love you. Phone number 6942, 12/13/2018 at 4:59 p.m. Grandma wants to FaceTime you.
From 9807, sent 12/14/2018, 5:07 p.m. And the location was sent.
Publishing page 101. Phone number 6942, 12/14/2018 at 7:08 p.m. You okay? Question mark. Same phone number. Message sent 12/15/2018 at 1:21 a.m. Me and Brandon went back to the hotel. You did amazing with Trippy. Love you, kid. 12/15/2018. Message sent from same phone number at 3:15 p.m. I'm at restaurant. The owner grandson is your biggest fan. Follow him at Andrew2199. Same phone number. Message sent 12/16/2018 at 4:25 a.m. 739. Same phone number. Message sent at 12/17/2018 at 6:59 p.m. Your little tree with an image. Same phone number. Message sent at 12/19/2018 at 11:44 a.m. Hi Jamie, this auntie, let Jamell know he's been on my mind very heavy. I'm praying for him. Ask him to Google Smokey Norfolk song, Once in a Lifetime. That song reminds me of him. Publishing page 109, and specifically message ending in phone number 6942, 12/31/2018 at 5:46:24 p.m. Contact attachment sent. File name Shell Juvy Mom. That ends the publishing of this exhibit.
Detective Marie, you had mentioned, and we've talked about in the past couple of days, the phones that were from Mr. Thomas and Mr. Williams.
Yes.
Did you have the opportunity to bring those with you today?
Yes.
So I'm showing you what's been marked as states quadruple N and states quadruple O. Do you recognize these items?
Yes, ma'am.
What are those items?
Those are the cell phones that we recovered from the vehicle on 1026 pursuant to a search warrant.
Are they in the same or substantially same condition as when they were recovered on October 26th of 2018?
Yes, ma'am.
Have you had the opportunity to review the contents of those packages before you came into court today?
Yes, ma'am.
Are they in the same or substantially same condition?
Yes, ma'am.
Your Honor, at this time, the state would request a move into evidence states quadruple N and states quadruple O.
Is there any objection?
No, sir.
They'll be admitted.
States quintuple N will be marked states 113. And states quintuple O will be marked states 114.
Okay, and Detective Moretti, so it's clear for the record what's been now admitted as states 113, quintuple N, now 113 in evidence. Whose phone is this?
This was the white Apple iPhone that was found on the front right passenger side floorboard. It was the phone of Anthony Williams.
And now what's been admitted as states 114. Which phone is this?
This was found on the rear right side floorboard passenger side. It was the phone of Chris Thomas Jr.
Was there another phone that was found in that car as well?
Yes, ma'am.
And what phone was that?
It was an Android phone. It was found in the back seat pocket on the right rear passenger side.
Okay. And I'm showing you it's been marked as states quintuple P for identification purposes only. Do you recognize that? Do you have an opportunity to review that before you came into court? Is it in the same or substantially same condition as when it was collected in October of 2018?
Yes.
Or at this time, the state would request to move in states quintuple P as states 115.
No objection.
It will be admitted.
States quintuple P marked states 115.
Detective Moretti, on states 115, this other phone, when it was collected in October of 2018, was it working?
No, ma'am.
What damage was caused to that phone? I'm sorry, let me rephrase. What damage was observed of that phone?
There's a broken screen. We tried to have it forensically download. They would not allow. We even tried to analyze.
Pull the microphone back to you, please, sir. Thank you.
We attempted to have the phone forensically examined. It would
Objection calls for hearsay.
Steps that you took.
I'm sorry?
Calls for hearsay.
She said-
Things that you did, not hearsay.
What was it?
I was present when we attempted to forensically download the phone. We were unable to. I personally tried to extract the data from the SIM card to see at least who the user was, owner, or anything, and the SIM card wasn't even reading.
And as a law enforcement officer, and you testified about your experience with Celebrite and Cellhawk, what does that tell you about that phone?
It's an inoperable phone.
So Detective Moretti, going back to what's in evidence as State 64, the extraction of the 772-713-9807 phone number.
Yes.
I'm going to show you what's been now marked as states quintuple Q for identification purposes.
Can we approach?
Yes, sir.
Thank you.
Okay, Detective Meridian, I'm going to approach and show you what's been labeled as state quintuple Q for identification purposes. Do you recognize that document?
Yes, ma'am.
How do you recognize that document?
It is the data that was extracted from the phone regarding the Apple Health data, the steps patient on the day.
And does that data fairly and accurately represent the data that's on the phone that is now in evidence?
Yes, ma'am.
How do you know that?
I personally verified it by opening up the device and manually scrolling through that specific data to verify how many steps were taken on what date, what time.
In terms of the GPS points and things that are on that phone as well, did you verify those?
Yes, ma'am.
Is there been any additions or deletions to that data that is in this document before you?
No, ma'am.
And at this time, the state would request a new state quintuple Q as states 160.
Objection on grounds that we raised.
Objection, no, so I don't think.
This quintuple Q would mark states 160.
Detective Moretti, in terms of the data in this particular, if you could explain the start time and the end time.
It's when the phone reads or detects that there's movement. So it starts, it creates a start time, timestamp, which is already converted from UTC to our present time zone, Eastern Standard Time. And when the phone detects that it's no longer moving or in activity, then it stops. In which then you see the last launch, 10/29/2018, 5:40 in Eastern Standard Time. You see a little parentheses where UTC -4. That's just telling me that the phone already converted from UTC to Eastern Standard Time.
So when I want to go to October 26th for the start time, so going to entry number 43. If you could be so kind as to read the start time, date, and the end time.
Okay, the start time was 10/26/2018, 12:29 a.m. And the end time was 10/26/2018 at 12:47 a.m.
Does at that point the device record steps or movement?
Yes, ma'am.
And does it record a distance?
Yes, ma'am.
So continuing forward. So October 26th, the start time 2:57 a.m. to 3:04 a.m.
From 10/26/2018 to 57, it started registering movement. It recorded 5 steps, traveling 4 meters. And the end time was 10/26/2018 at 3:04 a.m.
Going to number October 26, 2018, 3:12 a.m., entry number 48 from this data.
That was the start time, and then the end time was 10/26/2018, 3:19 a.m., which the device detected 38 steps, traveling 28 meters.
Going on to number 14. I'm sorry. To number 49.
The start time where the device detected movement, it was 10/26/2018 at 3:19 a.m. And in the end time when it detected the one detected movement, it was 10/26/2018 at 3:35 a.m. It detected 70 steps, traveling 33.34 meters.
Okay. Going on to number 50.
The start time was at 10/26/2018 at 3:46 a.m. and the end time was 10/26/2018 at 4:02 a.m. The device detected and recorded 70 steps, traveling 40.93 meters.
And number 51.
The start time of the detection of movement was 10/26/2018, 4:20 a.m. And the end time was 10/26/2018 at 4:48 a.m. A total of 1,397 steps were detected. A total of 947 meters was recorded.
So, Detective Moretti, we've talked a little bit about the Instagram. Did the defendant have other social media platforms as well that you've reviewed?
We reviewed Snapchat, Facebook, and Instagram.
In terms of the social media accounts that you reviewed on this case, did you look at other people's as well? I know you've spoken about Mr. Hedgepath.
Yes.
And reviewing Mr. Hedgepath's Twitter account, you mentioned that you thought there was a photo that was published.
There was a photo. It was an image of what would appear to be like crosshairs from like a rifle scope, and it said something in the nature of "we aiming at you," and it said "diss track YNW Melly," and then in the caption it made reference to the Jeep.
So you've had a chance to review that. I don't have to pull it up for you to refresh your memory. Thank you. Detective Moretti, in terms of the timing on that diss track that came out, how long after the homicide was it?
I believe the release date was going to be November 2nd.
And for the contents of that song, did you review those?
No, ma'am.
Was there any other evidence other than one song lyric that tied David Hedgepath to Miramar on October 26th of 2018?
Nothing else, ma'am.
So we've already talked and started talking about the Instagram records on that. So I wanted to go ahead. What's been previously marked as state quintuple M. Detective Moretti, I'm showing you what's been marked as state quintuple M. If you could review those.
Yes, ma'am.
Detective Moretti, are those, what are those?
Those are the messages that was recovered in the direct shares from the Instagram download that we received from Meta Platforms Inc.
Do those fairly and accurately represent the direct shares involving the J King RN and the user YNW Melly?
Yes, ma'am.
Okay. Are those compiled from what's been previously placed into evidence as states 110, the Instagram downloads?
Yes, ma'am.
Have they been edited or altered in any way?
No, ma'am.
And do they fairly and accurately depict a portion or sample of those Instagram messages?
Yes, ma'am.
Your Honor, at this time, the state would request to move in states quintuple M.
Objection on grounds previously raised.
Proceed, please. Thank you. Objection is overruled. She will be admitted.
states quintuple M will be marked states 117.
I'm sorry, what exhibit?
117.
117, thank you.
So Detective Bernie, I want to go ahead and publish states 117. Specifically at the bottom of page 1, could you publish the username and display name of that particular message?
The username was j.kingrn, and the text was Jamell Demons, go lay down, I love
Demons.
you.
It rhymes with lemons.
I apologize to the court. Jamell Demons, go lay down, I love you. 2018, 10/24, and the time was 5:01 UTC, which would have been 1:01 a.m. Eastern Standard Time.
Okay. So I want to go now at the top of this page. Again, this message says what at 10/24/2018. Just the text of the message.
I told you so, Melly.
And those were from page 71,473 for counsel. Going to page number 75,935. Starting with the message in the middle of the page, October 26th, 2018, 10:58 UTC. What time is that in regular Eastern Standard Time on that date?
It'd be 6:58 Eastern Standard Time a.m.
And who is the author of that message?
j.kingrn,
And who is the recipient?
YNW Melly.
What is the text of that message?
Are you okay? Question mark. I'm here in Miami. Send me an address. I'm by the stadium. I'm a mess.
The next message, and again, it's talking about the thread IDs. Are we still in the same thread ID? Ending in 4182. You could publish the next message of October 26th, 2018, 11:26 UTC.
Which would be 7:26 a.m. Eastern Standard Time. The text.
I'm sorry, give me a break.
Sorry, we apologize. We need to take a recess, but it's 20 to 12 now. My thought is maybe we just take an early lunch. Something came up and I have to resolve it. All right, I apologize for the inconvenience. Just keep no place on your chair. Remember the admonition. Do not discuss the case. Don't form any opinions about the case. Don't allow anyone to discuss the case in your presence and certainly no research. 1 second. Counsel, can I see Sidebar? Try to check with the attorneys, see how much time you need. My thought is we'll see you back at 1 o'clock, all right? 1 o'clock, have a nice lunch, don't discuss the case. Thank you. The record reflect the jury stepped out. Counsel remain along with the defendant.
Judge, we would like to look at the Android phone. I know it's sealed. It's in evidence. Pardon me?
Yeah, we can look at it. It's no problem.
If you can look at it during the break or what have you. Just want to
That's fine.
You got it.
The only concern I have is, we have two ladies, both, one has no voice and the other says she's nauseous, so.
No, go. We'll do it later, before the jury comes back, if possible.
Well, I think Ms. Smith is here, she's fine, right? You can
Yes,
assist him, show the phone, or whatever.
Yes, with the detective's assistance.
You're all right, detective?
Yes,
You good with that?
That's fine.
All right, so take care of that now, and
Thank you.
feel better, all right? All right, thank you, we're in recess.
I believe so, ma'am. Phone 9807, sent 11/3/2018 at 4:29 p.m. Love you too, Bob. Phone 9807, 11/3/2018, 5:27 p.m. Mom.
Phone number 6942, message sent 11/3/2018 at 5:51 p.m. Yes, son. Publishing page 65.
Phone 9807, 11/3/2018, it's 6:10 p.m. Never mind, you already going to get it.
Phone number 6942, 11/3/2018 rather, 6:13 p.m. Okay.
Phone 9807, 11/4/2018 at 1:13 a.m. Give Mariah the phone.
6942, phone number, message sent 11/4/2018 at 1:35 a.m. I just went Jessica House real quick. Everything okay? Question mark. Brandon up. Same phone number, message sent same date at 1:35:54 a.m. How was the show?
Phone 9807, sent 11/4/2018 at 1:36 a.m. I'm on my way. I'm on the way down.
Publishing page 74, phone number ending in 6942. Message sent 11/10/2018 at 1:19:56 p.m. It's an image. Same phone number, message sent on same date at 2 p.m. Where? Same phone number, message sent on same date at 2 p.m. 51 seconds. Are you?
Phone 9807, sent 11/10/2018 at 2:07 p.m. Palm Beach. Same number. Time 11/10/2018 to 2:07 p.m. Got pulled over.
6942, phone number 11/10/2018 at 2:07 p.m. FaceTiming. Publishing page 75.
Phone 9807, sent 11/10/2018 at 3:16 p.m. I'm not going.
Who may be inclined to convict just because they've heard irrelevant, unrelated conversations between Mr. Demons and his mother, where he's calling her the B word and all sorts and manner of disrespect that is clearly off-putting to anyone. And under the pretext that they're trying to prove this phone belongs and is being used by Mr. Demons, the state is offering in reams and reams, tons and tons of inadmissible evidence that is irrelevant to this case. There's a point at which they sat there for 2 hours showing 530-something photographs. They introduced a jail call, and it seems like in the mission of proving that it's his phone, it's a license to put in all manner of evidence that is prejudicial and irrelevant. And we think that Mr. Demons' image, his character has been assassinated and irreparably tainted by the manner in which he is conversing with his mother, and the mothers sitting on that jury are now tainted in their impression of him and the manner in which they will render judgment. So we move for a mistrial on that ground and ask that the court put a stop to this if it is not going to grant that mistrial.
Stage Creeper,
We're going to do it, that's the section.
motion to that.
We address the juror issue, Your Honor, and I don't want to put any particular approach on that.
Bridget, the judge felt kind of quick there, automatically saying denied. I thought the defense made a good point. I mean, the juror, you can't unring the bell. The jurors heard this about YNW Melly. Now, maybe it is a leap to suggest if he calls his mother these names, he's automatically a murderer or they're going to convict him because of that. I mean, maybe it's a little bit of a stretch.
Well, I mean, I continue to be impressed by this defense counsel. He does an excellent job of bringing up issues whenever the state continues to try to bring in prejudicial information. He filed his motion before she attempted to bring in this evidence. That was denied, but it's something that he has to do to file a motion for a mistrial in order to save the record, preserve the record, in order for him to file for an appeal in case Melly loses this case. And so he's doing an excellent job of preserving the record and also making sure that the state knows that they are intentionally bringing in prejudicial information against Melly. Yeah. He knows that, and so he's doing a great job here.
Sometimes I look at this, Timothy, and I think, oh my goodness, the defense is, I'm not talking about this case, but in general, I say the defense is making unfair accusations or unfair complaints about the prosecution. You think the prosecution knows what they're doing here? Do you think that they're thinking, yeah, we know what we're getting in here? I mean, I don't want to accuse them, but this is not great evidence for the defendant, and I don't think they're too worried about the jury hearing about these details.
The prosecution knows exactly what they're doing. Part of the reason why they're introducing this evidence, particularly the volume of evidence and reference to the disrespectful tone that Demons took with his mother, is to establish, even if by inference, things about his character, and also to paint him more broadly in a bad light. And so to that end, his defense counsel did precisely what they should have done in this moment, to move for a mistrial. If that motion is defeated, to at least establish for the record that this is an error that could be appealed later, and just signal in a broader sense that this is prejudicial evidence. It's irrelevant to the case in chief. It's not drawing a line between the facts and the defendant's behavior. And so with that said, the prosecution knows what they're doing. They're trying to establish as much of a perception of Demons as possible as someone of low standing character and lacking in moral turpitude as a helpful inference that they can use later.
Prosecution, you sneaky people, you know what you're doing there. All right, let's take a break. We're going to hopefully get Terry Austin on to talk a little bit more about what she's seeing in that courtroom. So stay with us here on Law and Crime. We'll be right back right after that. Crime, everybody. So the Broward County courtroom took an early lunch break in the YNW Melly double murder trial. Today marks day 14 of the state's case against the man that they allege, 24-year-old Jamell Demons. They say that he shot and killed his two friends, Anthony Williams and Christopher Thomas Jr., back in 2018. The Murder on My Mind rapper and his co-defendant, Cortlen Henry, who's being tried separately at a later date, they claim that they were victims of a hit and run the day of the shooting, but authorities found evidence to suggest that the shooting came from inside the vehicle and that this was a staged drive-by shooting. Right now, I want to get some perspective from Law and Crime's very own Terry Austin, who's been sitting in that courtroom for us and tweeting as well about what's been happening. What an interesting morning, Terry. Good to see you again. So lead detective Mark Moretti back on the stand. He's still under direct by the state, and we were just listening to them read all of these text messages between Melly and his mother. When you were there this morning, you said that they lacked some kind of context, but what are you thinking about these messages right now?
Well, I think the prosecution is putting it into context now. They're reading these messages in chronological order, and you can tell from these messages what is going on. Lots of the messages are talking about, I love you, Mom, and her saying, I love you too, going back and forth. They had some altercations as far as he apparently canceled a concert and didn't tell anybody. But just like a regular mom, the mom is saying, look, you got to tell me, you got to tell people when you're canceling. So these messages to me were not as inflammatory as I think the defense thought they were. Yes, they are arguing back and forth, but they are pronouncing their love for each other, and any mom on the face of this earth will know that that happens with children. So there was a motion by the defense to have a mistrial, frankly, Jesse, based on the inflammatory nature of those comments. But based on my opinion, I think they weren't as bad as they thought they were. They were simply arguments between a mother, her son. But the bottom line is they profess their love for each other.
Well, he does call her names. I'm not going to say what he called her, but he said he did call her names. I guess I'm trying to understand, why the prosecution wants all of this in, other than to establish that this was his phone. And if they can say it was his phone, it helps in terms of tracking him and whether or not he was close to the victims on the night of the shooting. How can the prosecution justify this?
Well, that's exactly right, Jesse. The prosecution is justifying it by saying, look, this is his phone. He's talking to his mother. His mother's talking to him. It's the 9807 number. It's her telephone number. But the defense did say, Your Honor, this is just a, effort to make these messages come in because they are inflammatory. So not really for the purpose of showing that it's his phone, but for the purpose of outraging that jury. So the defense said exactly what you said, Jesse, which is, look, there's no real reason to bring all these messages in. We know the phone is associated with his mother's name. We know that he's using the phone, and they're just trying to inflame the jury. So I do think that was part of what the prosecution was trying to do here.
By the way, YNW Melly, how's he reacting to this? Because clearly his defense wasn't happy with it. How's he reacting to these messages being read out for the jury to hear and for all of us to hear?
Well, YNW Melly is sitting there. He's listening to all the testimony. He's basically just being very astute, very, observant of what's going on. I don't see any reaction one way or the other. He doesn't seem happy or sad or angry. He's just listening to all of this coming in. He's letting his attorneys do their job, and that's exactly what they're doing. They're objecting when they need to object. They're setting this record straight. I think the mistrial, part of the reason for that motion was for the record, and you have to obviously make these objections so that if you want to make an appeal because something has gone in that shouldn't have gone in, you have to lay that foundation during the trial. So that's exactly what they're doing. And
my understanding at the beginning of the day, I think the judge made a good ruling in terms of what these messages would not show. I think there were messages about a firearm, and the judge said that he would not allow those in. Can you walk us through what happened this morning?
Well, that's right. There was a motion. First thing, that's how we started off the court. We saw David Howard get up. He's one of the attorneys for the defense, obviously, for Melly. And he said, look, the messages regarding the gun should not come in. The judge said, I agree. And one of the things the judge said was, I'm letting all of these messages come in because prosecution is attempting to show ownership of that phone. But as far as the message regarding the gun, it is not relevant. It's subsequent to the shooting incident. So he admitted that, the defense was right, and he basically sustained the objection. So nothing came in regarding messages about a gun this morning. So the jury did not hear that.
How much longer is Mark Moretti going to be on this stand? I mean, I know that the defense probably has some questions for him.
Well, this morning we heard from Bradley, and by the way, she stepped out because
the prosecutor in the case.
The prosecutor, exactly, Christine Bradley. Her voice is she's losing it, and we're having Camille Smith do some of the reading of the messages. But this morning, the defense, essentially, that was the very first motion that they made. And so, we saw that was not allowed. And then these messages are coming in now through Moretti. And I think Moretti is going to be on the stand for probably 2 more hours. I don't think more than that. Very first thing that Bradley said this morning was 2 hours, and we're already through the morning, so maybe another hour or so, and then I think we might begin the cross-examination.
Where do you think that cross-examination is going to go based on what you've seen so far in the questioning of Moretti?
Well, I don't know if they're going to go in reverse order, if they're going to start from the beginning. I think the 2 main areas they're going to focus on certainly areas I would focus on, is the investigation and what a poor investigation it was. That was one of the things that the defense said in the very beginning. I think they're going to come back around and talk about what type of investigation he did, the failure to follow up on leads, the failure to look in areas, the failure to talk to witnesses. And then I think the other area they're going to talk about is the cell phone messages and the fact that you cannot, from the Cell Hawk and the Celebrate, you can't tell exactly where the location is. I think they're going to talk about that a little bit. And I do think that they'll probably go through some of these messages and give the jury a better idea about what they may or may not mean. Meaning, is there anything there that said I was there and I pull the trigger? What are these messages for? I do think that they should focus, and they may, on what is the significance of these messages, and why are you listening to all of this? So I think he's going to try to pursue that somewhat.
And if the prosecution ends their case, then we think the defense is going to try to move to acquit and not have this go over to a jury. Probably going to be unlikely. But Terry Austin, thank you so much. Really appreciate it. Great reporting as always. I am signing off. You are in great hands, because up next we're going to do the live Q&A lunchtime show hosted by Anjanette Levy. Stay with us.
I'm Anjanette Levy, and welcome to Law and Crime. We are taking your questions during the lunch break in the YNW Melly double murder trial. The state's case is winding down for sure. We are in day 14 of the state's case. And they've been hearing all day, all morning, again, from lead detective Mark Moretti. Just to bring you up to speed, in case you haven't been following the case closely, Jamell Demons is YNW Melly. He's 24 years old and faces 2 counts of first-degree murder and the possibility of the death penalty for the shooting deaths of his 2 friends back in 2018. His co-defendant, Cortlen Henry, claims that Chris Thomas Jr. and Anthony Williams were killed in a drive-by shooting. But the state says the evidence shows the fatal shots were fired from the back seat and that Melly did it. We have a great panel to take all of your questions today. With us is Terry Austin. She is down at the Broward County Courthouse in Florida covering the case. Also with us is Linda Kenny-Bodden, a defense attorney and host here at Law and Crime. And of course, Brian Buckmeyer is with us as well. He is a host here at Law and Crime and also a defense attorney. But Terry, let's start with you before we get to the questions. What's been going on in the courtroom this morning?
Well, Anjanette, this morning we started out with a motion by the defense to keep out some evidence that had to do with a gun. It was subsequent to the crime, and there was some discussion and some messages about buying a gun, and the judge actually agreed with the defense and said it's not relevant and it will stay out. The judge also added that he only allowed all of these messages to come in because he understands the prosecution wants to establish the ownership of the 9807 gun, and the prosecution is saying that that gun belonged to YNW Melly. And then we heard, as you said, Mark Moretti got back on that stand and they began going through messages, and many of those messages were between Melly and his mother. Some of it was inflammatory, but a lot of it had to do with, Mom, I know, I love you, and messages back and forth between the two of them talking about issues like, why did you not tell me the show was canceled? People are talking about your show was canceled. So to me, it sounded like typical mother and son discussions. And at the end of the day, you know, the defense actually wanted to keep it out. The motion for the mistrial was because of those inflammatory messages. And what David Howard argued was, he's the attorney for the defense, one of the attorneys, and he was arguing that it was put in only to inflame that jury, to make them upset about words that were being used, some derogatory words between the two of them by Melly. But as you know, I mean, arguments do happen. The judge immediately denied the motion, and Mark Moretti got back on the stand and continued to read the messages back and forth. So that was most of this morning, and I do expect when they come back this afternoon, we'll hear more of the same.
And it's been very tedious, Terry. I mean, I was going through the testimony again last night, and some of this is just, it goes on and on. I mean, there are 75,000, if not more, pages of Instagram messages or a download from a phone. And Melly was, talking in pretty derogatory terms about his mom. He was calling her the B word at some points and talking with friends about her, said she sold her soul. So I think he had a point, David Howard did. That, I mean, he's literally slamming his mom, and he said that it was basically tainting every mom on the jury.
Well, I think it was a great argument. I think it's an argument that the defense should have made. But for any mom out there who has a teenager or someone older than a teenager, once you have these grown children, they do say things. I think the bottom line as a mother I would take away, and I'm not sure how that jury is thinking about it, is they express love for each other at the end of the day. Yes, there are some derogatory language that's used. There's some, accusations that are made, but I mean, they're grown adults. And remember, Jamie, the mom, is a little younger than most moms, so they're closer in age than most. And so I definitely think they have a very close connection and probably do speak to each other slightly differently than other moms and sons may speak to each other. But the motion was made, and I think it was on behalf of the defense, obviously something that had to be done. But I think the mothers on that jury are probably not too worried about it.
That's interesting. Jamie King was 14 when she had YNW Melly. So I saw that in the documentary that was produced by Melly's team about them. Let's get to the questions now and keep them coming. We've got some great ones coming in. Submit them on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads, and we'll get to as many of them as we can during this hour. The first question is going to go over to you, Linda. Inside Hacker 3847 asks, why is the prosecution focused on the phone so much when they should be instead more focused on who the actual shooter is? They established the fatal shots came from inside the car, but not from who. Also, when is the defense's chance to state their case and bring in their own witnesses? So there was a lot there. So let's start about the focus. Start with the focus on the phone.
Okay. This has been a question from our viewers since this case has really started all the way through. And it's a great question because what the prosecution is trying to do is show that that phone with that last four-digit numbers was in the vicinity of the shooting at the time the shooting happened. That it wasn't someplace else, that the phone didn't have its own alibi. And therefore, the person who owns the phone, which they say is Melly, actually ownership in terms of use of it, was near the shooting. And he wasn't, he didn't leave, he didn't go someplace else. And the shooting is not where his co-defendant said it is, but it was someplace else. So that's why they're trying to establish by implication the location of the phone, bringing Melly there, and therefore he has to be the shooter. Now, does he have to be the shooter? That's the crux of this question. I think we're focusing an awful lot on that. But to me, they have not put the gun in Melly's hand. They have to put the gun in Melly's hand. And even if the shots are fired within the car, which I'm not sure about that, we'll see what the defense has to say. There's another person who's charged here with the homicide, and that's Cortlen Henry. So I don't think that the focus on the phone really gets them as far as they think they have gotten. And will they be able to prove something? Will they present their case? Well, yes, I believe they're going to present a case. They'll start when the prosecution rests. They don't have to. Defense has to do nothing. But in my view, it is always better if you have something to present to that jury to give it to them so that those jurors in that jury room who are on your side can argue for you and say, hey, the prosecution didn't prove its burden at the time the jury deliberates. So I hope that answered all the questions.
And I just want to add to that, the state says that, a big part of establishing that Melly owned this phone was the fact that the phone showed a location at the crime scene at US 27 and Pembroke Road at 4:03 a.m. the morning of the shootings. So I think that's part of this as well. So I don't know if that's part of why they're hammering on this so much, to show that Melly had possession of that phone in that time period. So I guess we'll wait and see. But yeah, the defense should get started on Thursday. They said they're going to try to have civilian witnesses here on Thursday to testify. So let's get to our next question from TikTok. Will any of YNW Melly's family or his ex-girlfriend take the stand? Brian, what do you think?
I don't think so. And the reason why I would say that is, what would they be able to offer other than for character evidence? And while I'm sure YNW Melly has some parts of his character that he wants to put in front of the jury, that's probably a door he doesn't want to open, because if we start talking character evidence, you get to see not only the good, but you also get to see the bad. And you don't want to bring that in for a case, at least as a defense attorney, where it kind of looks like you might be on the horizon of a victory here. I think keep it technical, keep it to the facts, establish that they cannot put the gun in YNW Melly's hands, and forget the rest of the noise. And I think that's a good strategy for the defense.
And Melly does have, a prior criminal record, a juvenile record involving a firearm. So I'm sure the defense doesn't want to open the door to that coming in at all. Our next question, Terry, from Miss_Catania_ from Instagram asks, why the long video of the car ride by the cop in helicopter views, clutching at straws if you ask me? So Terry, why did they show that?
Well, I think everyone is wondering, why did they show that? They had the helicopter view, so they had that from way up top, so you can have that 30,000 foot level view, and then they had the same view from a car from the inside. They're just trying to show the route that the cars took that evening, but there was, in my opinion, no discussion about where they're coming from. Just very little commentary by Mark Moretti, who is basically saying, okay, now here we are passing the Montessori school, which is where some of that surveillance footage was obtained. And here we are, passing where we think the crime scene was at the time. And so he's marking some locations, so I think the jury can take a look and a feel for how long the distances were between each other. But other than that, I mean, they were fairly long. I don't think that it was that valuable. I will say this, it was more valuable than the original footage that the jury saw, where there was no commentary by any witness at all, and where the prosecution simply just played video of cars going back and forth on a highway. So I think this was a little more valuable, but I'm not really sure exactly what the prosecution wants the jury to walk away with, except understanding time and distance between various points.
It was interesting to watch from above like that. Not much traffic when they shot that either on I-75. Let's take a quick break. Keep the questions coming to us on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. We'll get to as many of them as we can when we come back. I'm Anjanette Levy, and you're watching Law and Crime. Stay with us. Welcome back. I'm Anjanette Levy, and you're watching Law and Crime, and we're taking your questions this hour during the lunch break in the YNW Melly double murder trial. So keep the questions coming in to us on all of our social media platforms, YouTube, Twitter, Facebook, Instagram, Threads, and TikTok. We'll get to as many of them as we can. So let's get right to the questions. Quandale Dingle, Terry, from YouTube asks, what is the prosecution's best evidence for convicting Melly of the murders?
Well, I think the best evidence they have so far is that video from the studio showing him getting into that car. So we know he's there in the car at a certain point in time. But what they failed to show is, was he in that car when the shooting from the back seat occurred, and was he holding the gun when the shooting from the back seat occurred? And so I don't think they've connected all of those dots. And, right now they're very close to the very end of their case, and they really have not established everything I think that they need to establish. The medical examiner was also very good for the prosecution. The medical examiner stated that the shots that killed the two victims came from inside of that car, and the reconstructionist also came in and corroborated that information. So I think the video showing Melly getting in the car, what the medical examiner said as far as the autopsy were concerned, and connecting that to what the reconstructionist said. So far, that's their best evidence, in my opinion. Is it enough? We'll see, but thus far, I don't know if they've convinced that jury beyond a reasonable doubt.
Our next question, Linda, comes from Lavender from YouTube, and Lavender asks, should the prosecutors have gotten someone to interpret the text slang and acronyms and emojis? It's important to have the right context to understand the conversation. Many misread messages.
Yeah, I know. That was a really interesting question, because when I was here yesterday, and Jeanette, and they were reading some of those text messages, you really had to know what some of the words mean. And I laugh only because, like, the night before, I had completed a quiz that said, can you get these 60 slang meetings for Generation Z, and can you answer them all? Because that's what you're going to need to interpret things in court. And of course, I only had 37 of the 60. So it was on my mind, but I don't know if there's an expert in that. Is there an expert in slang? Is there an expert in rap? Is there an expert in hip hop? Is it an expert in Generation Z? Is it an expert in black culture? Who is the expert that would interpret it? That's going to be an interesting issue if you tried to go there. Brian's
whatever,
laughing.
I don't know what.
37 is good.
Yeah, whatever. I don't know what an abbreviation is or whatever. I just Google. And, usually I can find out and figure it out. But the jurors are not supposed to do that. So it will be interesting to see if they're able to understand some of it. Because, these are young guys, too. I mean, young people use all different types of ways to communicate in text that a lot of people who are a little older don't. Let's get to this next question.
Can I just add one thing to that?
Yes.
I mean, I've been in a case where a judge thought that the meaning of the word Gucci in text messages meant Gucci, that you're going to go buy Gucci, in the store. And it really was referring to a type of drug. But even the judge didn't understand that. So, it's hard to get somebody to interpret all of the language that's being used.
That's very interesting. Well, maybe they'll bring Danny Polo back. I don't know. Maybe he can get to the bottom of this for us. This next question's from Twitter, and I kind of feel like everybody could weigh in on this one. We talked about this morning in our morning meeting. @reallyher_ty asks, do you guys think that the purpose of the documentary trailer that was played yesterday in court places Melly at the scene of the crime, as the words at the end said something along the lines of YNW Melly and his two friends were victims of a drive-by shooting? And we were talking about this morning because Detective Moretti was asked about this yesterday on the stand before the clip was played. It was posted less than 2 months before the homicides, or after the homicides, December 4th of 2018. And he said that really interested him, or piqued his interest and made him curious because, and then the defense objected. So Brian, I'll start with you. It sounds like it puts Melly in the car, but we don't know if he put that text on the screen.
Yeah, so there's a number of issues there. I was trying to look at the text of the screen. I thought it said something about he was the target of a drive-by. And to that I would say one of two things. One, did Melly write it? Two, did someone who actually produced that write that as a screen grab of what they perceive this to be? And three, that's not the way the English language works. I'll make it this way. I'll do it the same way I would argue in front of a jury. I used to live in Toronto. I still pay bills there and help out. I drop off my child every morning in Harlem. I work in 32nd and Broadway, where this recording studio is, and so I can be at any three places. If someone goes and shoots up those locations, they are targeting me, but that doesn't mean that I'm actually there. I could be on vacation. I could be somewhere else. Just because you know where I may be and you shoot up that place, it doesn't mean that I am there. That's what I read there. I don't see how that means that because you're targeting me at a location, it means that I'm actually there. If they want to walk into that argument, by all means, I would flip that on them, and I would tell the jury, I want you to sit back and cross your arms when they make that argument on summation and just shake your head at them. And as they make that argument, because prosecutors often walk into it, and they start to see jurors do this as I told them to, I'm sitting back, putting my feet up, and I say, yo, YNW Melly, your next rap video, I want my name in it, because we're walking. because that's a ridiculous argument to make.
But doesn't it, what matters is what piqued the interest of the detective. He said he saw it, and that made him kind of go, because Bortlen did not say that Melly was in the vehicle.
I'm glad it piques your interest. I'm sure a lot of things pique your interest. It doesn't actually make it fact. Officers have their interest piqued all the time. You think if piqued interest in an officer should mean conviction of a death penalty trial, then by all means, I have a million people in New York City that are piquing police officers' interest, and we should put them all on death row.
Well, I mean, it was 4 years ago, almost 5 at this point, 4.5. So I thought it was interesting, and, it'll be up to the jury to give any weight to it at all. We don't know if they're going to give it any weight. Terry, I know you thought that it helped the defense.
I did think that, Anjanette, and here's why. In my opinion, it does show Melly and Christopher Thomas and Anthony Williams working together. They're in the studio. They're expressing, love for each other. There's no question that it's endearing and that they had a very strong relationship. And I think the words at the end, whether or not they were targeted or whether or not he was in the car, it is sort of giving homage to his two friends. They were shot and killed shortly after, this video was made. They were shot and killed right before that, and then the video was made. So I think it's sort of showing that, he's recognizing them, he's acknowledging them, he's giving homage to them. And, he looks very pensive. He's looking out over the ocean. He doesn't look like he would have shot up his friends if, in fact, he has such a close relationship. And the other thing I'll say, Anjanette, is I don't think if the defense wanted to get that in, they would have been able to get it in because it's self-serving. And so at least I think that's the argument that would have been made. So I think it actually, all in all, it favored the defense.
Can I weigh in on this? Because this is such a hot button target.
Of course, Linda.
A target on this. Not only with the piquing of the interest that Brian has said, I think the defense can now argue, you see, even this piques everything piques his interest. Why? Because they targeted him as being the defendant, as the one they're going to go after. They had blinders on. This is what the police were doing. So everything they see says it's Melly, and they didn't really look beyond that because they wanted the high-profile defendant. They wanted Melly. And if that piques their interest and that says, hey, he's guilty, then all their evidence is as suspect as that.
Well, that's where they're going with this, Linda. David Howard said in his opening that the investigation was botched and that Moretti saw this as his chance to be a star. He was going to get the celebrity put in prison for this. So that's definitely where they're going. So it'll be interesting to see what else they do with this. What I thought it was interesting, too, is that they played a 90-second clip. It's a 20-minute documentary. So obviously they played a condensed, shorter version. Why? I'm not sure. But it was an interesting watch. I watched the whole thing last night. Let's go to our next question. If all the shots were fired after they passed, shouldn't they get life for that regardless? This is from Ryan Mercer from YouTube. Terry?
Well, look, the shots that killed the two victims, at least according to the medical examiners who did the autopsies for each of them, were from inside the car. At least that's what they're claiming. And then the prosecution is saying that it was staged, that in fact the car was, shot up by both of the defendants and trying to make it look like it was a drive-by. Now, the death penalty is for crimes that are, heinous and atrocious, and they're asking for the death penalty because they are claiming that it's exactly that. They're claiming that it's gang-related. They're claiming, that it was something that was premeditated. And so because of those reasons, that's why we have that death penalty. I don't know if this is a case that most people would say is a death penalty case. The fact that they drove and ultimately shot into the car to make it look like something, at least that's what the prosecution is claiming. Does that make it a more aggravating factor, more heinous? Perhaps, and perhaps that was one of the issues that went into the prosecutor trying to decide whether or not to make this a death penalty case. So the totality of the circumstances, I think, is what made them decide to do it. Whether it's the right thing to do or not. We've had some discussion about, death penalty is very serious. Do they have enough evidence to make this a death penalty case? Will the fact that it's a death penalty case make the jury think twice about convicting? Those are all the things the prosecution should have taken into consideration, and I'm sure they did, and they decided to bring it as a death penalty case.
Mm-hmm. Our next question, Linda, comes from XO_Nikki_from Instagram. When did Melly say he wasn't there or that it was a drive-by? Is this not hearsay? Only Bortlen is on record saying it was a drive-by, not Melly.
Well, you're absolutely right about that. Melly did not, unlike Bortlen, give a statement, and Cortlen Henry give that statement to the police. But the defense argument is that, hey, you haven't proven he was there. I mean, he left the car. I mean, they're basically asserting that, right? And so that assertion is something the prosecution has to disprove because they haven't really objected to, which is why they're going so far into the weeds of this phone to try to say, hey, the phone was in, 4,000 steps or 3,000 steps of the location of the shooting, and therefore it had to be him who was there. He couldn't have left the car. So that's where it's all coming from.
Brian, our next question comes from Twitter. At Amanda ACC asks, why were Melly and Cortlen's cases separated?
So Amanda and ACC, thank you for that. I believe, and Angela, correct me if I'm wrong, it would be one of two reasons. One, they might have what's called an antagonistic defense. So one might be pointing the finger at the other, or evidence might prejudice one over the other. So they would separate the case. The other, which makes sense, is that there are different punishments. For YNW Melly, you would have to find a death penalty qualified jury, while for his co-defendant Henry, they would not. So in seeking the different qualifications for jurors, I think it's probably more the second than the first. That's why the jurors would be separated, or the cases, would be separated.
Right. If you have a case with multiple defendants and both are facing the death penalty, they still have to be separate trials because you can't try two people together in a death penalty case. So that is more than likely why the cases were severed. Our next question, Terry, and I hate to put you on the spot with this, but it's an interesting question, and I'm assuming the answer is no. But Ta_Shah7056 from Threads asks, does the state of Florida have ShotSpotter technology to show a shooting occurred that morning in the track from the studio to the hospital? And just a little background here, ShotSpotter is a technology where they can detect, it literally is listening and can detect where a gunshot is coming from with some type of reasonable degree of certainty. So do you know if that type of technology is used in Florida or was back in 2018?
I don't know if it was used in Florida back in 2018. I do know that the prosecution did have a witness who talked about spatter early on, and that there was some of that, I believe, on the shirt of Bortlen, if I'm not mistaken. And so that expert came in to talk about what would happen if blood was, coming back onto someone else or to a seat or anyone in that vehicle. As far as the state of Florida, getting some sort of expertise in there, they had that one witness that was the witness from, I think, the first week of trial who talked about that. I don't know how much it added because the spatter didn't, from my recollection, and Anjanette or anyone else if you remember, but I don't believe there was spatter all over the car. In other words, I don't believe that there was anything on Melly. Obviously, the two victims had their own blood on them, and, the spatter would show whether or not someone who wasn't killed was in that car. And so I don't think they made a lot of progress as far as that expert testimony was concerned.
We are going to take a quick break, so stay with us and keep the questions coming on all our social media platforms. We'll be right back. Welcome back. I'm Anjanette Levy, and we're taking your questions here during the lunch break in the YNW Melly double murder trial. The state is wrapping up its case. Detective Mark Moretti is on the stand, and he's still on direct examination. He's been on the stand since Monday. So the defense will get its turn with Detective Moretti later today. And this is somebody they're going to hit hard. They will go hard at him because they said in their opening statement that he basically botched the investigation. The state disagrees. They don't believe that. So let's go ahead and get to these questions. Our next one comes, Linda, from Hugh Josso from Twitter. Haven't watched a second of this trial, but every pic I see, he's laughing or smiling. Is he insane?
Well, no. What you're seeing, a lot of those pictures are out of the presence of the jury, okay? So that, we tend as defense attorneys try to relax our clients out of the presence of the jury. You can be laughing, you can be smiling with them because when they get, it's a very, it's a death penalty case. So when they get in front of the jury, you want them to be like totally without emotion. So those are the pictures that you are seeing. It really doesn't mean anything. The jury is not seeing them. And, you're coming from the viewpoint of having this trial on camera. But most trials are not on camera. I can guarantee you that a lot of times you will try to make sure that the pressure is relieved from your client out of the presence of the jury and smile with them, tell them a joke, laugh, whatever.
Mm-hmm. Yeah, and I don't think you can read too much into that. It's not like this guy is sitting there cracking up when they're showing pictures of his friends. I mean, these are things that are happening outside the presence of the jury. So I've seen some images of him, especially yesterday, where he looked none too happy during the text message segment of the text messages between him and Sack before the homicides. He wasn't very happy those were being shown in court, or at least he didn't appear to be. Michael Jorgensen from YouTube, who I feel like Michael asks questions every day. Brian, after 2 days of delays and constant objections over the phone and messages, do you think the defense will look panicked or as if they are trying to cover something up in the jurors' eyes?
Well, one, thank you, Michael, for always coming every day and asking questions. And two, that is a great question. It's really walking a tightrope. Like, it could go either way. And really, it's hard for me to analyze it in this case because it really comes down to the relationship that either side develops, not only from voir dire when they do jury selection, but throughout the case. Because you can make 5 objections, and that can be too much, depending on the strength of the other side's case and how you come across. Or you can make 50 objections, and you could be the greatest person in the room. And so I think it really depends. It's not really, unfortunately, for us to say, being analysts, or us to say as viewers, but it's really that relationship between the jury and the defense attorney and the jury and the prosecutor. Right now, if I was to, and we should probably ask Terry because she's in the court. Right now, I'd probably guess that the defense attorney is well liked in that room based on some of the rulings from the judge, based on his swagger and just the way he holds himself. Either he's really faking it till he makes it, or he's kind of feeling that the jury is picking up what he's putting down.
Well, I mean, you have to keep in mind, you can't let them see you sweat. The old saying, never let them see you sweat. So I think David Howard has a lot of swagger. But Terry, let's talk about that for a minute, because his co-counsel was the one jumping up with all of the objections yesterday and all of the sidebars. I mean, I feel like there are more sidebars in this trial than I've seen in ages. So how do you feel that the defense is perceived by the jury?
Well, I think both of them are well regarded by that jury because they are defending their client. I think you saw Stuart Adelson jumping up more yesterday because I believe he's going to do the cross-examination of Mark Moretti. So he's the one who's paying close attention to that direct testimony. At some point, I do think you have to just sit back and let the judge make his rulings, and if you know how he has ruled on certain issues, just allow those certain pieces of evidence to come in, knowing that he's probably going to rule against you. If you have a standing objection, and he has tried to do that, to put a standing objection to protect his record, because remember, if he doesn't object to something, he may not be able to appeal that very issue. So I think he's trying hard not to have too many up and downs and too many sidebars. He has asked for some sidebars. One of the reasons that both attorneys are asking for sidebars is because the judge has said, look, no speaking objections. He doesn't want to hear you explain before that jury why you are objecting. So I think the jury understands as well, because the judge has said in front of the jury, no standing, no speaking objections. You make your objection. If you want to talk about it, you come to the sidebar. So I think they may be frustrated by all of the breaks, but at the same time, I'm getting the impression that the jury understands this is the process. This is a death penalty case. You have to do what you need to do to protect your client.
Linda, let's get to our next question for you. It's Tanya Baby. She was on yesterday too from Instagram. Why are they viewing text messages before the murders?
All right. Again, yes, very good question and something we have been talking about. The only reason the prosecution is putting these text messages in is to show that this is Melly's phone, that he had care, custody, and control of it really all the time, not some of the time, that it really wasn't a shared phone, as has been argued in court. And therefore, at the time of the homicide, time of the murders, when the shooting happened, when the phone is nearby or within a certain vicinity of the shooting, that Melly had to be attached to that phone, as many of us are. We take our phones everywhere, right? If we lose our phones, where's our phone? Where's our phone? Let me ping our phone. Hey Siri, you know, I don't want to do that because Siri just responded to me. But so that's why they're she does that. She does that. That's why they're showing all of these text messages, and that's why the defense is objecting, saying, look, these text messages are irrelevant. It's bringing in prejudicial material. It's bringing in character evidence, how he treats his mama, and they should not be in.
Some of those messages, though, from yesterday showed arguments between Sak and Melly. And they were arguments about Melly's mom. It looked like Sak thought Melly's mom was trying to break up the group. Sak was upset, feeling like Melly was getting all the credit. He said in one of the text messages, you know, you're the face of it, but I'm the CEO. There was also a lot of talk about money, too. So I think the prosecution is in part showing these to show what was going on with these two beforehand, before the homicides, in the discussion about the money. So I could be wrong, but that's kind of part of where I think they're going with this. We got a question from Threads, Brian. This one's for you. Ohey.Shauna asks, does any team have the clothes that Melly was wearing during the murders?
Oh, hey. Well, thank you, oh, hey. First, I don't think so. I know that we heard from Glass about this whole issue of changing clothes, and I know it wasn't exact, and I have a very big problem with that, especially when it comes to cross-examinations, unless that's your strategy. If you're going to cross someone to figure out when someone says your client changed clothes, when there's a recording session at like 2:30 in the morning and then he sees them sometime later, I want to know what that sometime later is. Are we talking about 3 o'clock in the morning, 5 o'clock in the morning, 5 o'clock in the afternoon? Because it makes sense to me that if he's up this late in the recording sessions, and I think they didn't fall asleep, or they ended the recording session early because some people did and some people didn't fall asleep and they went later. If Glass sees YNW Melly at 5 o'clock in the afternoon after seeing him 2 o'clock in the morning, I would hope that YNW Melly changes clothes. He'd be smelling pretty ripe at some point in that day, and it would make perfect sense. The real question that I have, and I think it goes to the defense in terms of helping them out, is where's his clothes? Why did you not subpoena it? You have a video of what he was wearing. You could easily ask for that subpoena. As a defense attorney, I have nothing that I can stop that. You can go and get it. If you can't get it, then you can put an investigator up there and say, we did everything within our legal power to get these clothes to show to the jury, and they, being the defense, or they, being the defense client himself, stopped us from doing it. You would have had an amazing negative inference against them, but you didn't do that. Why? Now the defense gets to use that against you.
It's reminding me a little bit of the Alec Murdaugh case, where the discussion about the change of clothes came up, and they never found the clothes that he was wearing in a video before the homicide. So everybody's on tape these days. So let's take a quick break. Terry, we are going to sign you off, and we thank you for coming on. We want you to be able to get a bite to eat and then get back into court. Everybody else, stay with us. Brian, Linda, and I will be right back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and you're watching Law and Crime. We are winding down the lunch hour here and still taking your questions, so keep them coming as we wind down this Q&A session. Brian, this one will go to you. This is Ty from YouTube. He asks, is it going to be to the defense's benefit that there seemed to be no messages referencing the shooting? That like Melly and his mom were concerned about Melly's safety after.
Well, Ty, thank you for that question. I agree. Not only to your point that Melly's mother seemed to be only concerned about his safety, but for all the good and bad of what that conversation shows, him being extremely disrespectful to his mother and his mother kind of going back and forth with him. I'm not advocating for that in any way, shape, or form. Mom, I would never do that to you if you're listening. But if they're open, if their relationship is that open that they can have that kind of conversation with each other and she would still be cool with him afterwards, don't you think that he would also be open enough to talk about maybe a little bit more, maybe leak that he did this? I think the defense can use that to their advantage if they can flip it to say, yeah, he's a horrible son. Like, I'm not going to protect him from that. But if he can say whatever he wants to his mother, wouldn't he also feel comfortable enough to say that he shot someone or was involved in some way, shape, or form? I think it can be used either way. I just don't see how strong it is for the prosecution overall.
Mm-hmm. Linda, Riley J from YouTube asks, in terms of the defense, what would be the best move/questions for them to ask moving forward to potentially move the jury to a not guilty verdict?
Well, I think it's the theme of the defense. And by the way, just a comment on what Brian's point is, isn't the mom in the courtroom all the time supporting her son? So that says a lot. But
yes,
I think
she is.
Yeah, it's the theme of the defense, really. The theme of the defense is, like, you didn't prove that the gun is in his hand. He has no motive. And even though the prosecution doesn't have to prove motive, I would harp on that. I would say, look, what did they show you? 3 texts because people were discussing, who's the CEO, whose money? Everyone does that in a business. You have that conversation with everybody in a business that you run. That's not unusual. What would be unusual if you didn't have the conversation, actually? So, I mean, I think it's the theme that you can't prove he shot. The gun was in his hand at the time the shooting occurred. He's the one, of course, that would be the target, not the other two, because he's the high-profile person. If anyone wants to get anyone, he's going to be the one that's the target. Also, I would bring in my own forensic experts to cast some doubt on what both the medical examiner and the crime scene reconstructionist did. All you need is a little bit of doubt, because this is a death penalty case. And so in that jury room, that jury is going to hold the prosecution to a higher standard. Yes, beyond a reasonable doubt, but they're going to make sure it's beyond a reasonable doubt, not just kind of like you kind of eked yourself there.
Mm-hmm. This question, I feel like both of you guys could maybe answer this question since we've talked so much about the phone. But Brian, I'll start with you. Anaya Thompson from YouTube asks, do you think the defense really has a way to prove that the phone was in fact shared?
Oh, Thompson, thank you for that question. So I don't think there is a way to ultimately prove. I mean, if you believe the other people who shared the phone, then yes, you put on those witnesses, maybe you put on the mother, and you have a very limited direct examination and say, hey, I only want to talk to you about the possession of this phone. I don't want to talk to you about anything else. And the reason why I say that is because the cross-examination of that witness would then be limited within the scope of what you're talking about. So if you make it nice and tight and neat, maybe you can get that. But I always say, whenever it comes to arguing with anyone, prosecutor, whoever you want to argue with, or don't, I always ask the question, is this the hill you want to die on? Because you don't have to fight on that hill. You don't have to go and say, I want to argue now as to who's the possession of this weapon. You can go exactly to what Linda said and attack those 3 things and say, I don't care whose phone this is. You know what I know is not in my client's hand? A gun. And then just walk away from that argument. Let them roll in the mud with arguments that won't get them to a conviction.
Very interesting. All right, our next question I'm going to throw over to you, Linda. Do you think that, this is from Daryl VZ from YouTube, do you think the defense is going to call Jamie King to testify on behalf of Melly? We kind of touched on this earlier with Brian, but what are your thoughts on that possibility, Linda?
I don't think they need to, because she is in the courtroom. Now, if this gets to a penalty phase, of course, on the stand, number 1 on the stand. But I really don't think they need to. I don't think they need to go into, what are they going to, if they put her on the stand, they could make a mistake and open her testimony up to a lot of different cross-examination that they don't need. Because the only issue was those text messages she had with her son, which are there before the jury to see. And, you know, in those text messages, what he didn't say, hey, Mom, I need your help. I just killed somebody. So they don't need to do that. Her presence is enough.
Quandale Dingle from YouTube asked, what will the defense try to do to win this case? And is it even possible, Brian?
So Dingle, thank you for the question. So I'm going to echo a lot of what Linda said, but I think the main things you go after are the trajectories. You want to muddle that science there, because for the prosecution, I think that is partially their strongest piece of evidence. The other strong piece of evidence they have is this video of them walking in to the vehicle and where YNW Melly sits. Now, you can't argue that. It is what it is. But I think you can make the argument of, we know where he enters and where he is when he enters the car. We don't know where he is when the shooting happens. We don't know where he is when he gets out of the car. And you leave it at that. From there, I think you make this you attack the investigation. I think you can also bring the prosecution into the attack as well. And I think for a case like this, what I like to argue, I go back to hey, my father's a general contractor. And although he didn't tell me a lot about being a lawyer, he did teach me one thing. You measure twice and you cut once. Well, the prosecution and law enforcement measured once. They seem to get it wrong. We're not asking you to measure it again, because if we cut here in a death penalty case, just like the general contractor, you can't use that wood again. You can't go back and correct it. So we are expecting you, the jury, to be the second measurement and correct the first error. I think you attack them like that and you empower the jury. I think it's not that hard of a case for the defense.
All right, Brian. Well, thank you so much, guys. It's been fun as always. I'm going to be signing off here, but Linda Kenny-Bodden is taking over and will take you through the afternoon. I'm Anjanette Levy, and you've been watching the Lunch Show Q&A here on Law and Crime. We'll be right back.
Good afternoon and welcome back to the Law and Crime Network. I'm Linda Kenny-Bodden. Well, South Florida rapper Jamell Demons, better known as his stage name YNW Melly, remains on trial accused of a double murder. The 24-year-old rapper is accused of killing his friends and members of the YNW music group Anthony Williams, also known as YNW Sakchaser, and Christopher Thomas Jr., also known as YNW Juvy. It's day 14 of this trial, and we're nearing the end of the state's case finally. Their final witness is Detective Mark Moretti. He is continuing his testimony since Monday, but while we wait for court to return from their lunch resets, I'd like to recap with you some key moments of Detective Moretti, the lead detective's testimony from earlier today.
Mom out for me. Published on page 8, phone number ending in 6942, sent August 30th, 2018, 11:32 a.m. Listen, I do care about any of this, but I have not posted anything about Sack, and he jumped in when his sister started making posts about me. That's crazy.
Number 9807, sent 8/30/2018, 11:32 a.m. Leave it alone. From number 9807, sent 8/30/2018, 11:32 a.m.
Publishing page 11. Phone number ending in 6942, sent September 11, 2018 at 11:54 p.m. You're my heartbeat. I cry all the time. I miss you so much, but I know I have to let you grow up.
Phone number 9807, sent 9/11/2018, 11:55 p.m. No need to cry, you fit to be a millionaire.
Phone number 6942, sent 9/11/2018, 11:56 p.m. You deserve it. You're so talented. We play your music all night. Same phone number, sent September 14th, 2018 at 6:15 p.m. I love you, kid.
Phone number 9807, sent 9/14/2018. Love you too. I see you be chillin'. I love that. Keep doing you. Phone number 9807, sent 9/14/2018 at 6:15 p.m. Everything gonna be in place.
Publishing page number 28. Phone number ending in 6942, message sent 9/23/2018 at 2:53:01 a.m. Phone number 772-940-4993. Same phone number, message sent same date at 2:53:14 a.m. You owe like $8K.
From 9807, sent 9/23/2018 at 2:53 a.m. No, I don't. From 9807, sent 9/23/2018 at 2:53 a.m. The show was only 5K.
Phone number ending in 6942. Message sent September 23rd, 2018 at 2:54 a.m. This is bad. Call him, please. It looks bad for everybody involved. Same phone number. Message sent September 23rd, 2018 at 2:57 a.m. You put everybody before you, and real friends would have said leave, and they would miss the show, not you, because it's your face. I'm disappointed. Publishing page 29. Phone number ending in 6942. Message sent September 23rd, 2018 at 2:59 a.m. You act like you don't care anymore about your career. This is your future, not mine. I have a career. You need to start thinking about you and get your priorities together. I can't do it for you because you don't want me to.
From 9807, sent 9/23/2018 at 2:59 a.m. Man, you don't know what you're talking about. Just stay out of my career, please. From 9807, sent 9/23/2018, 3 a.m. I've been working harder than ever. You don't know the half. From number 9807, sent 9/23/2018 at 3 a.m. I made one mistake. Wow, everyone misses at least one show in their career.
Phone number ending in 6942. Message sent September 23rd, 2018 at 3 a.m. They called me at work. I was afraid something happened. You didn't call me.
On 9807, sent 9/23/2018 at 3 a.m. Where Brandon at?
Publishing page 30. Phone number ending in 6942. Message sent September 23rd of 2018 at 3:01 a.m. This is the second show that DA promoted for you. It looks bad on him, and people already talk so much stuff. I get put in it regardless because you're my child, Jamell, and I can't take up for you when I don't know. Same phone number, message sent same date at 3:03 a.m. No, I don't know because you act like I did something to you, and I never anything but help you, and it looks bad because tracking everybody there, why you ain't go with that?
There's three of defendant's lawyers, as well as the assistant state attorney, New Jersey, New Jersey. Mr. Demons.
Mr. Demons.
Okay? Outside your presence, counsel, one of your attorneys advised me that Ms. Liberty is ill, is not able to proceed. I thought we took an early lunch, but she wasn't feeling well. But they told me she's not able to proceed, and she's part of the team that we could be here, the way I understand. So counsel respectfully asked me to break early today, and asked him to go outside and talk to Ms. Liberty and find out, make sure, get an idea when she's able to proceed. After he spoke with Ms. Liberty, he thought it would be better to postpone until Monday. Is that right, Mr. Anderson?
That is correct. And as I've indicated to the court, she's outside the courtroom, down the hall. And I would bring her in, but I don't think it would be advisable. And I told her what I was going to report to the court, and I just reported this to our client, who understands, unfortunately, the inconvenience, and I want to thank the state and the court for their patience and understanding of this issue.
That's not an issue. Mr. Demons, you understand? Okay. And so you're in agreement, we're just going to proceed on Monday. If there's Liberty a chance to recoup. And so counsel, as I explained also, my thought is I need to say something to the jury. I'm just going to tell them the attorney is ill. I'm not able to go. I'm concerned about tomorrow, so we're just going to see everybody back on Monday.
We're in full agreement.
Stay all right?
In terms of on Wednesday of next week.
I'm sorry, I didn't get
On
that.
Wednesday of next week, I was supposed to be with Judge Fund. I don't want to delay this any longer, and I think the defense counsel in that case is moving for a continuance for scheduling issues as well.
Which case?
The one that Judge Fine and Your Honor had said I would be available on the 19th to time qualify.
Excuse me, don't put me.
Sorry. Judge Fine asked Your Honor to accompany time qualifying on that case on the 19th.
So that may not go?
Correct. I just want to make sure everybody's aware.
I wasn't aware that I hadn't had any discussions with Judge Fine. I was just told that he didn't leave on that day. All right, so I'm going to bring the jury in, and we're just going to tell them Monday.
Thank
All right?
you. And I thank the court for
No problem. Detective, just send that. Thank you. We'll see you back Monday, all right? Yes, Your Honor. You bring them.
Citizen stay here.
Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, and ladies and gentlemen of the jury. Ladies and gentlemen, we're going to have a break early today. I apologize for the inconvenience. One of the attorneys that probably took an early lunch wasn't feeling well, and now she's indicated she just can't proceed further today. So we're going to call it for today. We're going to adjourn today. I also try to inquire whether or not they'd be, is tomorrow good, and the answer I gave was probably not. So my thought is to just hold off. We won't be in session tomorrow, so I'm not sure whether the attorney will be available or not tomorrow. So my thought was to see everybody back on Monday. All right? I apologize for the inconvenience. There's nothing anybody can do about it. You're sick. You're sick. All right? So just remember the admonition. Don't discuss the case. Don't form any opinion about the case. Don't allow anybody to discuss the case in your presence, and certainly no research about the case. All right? Just leave your notepads on your chair, and we'll see everybody back Monday. Sorry for the inconvenience. Let the record reflect the jury stepped down, Councilman, all the defendants. What are we doing about the deposition tonight?
I'm going to find out right now. I think she wants to move it to Friday at the early. And but I'll check. Don't leave, and I will. It will be done before Monday.
Definitely not tonight, correct?
Definitely not tonight.
So I can cancel it before that.
Yes, please.
Anything else to discuss, Council?
That's it.
Have a good weekend. Tell Ms. Winby I hope she feels better.
I certainly will.
We're adjourned.
is in the hands of Jamell Demons, YNW Melly. My guests are here to break it down with me. Mina Sawetlona, Sirius XM host. Mina, welcome back. I haven't seen you since you were in the studio. And of course, my dear friend from out in California, Mitra Hurian. Mitra, I want to go to you first though. All right. Let's start with the primacy recency that we just heard. The text that, if assuming that the prosecution has proven that this is Melly talking to his mother, Jamie King, who's in that courtroom, she asked, "What's wrong? Is someone threatening you?" He says, "No, Mom, I'm not scared." But then later on he says, "I still need to protect myself." So it sounds like he actually could be the target of some type of shooting, which is what Melly actually has in that documentary at the very end, or somebody put in that documentary at the very end, that he could be a target, not a shooter. What are your thoughts about whether this is backfiring on the prosecution?
Yes and no. I think that's a bit of a, assumption, because a lot of people use that language when they talk about, the possibility, and I think this is where the prosecution may be trying to go, but, the possibility of needing to protect themselves, or, getting a gun, or some of these other, language that's commonly used when people talk about needing to protect themselves in general. So maybe, but I don't think it's really conclusive. And the thing I want to know is, why do we need, if the prosecution got this in order to establish that this is his phone, why did we need so many of these communications between him and his mom? Really didn't really show anything other than their relationship. So, I think the jury's probably sitting there wondering, okay, why are you hearing this right now?
Yeah, so let me go to Mina. Mina, say what? All right, let's say what? There was a text there that said, hey, something about Juvy's sister posting bad things on social media about the mom. Now, we know during this trial, she apparently, according to what we heard in court, threatened Jamie King, and Jamie King has to come in with bodyguards. But does that have anything to do with whether or not YNW Melly had the gun in his hand at the time? Parts of his collaborative, Juvy and Sakchaser, were shot or executed in that car?
It does not. It has nothing to do with the question at hand. Did Melly shoot these men? And I actually think these text messages are actually backfiring on the prosecution, because we're seeing the different interactions, not only with Melly and his mom, but also Melly and his girlfriend, and Melly and Sakchaser. I don't understand why they admitted so much of this. First of all, it's a waste of time, because I'm sitting there waiting for the smoking gun, right? I'm sitting there waiting for this bombshell discovery that some text message is going to reveal that points to Melly as the shooter. No, we don't have that. I actually have more questions. I have questions about why he's being threatened, because that would explain why he's walking around with a gun, right? The prosecution made sure that Mr. Javion pointed out that Melly had a satchel, and the gun could have been there, right? Well, if Melly was getting threatened prior to the shooting happened, that would explain why Melly's walking around with a gun. I want to know why his mother is so involved in his career. I'm sure her intentions are great, but she's talking about him missing shows. And I'm like, okay, well, why isn't the manager having conversations with him about that subject? Because that's part of his business. It's actually adding to my questions and not resolving the main question, which is, was Melly responsible for the death of Sak and Juvy?
You know what? With that, with so many questions there, we're going to take a break, and then I have something to discuss with you when we come back from the break, and that's something that just happened in the courtroom about whether there'll be another witness or a cross-examination today, but you'll have to hear it from me on the other side. Thank you for coming back to the Law and Crime Network. I'm Linda Kenny Bodden. Well, we're in day 14 of the YNW Melly case. Double homicide is charged, death penalty. But we were expecting to come back and hear the end of the lead detective's testimony and then the beginning of cross-examination. But there has been an unexpected development. And with me here to discuss that development is our own Terry Alston, who was in the courtroom. But first, why don't we listen, Terry, to what happened?
three of defendant's lawyers, as well as the assistant state attorney, New Jersey, and jury room. Mr. Demons.
Mr. Demons.
Okay. Outside your presence, counsel, one of your attorneys advised me that Ms. Liberty is ill, is not able to proceed. I thought he took an early lunch because she wasn't feeling well. But they told me she's not able to proceed, and she's part of the team that we could be here, the way I understand. So counsel respectfully asked me to break early today, and I asked him to go outside and talk to Ms. Liberty and find out, make sure, get an idea when she's able to proceed. After he spoke with Ms. Liberty, he thought it would be better to postpone it from Monday. Is that right, Mr. Anderson?
That is correct. And as I've indicated to the court, she's outside the courtroom, down the hall. And I would bring her in, but I don't think it would be advisable. And I told her what I was going to report to the court, and I just reported this to our client, who understands, unfortunately, the inconvenience, and I want to thank the state and the court for their patience and understanding of this issue.
That's not an issue. Coach, you can't go. Devin, do you understand? Okay. And so you're in agreement, we're just going to proceed on Monday. If there's Liberty a chance to recoup. And so counsel, as I explained also, my thought is I need to say something to the jury. I'm just going to tell them the attorney is ill. I'm not able to go. I'm concerned about tomorrow, so we're just going to see everybody back on Monday.
We're in full agreement.
Stay all right?
In terms of on Wednesday of next week.
I'm sorry, I didn't hear that.
On Wednesday of next week, I was supposed to be with Judge Fund. I don't want to delay this any longer, and I think the defense counsel in that case is moving for a continuance for scheduling issues as well.
Which case?
The one that Judge Fine and Your Honor said I would be available on the 19th to time qualify.
Excuse me, don't put me
Sorry. Judge Fine asked Your Honor to accommodate time qualifying on that case on the 19th.
So that may not go?
Correct. I just want to make sure everybody's aware.
I wasn't aware that I haven't had any discussion with Judge Fine. I was just told that he didn't leave on that day. All right, so I'm going to bring the jury in, and we're just going to tell them Monday.
Thank you.
All right?
And I thank the court for their
No problem. Detective, thank you. Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, and ladies and gentlemen, the jury. Ladies and gentlemen, we're going to have a break early today. I apologize for the inconvenience. One of the attorneys, before we took an early lunch, wasn't feeling well, and now she's indicated she just can't proceed further today. So we're going to call it for today. We're going to adjourn today. I also try to inquire whether or not they would be, is tomorrow good, and the answer I gave was probably not. So my thought is to just hold off. We won't be in session tomorrow because I'm not sure whether the attorney will be available or not tomorrow. So my thought was to see everybody back on Monday. All right? I apologize for the inconvenience. There's nothing anybody can do about it. You're sick. You're sick. All right? So just remember the admonition. Don't discuss the case. Don't form any opinion about the case. Don't allow anybody to discuss the case in your presence, and certainly no research about the case. All right? Just leave your notepads on your chair, and we'll see everybody back Monday.
As I said, Terry, I watched it just on tape. You were there live. Who got sick, did they say? And the judge, you watched the jury as the judge was telling them they'd come back Monday. Any reaction?
Well, Linda, it was really interesting. I think there's a bug going around. We heard this morning that the prosecution, Christine Bradley, was under the weather to the extent that she lost her voice. So we had Camille Smith doing some of the reading of those messages. Then we went to lunch. after lunch, we learned that it actually was Raven Liberty who was feeling nauseous and not well, and she is the reason that apparently we are adjourning this until Monday. And there's another member of the team who may have a headache. The judge was very understanding about the whole situation, as was the state. They were all in agreement that if one of the parties on either side is not able to be available, the case should be adjourned. Initially, I think the judge probably wanted it to go tomorrow, but he understood it may take some time for everyone to recuperate. You heard the judge talking to YNW Melly there. He was making sure that Melly understood if one of your attorneys cannot be here, you have a right to have them all here. It seemed as though the judge wanted him to make that decision to understand whether he goes forward with all of them or not. And Melly indicated, yes, he understood. Yes, he was in agreement. And so the judge decided to put the case off until Monday. That makes it much easier. The last thing I think anyone wants is to have the case stopped and started and stopped and started again. So we're off until Monday, and hopefully everyone will be better. Hopefully Christine Bradley will have her voice back. Hopefully no one will have a headache. And hopefully we'll see the entire defense team here and Miss Liberty feeling better.
Yeah, and Terry, I've been involved in cases myself, actually, where one member of the defense team becomes sick. I had pneumonia in one case, and the judge said, nope, the case has to go on because there are more than one attorney who are representing you. Is there something different in Florida, or is it because it's a death penalty case?
I think it's because the defense wanted the entire team. They wanted to make sure each of them has a different role. Each of them is dealing with separate witnesses, and they all want to hear everything that's going on. And that's my understanding. And the request to the state was something that I think the state understood as well. There are only two people on the state side, and I think if one of them was not able to proceed, the defense would also agree, listen, we'll wait until everyone is there. So it was an accommodation. The judge explained it to the jury and said, look, these are some things that are beyond our control. People get ill, and we want to give them all an opportunity to recover. So I think it was a discretionary decision. The only issue, as I mentioned, is I think the judge wanted to make sure Melly understood the ramifications of that decision, that he would not be able to attend trial for Thursday. Friday, the court is usually closed in any event, but now we're not going to be back on live until Monday.
And was there any mention of that dreaded COVID word, that we've become so used to in the past couple of years, where trials were adjourned in the middle of the trial because one of the attorneys or one of the jurors or somebody had COVID, or was that not even brought up?
It was not brought up, Linda, and I'm glad it wasn't brought up. We're not all wearing masks. In fact, I would say 99% of the people are not wearing masks. I did see that two of the jurors consistently they are wearing a mask, and I think it's something that they want to make sure they keep doing, but the rest of the jury is not, and that word hasn't been raised. As I mentioned, she felt nauseous, Ms. Liberty, and, I'm not really positive what that symptom could be a result of, but no one has said anything at all about COVID. And Ms. Bradley, obviously, it's her voice, I think probably because, she's been on her feet and talking for most of this time. So right now it seems as though it's just your normal cold or laryngitis or a stomach bug, perhaps. No mention of COVID at all whatsoever.
All right. So when you were watching the jury all morning for the testimony, do you have an impression, Terry, as being the great trial lawyer that you are, as to who this break may benefit, the prosecution or the defense? Because Moretti was about to finish his testimony and cross was about to begin. I think Stuart Adelson was going to do the cross. So is it your impression that the defense benefits from this or the prosecution?
Well, I think that both sides will benefit. Frankly, I do think that jury needed a break. I don't know if they needed this long of a break, but remember, Mark Moretti has been on the stand for a couple of days now, and the testimony has been fairly dry. So I think that jury wanted to either get it over with or an extended break, and right now they're getting an extended break. I think if they had to vote, they'd probably vote to get it over with so we could at least begin with the cross-examination. What the time off will do, Linda, is give the defense an opportunity to go over those transcripts, to read exactly what it was Mark Moretti did, and to come back with a surgical execution of that cross-examination cross-examination. And I think if they're able to do that, they will make some points. And frankly, the fact that the direct has been so long and so drawn out probably hurt the prosecution. So the break, as far as I'm concerned, probably helps the prosecution just a little bit more, only because the jury is getting a break from that long testimony. But it'll also help the defense, not from the jury side, but from the defense side, because they'll get more time to prepare.
And Terry, one final question before I let you go. I know you'll probably be looking forward to coming home and seeing your family for a while, but the testimony that we just heard on the text messages was a lot texting between Jamell and his mom, Jamie King. Did you see any, shall we say, looks between Jamie King and YNW Melly and his mom during the reading of those text messages? Was there any kind of interplay, interaction, or emotion shown by either one of them?
I think they're very well prepared, and they did not, in front of the jury, exchange any looks that I saw. I saw his mom listening carefully to the text messages, as was he. Some of the text messages, I think, as a mother, might be hard to hear. I mentioned this before. I think when you have a grown child and the grown child is close in age to you, you're very close and you say things to each other, and some of it might have been derogatory, some of it might have been mean, but I think the messages overall, in my opinion, Linda, really show a mother and child relationship. It shows a mother at one point who said, listen, why did you cancel that concert? It doesn't look good. Why didn't you tell me? A son who says something like, Mom, look, I have things to do. I'm busy. I can't always be calling. So while on the one hand it might look as though they're arguing, they always ended those conversations with, I love you, Mom, and she ended it with, I love you, there's nothing I wouldn't do. So yes, some of it was derogatory. Yes, he did some bad language in some of those texts, but I walked away, and I think the jury probably walked away, and the mothers on that jury probably walked away with, look, they argue, who doesn't? And at the end of the day, they're a very strong relationship.
And a very loving relationship. And that's what the jury is going to take with them home, I would imagine, Terry, just like you, until they reconvene next Monday. Terry Austin, great as usual, our eyes and ears in the courtroom. Thank you so very much, and stay healthy, and we'll see you soon.
Thank you, Linda.
And we're going to take a quick break here at the Law&Crime Network. When we come back, we'll go over some of the things that have happened in that courtroom from the lead detective who was expected to be the final witness. And my guests are still with me, Mitra Horian and Mina Saywat Lona. So they'll be going to be able to chime in also on the other side. We'll see you. Thank you so much for coming back to the Law&Crime Network. As you know, we are covering day 14 of the trial in Broward County, Florida, where rapper YNW Melly, Jamell Demons, you see him there, 24 years old now, is accused of a double homicide, killing members of his collaborative YNW Sakchaser and YNW Juvy. Well, we had some unexpected developments. As you know, the courtroom is on break until Monday because several of the attorneys are sick. But there was some fireworks in the courtroom earlier today that we have not yet discussed in full. And I'd like you to listen to a motion for a mistrial that the defense made based on some of the evidence the prosecution wanted to put before the jury, and they eventually did. But let's listen.
The mothers on that jury who may be inclined to convict just because they've heard irrelevant, unrelated conversations between Mr. Demons and his mother, where he's calling her the B word and all sorts and manner of disrespect that is clearly off-putting to any mother. And under the pretext that they're trying to prove this phone belongs and is being used by Mr. Demons, the state is offering in reams and reams, tons and tons of inadmissible evidence that is irrelevant to this case. There is a point at which they sat there for 2 hours showing 530-something photographs They introduced a jail call, and it seems like in the mission of proving that it's his phone, it's a license to put in all manner of evidence that is prejudicial and irrelevant. And we think that Mr. Demons' image, his character has been assassinated and irreparably tainted by the manner in which he is conversing with his mother, and the mothers sitting on that jury are now tainted in their impression of him and the manner in which they will render judgment. So we move for a mistrial on that ground and ask that the court put a stop to this if it is not going to grant that mistrial.
State Speaker.
We're going to do it on that's the section.
Motion to that.
All right, with me is Mina. Say what to discuss this, Mina? All right, I sat there listening to both days. This is actually my third day hosting. So these text messages. Why? Tell us a little bit why the prosecution feels they need to put in all these text messages, 500 photos, 24 videos, days of conversations. Some of them may have been with his mother to prove whether or not the gun was in the hand of Jamell Demons.
I think they're trying to characterize him. You know, these exchanges that we're seeing between him and his girlfriend Mariah and his mom and Sakchaser, he's talking to them in a certain way. And I think they're trying to kind of characterize him in front of the jury. I also think this is a very weak attempt at perhaps alluding to a motive. There's already some conversation about the mom and members of the YNW clique having some issues with the mom and maybe some drama with the mom. And we're seeing it even play out in the court. I think that's what the prosecution is trying to do here, establish maybe character and also a potential motive. But I don't think what we're seeing is strong enough to do any of that. And as I've mentioned before, I actually have a lot more questions after reading these text messages than I did before. I also don't understand why the prosecution didn't comb through this. Why didn't you edit this? Do I really need to know that Melly's going to pick up Brandon, his younger brother? Do I really need to know that his mother's asking for money for a car or this or the third? I just think some of this is superfluous, and I think it's actually hurting them because it's too much information and we just don't know what to do with it.
Yeah, I mean, in terms of hurting them, that was my thought too, because number one, and let me ask you this in the terms of the question. You know me, 1A would be the first question, right? There are the conversations where he calls her the B word. Well, why would there be a motive then to kill Juvy or Sack when he himself is calling the mother the B word? That's number A. And question B, at the very end, he says, she asked him, is anyone threatening you? And he said, no, Mom, I'm not scared. I still need to protect myself. But there's some kind of issue kind of underlying that she believes that he is being targeted. And certainly he's not being targeted by Sack and Juvy, who are in that car with him that night, if that's true what the prosecution says. What are your thoughts?
Right. That's exactly what my thoughts are as well. These are all the questions that are adding. I do agree there's a certain conversation he had with Sack. And I think even that is it's a little confusing because Melly's phone is named Young Sakchaser, right? So they're saying that's Melly's phone, but it gets confusing because he's actually talking to Sack with his phone, which says Young Sakchaser. So in that conversation, his mom comes up again, and maybe some questionable things that their mom is doing in order to get involved into the business. And even Melly says, I don't know why my mom is doing that. She's tripping. So I think that these messages are backfiring and they're actually giving us more context. There might have been a problem where the mom was involved and it was getting a little bit confusing when it comes to the business, but I'm seeing Melly being on the side of, I agree, my mother is too involved. I see Melly telling his mother, Mom, this is my business. Stay out of it. You don't have to be involved. And I also see a complicated relationship between a mother and a young son. His mom had him when she was 14 years old. So that's why you're seeing some of the, well, that's disrespectful. Well, she was a child when she had him. So there's this complicated relationship that they have that we are seeing play out via these text messages. But this complicated relationship that he has with his mother has nothing to do, from what I'm seeing, and the evidence isn't pointing to this, that has nothing to do with the murder. And unless they have something that can put that in a nice bow tie and I can see the correlation between problems with the mom and the murder, until they do that, this is just a waste of our time. And I'm sure the jury is happy to go home and because I was getting a little frustrated and a little lost in reading all of these text messages. I myself was wondering, when are we getting to the point? Let's wrap this up.
Yeah, and none of the text messages that I heard said or pointed to the fact that at the time that Sakchaser and Juvy were shot, that the gun was in YNW Melly's hand, which is this case and what it's supposed to be about. Anyhow, we're going to take a quick break here, Mina. Say what? You'll be with me on the other side. Stay with us. Back to the Law&Crime Network. I'm Linda Kenny Bodden. We're discussing the YNW Melly case, the rapper in Florida who's on trial for his life. He is charged with 2 counts of murder of his friends in the YNW collaborative, that is YNW Sakchaser and YNW Juvy, back in 2018. Well, the trial is on a break unexpectedly until Monday, as 2 of the attorneys, one from the prosecutor's office and one from the defense, have become ill. And so the judge decided the better part would be making sure that everybody is healthy and sent the jury home. But that doesn't mean we don't have a lot to talk about. And I have a great guest with me to talk about it. Mina Lona, who has been following this trial from the beginning. Mina, I just want to go back on something. The defense had argued for a mistrial that we heard, but they also argued earlier that none of these texts should come in because the foundation hadn't been laid, that it's actually the mom and it's actually Jamell Demons who is actually texting all the time. Maybe in part, maybe a little bit, but not through all the texts that they showed and all the photos that were taken. Talk to me about why the judge got it wrong when he said, well, you should have made your motion under Dahlberg before the trial. Why is it coming now? I think it's a reversible error, but talk to me.
Yeah, I'm on the same page as you and also the defense attorney. You know, it is confusing. We don't know who's talking about what, and that hasn't been laid out. And at one point, I believe the girlfriend has the mother's phone. And I think that is problematic in itself because we don't know where the conversations with the mom end and where the conversation with the girlfriend begins. I specifically remember the girlfriend saying, I'm not going to be arguing with you on your mother's phone. So there's confusion there, and it's problematic because this shouldn't be confusing, especially for the jury. It should be very clearly laid out who has this phone, whose phone is it, and who is speaking, and that hasn't been done. And I was very confused because at one point I'm like, well, why is he talking to his mom like this? And then it dawned on me, this is his girlfriend. His girlfriend has his mother's phone for whatever reason. So this is adding to the confusion of the phones. Is it Melly's phone? Is it Sak's phone? Is it his mother talking? Is it his girlfriend talking? And I could see why the defense would want to move for a mistrial because, as you and I spoke off camera, it is getting a little sloppy when it comes to the presentation of these text messages and the amount of text messages that we're reading.
Yeah, and one of the other things, Mina, that I want to get your impression on is right now, Jamell Demons, I mean, he's looking very serious in the courtroom, right? And because it is a death penalty case, and we have about a minute. But do you think that he feels that his defense is doing a good job for him? Do you think the defense feels that they're winning at this point, or what? And you have about 30 seconds.
I would conjure that probably he's up and down every day, depending on what happens that day. I thought that the ballistics and car medical examiner report was damning to his defense. But now when I'm reading the text messages, it actually humanizes Melly a little bit because we're seeing how much he loves his mother and him talking to Sak and saying, we're going to blow, we're going to do this. So I think it's situational and day to day.
All right. You are going to stay with me on the other side of the break. Mina, say what? Because I also want to go through clips, and I want to discuss the relationship between Cortlen Henry, the other co-defendant in this case, who's being tried later, and how that may affect what we've heard. Anyhow, on the other side, Law and Crime, YNW Melly, stay with us. Thank you for coming back to the Law and Crime Network. I'm Linda Kenny Bodden. We are discussing day 14 of the trial of YNW Melly, Jamell Demons, 24 years old, who is accused of killing two members of the YNW collaborative. That is his friends, YNW Juvy, YNW Sakchaser, back in 2018. Well, there was an unexpected development in court today when two of the attorneys became sick and the judge had to adjourn the trial until Monday. But so much happened in that courtroom this morning that I want to play a little bit of it. And one of the things that was played was by the prosecution, a documentary done allegedly by a team behind YNW Melly that may have had an ending that had some words that the prosecution is trying to attribute to him as being some type of a statement against interest. So why don't we go listen to the documentary and we'll talk about it on the other side.
Will publish this video?
Yes, ma'am.
At this time, you're on the statement of offer, states Triple X, states 98.
Any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple X will be marked states 98.
And permission to publish, Your Honor?
You may.
Other online investigations and other people that you looked at. Did you solely focus your homicide investigation on this defendant?
No, ma'am.
So let's talk a little bit about an individual by the name of Robert Colburn. Who was Robert Colburn?
Mr. Colburn was a young 15-year-old kid. He posted something stupid on social media.
Objection to the word stupid. He doesn't know what it is. I'm sorry.
One or two words. No speaking.
Objection, hearsay.
Thank you. Sustained.
So in terms of the post on social media by Mr. Colburn, did you view it?
Yes, ma'am.
And did he have a specific Instagram handle or name that he was using?
Yes.
And what was that?
Could I refer to my notes?
If you need to refresh your recollection, please do. Okay, and so what was the Instagram name of Mr. Colburn at that time?
It was Brackwoods, BRACKWOODZ.
And at some point, did you speak with Mr. Colburn?
Yes.
And in terms of when you interviewed him, how long after the homicide was that?
It was a day or two after the homicide that, I think it was actually that day, that evening, he made an inappropriate comment online.
Objection.
Okay. And when you say...
She made a comment online. Sustained.
So without going into what was said on that, did you find or locate any location data that placed Mr. Colburn in Miramar on October 26th of 2018?
No.
Did you find any casings that matched the homicide scene in Mr. Colburn's vehicle?
No, ma'am.
Did you find anything else other than the online posting, which we can't get into the content of, that Mr. Colburn did that would show he was involved in this homicide?
Absolutely not.
What about an individual by the name of Montrell Roll? Did that name come up during the course of your investigation?
Yes, ma'am.
And with regards to Mr. Roll, did you make contact with him?
I made contact with his sister.
And from April of 2018 to the present, where does Mr. Roll reside?
Indian River County Jail.
And in terms of October 26th of 2018, where was Mr. Roll residing?
Indian River County Jail.
Ever been out on bond to your knowledge?
Nope.
So, did you find any location information of Mr. Roll at the scene of the crime?
No, ma'am.
Were you able to verify his alibi?
Yes, ma'am.
I want to talk a little bit about Crucial Almighty, an individual on Twitter. Was that a name that you looked into?
Yes, ma'am.
Who was Crucial Almighty?
He was a gentleman from Fort Pierce, David Hedgepeth. He, shortly after the homicide, he placed pictures online, made references. So we eventually interviewed him. And our assumption of him was correct. He was trying to...
Objection. Let's not speculate on that.
Okay.
So, Detective Murray, with regards to Mr. Almighty, did you review some online songs and postings that he made back in 2018?
Yes, ma'am.
And in terms of, because we can't get into the contents of them, did you follow up as to where Mr. Hedgepeth was on October 26th of 2018?
Yes, ma'am.
And what did you do to follow up on that?
We subpoenaed work records.
And where was he working then?
He was working on...
Objection. Hearsay.
Maybe approach?
True.
Well, the detective already there trying to get in things that are being objected to over and over. But let me bring my guest in to discuss this. Ron Zambrano, great trial attorney, has joined Mina Sewat-Lona and I to talk about this case. Now, I want to specifically go to you, Ron, first about this video. The end of the video says, let me read it to you. 4 days after the completion of this film, YNW Melly and his friends were the targets of a drive-by shooting. Now, this caused a lot of questions in our question and answer today, because the prosecution is saying that because that is said at the end of this video by his team, is putting Melly in the car, as opposed to he could be a target and left the car. What are your thoughts?
I believe it's an easy distinction to make between whoever produced the video or the poor editor who put that copy on the end of that video not being an attorney, or the prosecution, or having an eye of how this will be viewed or skewed or spun later. It's an innocent, it's not even a mistake, but it's something that it's just a throwaway comment, and they're trying to make a mountain out of a molehill.
Yeah, and Mina Sewat-Lona, Mina, the detective said this piqued his interest. Well, of course it piqued his interest. He's a detective, and that's the defense point, right? That they targeted YNW Melly. But let's talk about the issue that you mentioned before the break, and that is the forensic reconstruction and the autopsy placing the shooter inside the car. Now, the only statement we have here is from Cortlen Henry, a co-defendant here. Why isn't he the shooter? Why didn't the prosecutor target him as opposed to YNW Melly?
I think we all have that question. I think the prosecution has made it clear that in their opinion, based off the evidence and the ballistic reports and the reconstruction, they believe that it was Melly who committed the kill shots, the 2 kill shots, and murdered his friends. So maybe that's why they didn't pursue Cortlen with the same, I guess, rigor. But I think it was actually a mistake, because Cortlen is very much involved in this murder. And he was not only a driver, but he was in the car. And he has not been treated the same as Melly. Melly immediately went to jail. There was no bail Cortlen was out on bail and had an ankle monitor. So I think it might have been a mistake for them to automatically say, well, we have the forensics report. Let's just focus on Melly, because say this trial doesn't end up convicting Melly. Now, what do? You have to kind of piece it back together and then figure out, well, how does Cortlen fit into this investigation? Had he have done it? And if you haven't crossed all your T's and dotted all your I's and did the investigation in a non-biased way, you might not have the evidence that points to Cortlen. Before we dismissed, we were getting into the fitness app steps, that Melly took on that night. And I distinctly remember thinking, well, did you get the fitness app steps for Cortland? Because you still have not put Melly and, with the gun in that car. So if you're trying to say he was pacing and there's all these extra steps, well, did you do the same for Cortland? Because at this point, they've proved very successfully that the murder happened within the car. And now we're wondering who committed the murder.
Yeah, you know what? But I'm going to disagree with you on that. I'm not quite sure about that, looking at the forensics. One of our viewers brought up an interesting point. The windows were open. And, shootings, Ron Zambrano, are not necessarily static. You're not necessarily just sitting there, one shot, right? People are looking around. If there's a car coming up fast and everyone thinks there's targets, you could have somebody looking this way. I'm going to look this way. And the bullet comes that way into the head, right? Close by. I mean, we had, in the Hernandez case, we had close shooting with a car drive-by, and we still had some gunshot residue. So I'm not sure the forensics says what the prosecution says they do. Do you expect the defense to go there with their own expert?
They should, because I think it's very, just like you put in these last 30 seconds, how there are alternate possibilities of what the evidence shows. And that's what lawyers do, right? We all agree what the report says, but we disagree what it means. And I think you're spot on going, listen, things are not static. There's a lot, one would think that there is a lot of motion, that no one has that much of a cool head not to move around. And I think it would be a mistake not to bring their alternative expert witness to testify on that point.
Yeah, as we know, evidence sometimes goes both ways. The documentary the prosecution thought would help them, and many of our viewers at lunchtime thought the documentary actually put in memoriam a wonderful picture of the relationship of YNW Melly with Juvy and Sakchaser, not a hateful relationship. Anyhow, we have so much to discuss, but we'll do so on the other side. Stay with us. Welcome back to the Law and Crime Network. I'm Linda Kenny Bodden, and we are hot in our discussion and replays of the YNW Melly trial. And why? Because two of the jurors were dismissed, the jurors were dismissed this morning because two of the jurors are probably more important, but the case can't go on without lawyers. They got sick, okay? And the judge said, rather than making sure or bringing them back and then having them sick tomorrow, and maybe getting other people sick, we're going to let the jurors go home until Monday and we'll all be back. But that gives us a chance, and for the jurors probably to think about themselves in their head that they can't discuss it, but we can discuss it and we can go over other trial testimony. And some of the trial testimony we're going to go over happened in the courtroom this week. That is of Travion Glass. Now, who is he? He was one of the people that got into the red Mitsubishi that left the recording studio those early morning hours when Sakchaser and Juvy were killed, the prosecution says, by YNW Melly. Why don't we go into court and listen to what he had to say? And let me tell you, he didn't really want to be there. So let's listen.
So let's go back to October 26th of 2018. What were you doing for work?
I wasn't working at all.
All right. Were you involved in the music business at all?
Kind of, sort of.
And how so?
Making beats.
All right. And when you were making beats, were you working with a specific group or music group or people?
One person to be particular, but yeah, supposed to be in a group.
All right. Let's start by saying this. What group was it?
YNW.
All right. And when you said one person specifically, who was that person?
Julie.
Okay. And can you tell the members of Judy's real name?
Christopher Thomas.
And how long had you known Christopher Thomas, who you refer to as Judy?
Over a decade.
Okay. And this is back in October. And did you know somebody by the name of Anthony Williams who went by Sakchaser?
Yeah.
And how long had you known Sakchaser?
A couple years.
Back on October 26, 2018, do you recall being at the New Era studio?
Yeah.
Who were you there with?
You other people.
Okay. Was Juvy and Sack there?
Correct.
All right. And do you recall around what time you guys got to the studio?
I'm not sure when we arrived.
Okay. Was it light or dark outside?
I believe it was dark. I'm not sure.
All right. And what was the intention going to the studio?
I believe we were supposed to have a 12-hour session.
All right. And that's a 12-hour recording session, right?
Yeah.
And who was the artist that was recording that night?
Really, everybody was an artist. And
All right. Did you guys end up staying for 12 hours?
nah,
Okay. What changed and why didn't you end up staying?
to the best of my knowledge, people were sleeping, so we ended up going home because, sleep in the studio.
All right. And part of that is because studio time is obviously, it's costly, right?
Objection to leave.
Stay.
Okay. You just said it was paid for. What was paid for?
Studio time.
All right. So you guys had prepaid for 12 hours.
Correct.
And obviously not utilizing that 12 hours, is that a waste?
Objection, Your Honor.
Stay.
Deleting.
I'll move on. How long, well, you said that people were sleeping. Who was sleeping?
Everybody but me, Anthony, and Chris.
All right. So who was upset that people were sleeping?
Objection, leading.
Who was upset overall?
There was no testimony that anybody was upset.
Okay, rephrase your question.
Was someone upset that people were sleeping?
I guess you could say that, yeah.
And who was that person?
Sad.
Okay. And how did Zach respond? How did Zach respond to people sleeping?
You woke him up and let him know it's time to go.
All right. And how did he do that?
Yeah, you went and woke him up, shook him up.
All right. Was there an occasion where he threw water on some people to wake them up?
Objection, Your Honor.
Stay.
And who's that person?
The best of my knowledge, Melly.
Okay. And the person I'm referring to, what is he wearing?
A jacket.
All right. Do you recognize the person on the other side of the photograph wearing what appears to be a black shirt?
Kind of, sort of.
If you do.
No, I don't.
Okay. Publishing image number 2. Do you recognize the individuals in that photograph?
3 of them, yeah.
Okay, so what you can do is identify them by the clothing that they're wearing.
Juvy, black jacket in the left, Sack in the middle, jean jacket, Tay, black jacket.
And Sack is he standing or sitting?
Sitting.
And Tay, is he standing or sitting?
Sitting.
And you said Cortlen was wearing the black jacket. Is he standing or sitting?
Who?
Oh, how did you refer to him? My apologies.
Tay.
No.
Or Juvy?
The person wearing the black jacket, who did you identify that as?
Juvy wearing the black jacket. Also, is Tay wearing the black jacket?
The person wearing the black jacket who's standing up, do you recognize that individual?
Chris.
Okay. Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
Right? So you go upstairs in Juvy's room, and what do you do?
Crash.
All right? Crash meaning?
Go to sleep.
Okay. At some point, do you wake up?
Yeah.
And why? Or how?
Phone calls.
Okay. Safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right. And at some point you answered the phone, correct?
Yeah.
Okay. What do you do in response to the phone calls?
I answered the one that kept ringing, and yeah.
All right. And so what do you do in response to getting that phone call?
I ended up at the hospital.
All right. Do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was in Broward.
All right. What city? Not the county.
Miramar.
Okay. Do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay. So you get to the hospital. What do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Obviously, at that let me not say obviously, but at that point in time, what do you do, or how do you react to that news?
Grieving.
Okay. Do you stay at the hospital?
Not long.
Right. Where do you go after the hospital?
I ended up somewhere, somebody's house.
All right. Do you recall whose house that was?
I don't know whose house it was, but I ended up there.
Okay. And what were you doing at the house?
Still grieving.
Okay. Who took you to the hospital?
The cameraman.
Okay. Do you recall his name?
Drew.
Right. And do you recall who took you from the hospital to Freedom's house?
Same person.
All right. And before you left for the hospital, or actually, who went to the hospital with you?
Just Drew.
Okay. Who was at the house, Melly's house, before you left for the hospital?
Same people that was there when we got there.
Okay. And same people being the 4 people that entered the Mitsubishi?
Yes.
Okay. So you're at Frito's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were?
Juvy's room.
No, not Melly's house. Frito's house. Where were you in Frito's house?
Outside.
Okay. And who was at Frito's house when you first got there?
Everybody that was in the house.
Okay. And it's because I don't know who everybody was or is, can you please specify?
Kobe, Melly. I'm on people I can remember.
Okay. Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new day. Nah, he wasn't.
Nah, he wasn't. You guys
wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
Mina and Ron are still with me. Mina, let me go to you first. All right, so let me just say to our viewers, the reason why he's behind the Dell screen there is because he can't see well out of his left eye, so the screen was put up close so he could look at the photographs, and later it was taken down. It wasn't the Dell screen that was testifying. But Mina, we just saw a picture that happened that was posted 3 years afterwards that had a broken heart emoji on it, which said 3 years ago today, as you see it, and a very sad face. Is the prosecution really trying to just say that YNW Melly is a rapper, a member of the gang, and therefore we're blooding him up, and of course he has to be the killer?
Yeah, I think that's the leap that they want us to take, right? By characterizing him, well, he's a bad guy. He has guns, he talks to his mom a certain way. He's in a gang. All of that could be true, but that doesn't mean he committed this murder. And the more that we're hearing from the different people involved, we're learning the other side of Melly, which is he has a great love for his mom. And they constantly say that. And he's protective of the people around him. And he's almost like a lifeline, right? A lot of people need him for things. I need you to open up the door for my house. I need this money for this. I need this. I need that. I need you to do this. So he's we're learning more about him. And I'm having more doubts as we learn more about him. In particular, this witness, I think that he identified that Melly, so the question was, did you see Melly with a gun? And Travion Glass said, I don't recall. So I found myself going back to this particular witness and pointing out different things. Him saying he doesn't recall Melly having a gun when he was at Frito Bang's house. I do think it was important that he identify who was in the car and where, because I actually created like a little map. Okay, this person went in here, this person went in there, and it helped us really see where everyone got into the car. And I also saw, I don't know if you noticed this from his testimony, that's it right there. I saw that Melly not only had that bag, but Juvy also had a bag as well. And he got into the back of the car. So his testimony was very crucial, and it helped me learn more about what happened on that night, but not enough to say for certain who committed the murder.
Okay, let me give you a quick question because I know I have to sign you off. But if Juvy has a bag and Melly has a bag, you can't assume then the gun was just in Melly's bag. You can't assume what was in the bags, can you?
Well, I think that the prosecution wanted to throw the bag in there, right? And this goes to the circumstantial evidence that we talk about, right? People are going to be like, oh, he has a bag. Well, what's in the bag? Yeah, but you were also preparing to be in a 12-hour studio session. Linda, I don't know if you've ever been in a 12-hour studio session, but you need food, you need drink, you need a lot to sustain and be creative for 12 hours. Not only that, but they also admitted that they were smoking weed, I believe, in the studio session. And there's 8 people? Yeah. So if there's 8 people smoking weed in the studio session for 12 hours, I would imagine you can't walk around with that in your hand. You got to get a bag.
Yeah, in fact, I've been in a 12-hour poker session recently, and I carry a knapsack that has everything. So I know. I have to let you go. I have to let you go.
We don't know what's in the bag. It could be anything.
You're a great juror, but I know I have to let you go, and I hope you'll come back. And Ron and I are going to continue this discussion. Trevion, Ron was one of my most favorite witnesses so far in this case. Now, we're going to get to the point about what was he wearing. I don't want to know what he was wearing when he got back to a house somewhere time later, because the police don't have any clothes. So what difference does it make what he was wearing if he, for instance, had gym shorts on? I mean, when I leave here and I go home, I'm going to change immediately. Does that mean I committed a homicide?
No, it wouldn't. And again, this is something that they're trying to make leaps, right? They're trying to make these huge leaps, these inferences that they're asking the jury to make. Oh, his clothes changed because he was trying to hide something, but there's no evidence of what it was or what it was to. Really they're trying to connect very, very dots that are very, very far across, without any real reason for us to take that leap of faith. And it's very, very dangerous that he's a rapper, he's a gangster, and he changed his clothes after this crime was committed by somebody. So why would anyone change their clothes? He did, so he must have done it. I mean, it's too many leaps. It's really a lot. It's it's not very strong, to be honest.
And speaking about the prosecution, when Trevion Glass testified, he said he was there. He was scared not to testify because he got arrested for obstruction of avoiding a service of a subpoena on May 30th. So he felt he had to come, but he wasn't happy to be there. It kind of went with the theme of the mother of YNW Melly's girlfriend, who said she felt threatened by the prosecution. So if there's anything bad that comes out against Melly, does the jury say, I'm just going to discard it because it's the prosecution being heavy-handed?
I think so, and I think when people that don't want to be there end up testifying, there's this instinct of like, well, what they're saying must be true because they don't want to be here in the first place, and you distrust people that are there. They're just talkative and chatty. So I agree with you. I think it may have backfired because he clearly doesn't want to be there. He's in his own way doesn't want to say a lot, but I think when he does say something, the jury's paying attention.
Yeah, very, very interesting witness. But Ron, you're going to stay with me because we have a lot more to discuss. But first, we have to take a quick break. When we come back, more on the YNW Melly case. Stay with us. Welcome back to the Law and Crime Network. I'm Linda Kenny Bodden. We are discussing day 14 and prior of the YNW Melly case. He's accused Jamell Demons, 24 years old now, of killing two friends in his YNW collaborative, that is Juvy and Sakchaser, back in 2018. And I say we're discussing day 14 and prior because earlier today, two of the attorneys became ill, and the judge decided to send the jury home until when? Monday, to ensure that everyone remained free of being sick and that all people can do their best when they come back to court on Monday. But some say that the medical examiner testimony in this case is some of the most important testimony for the prosecution in proving their case against YNW Melly. So why don't we go into court and listen to some prior testimony of the medical examiners.
So this is gunshot wound C, which was on the back of the right shoulder. Okay, the abrasion collar around that wound is not hemorrhagic. What that tells me is that there is no circulation to that part of the body when that gunshot wound is inflicted. If you think about, an abrasion is a blunt force injury, okay, from an object. It's a friction injury. If you think about riding your bike as a child, falling off your bike, skidding your knee, right? That will quickly turn red and bleed because you've taken off that top layer of skin.
Based on your autopsy, did you come to an opinion as to the cause and manner of death for Anthony Williams?
I did.
And what was that?
The cause of death is multiple gunshot wounds, and the manner of death is homicide.
Going forward, were you also involved briefly with the case number 18-3119?
I was.
And what was your involvement in that in March of 2022?
In March
yes.
of 2022? So prior to March 8th of 2022, it was brought to my attention that there was a gunshot wound on the lower extremity that we, Dr. Zotter and I, labeled as a penetrating gunshot wound. We labeled it as a ballistic injury, okay? Because we had a wound on the outside of the leg. There was no projectile in the leg, and there were just two little ditzels on the full body X-ray. So it was most consistent with a projectile usually hitting something else and then just coming up against the skin to make a rivet in it, but not a projectile that goes through the leg.
Did you recover an additional projectile from the body of Anthony Williams?
I did.
And where was that located at?
In the right scapula, or the bone, your shoulder blade, the wing of your back.
And in this next photo that we're looking at here, which is number 19, this number, is that where you retrieved that particular projectile?
That's correct. So to orient you,
sorry,
this is the neck, the back of the neck, the midline of the back. Okay, the entrance wound is right here, and it goes and it gets stopped by all that bone. And if you look at the muscles here, there's no hemorrhage either.
And so going on to this photo here, which is number 23, what are we looking at in that particular photo?
So that is a projectile that I recovered from the right side of the back.
Can I have a moment to consult?
Yes.
And so, Dr. McDougall, just clear, we talked about B and D. Was the victim, Anthony Williams, dead when the B and D was inflicted to the body?
So when gunshot wound B was inflicted, yes, he was dead. And it exited D, so it's one gunshot wound.
Correct. So when wound C was inflicted, was Anthony Williams dead?
Yes.
What is that?
That is the exit wound on the foot, and Yeah, the exit wound.
And that matches or coincides with the same wound track as in wound D?
Yes.
On to wound F. What does that show?
F is an exit wound.
And how can you tell that F is an exit wound?
Because of the laceration.
And what is a laceration?
It is a cut.
Moving on to G. What wound does this depict?
G shows the entrance wound of the right arm.
In terms of G, is there any hemorrhage associated with this wound?
No.
What does that tell you as a forensic pathologist when you're looking at wound G?
That the heart was not beating at the time that this wound was inflicted.
If you could explain what this is?
This is showing the brain and the extensive subarachnoid hemorrhage it has, and the lacerations that you can see to the right side of the cerebellum, which controls your balance, and also to the pons and the medulla and the midbrain.
So in terms of where we're looking right now, can you give me an orientation? Is this top, bottom?
This is the bottom side of the brain.
Okay. And for the head that you have in front of you, the styrofoam, could you show where on that how that would be oriented and put in the same position?
So.
And in terms of, is there evidence of hemorrhage along this wound track?
Yes.
Would you have an opinion as to if the individual was alive or the heart was beating when this wound was inflicted?
Yes.
And what would that be?
Can you say that again? I'm sorry.
What would your opinion be?
So, my opinion is that at the time that this gunshot wound was inflicted, because of all the hemorrhage to the base of the brain, that this individual was alive.
Okay. Going on to projectile number 7. Where was this projectile recovered from?
On the right occipital bone.
Same from the picture we just looked at?
Correct.
All right, this is some incredible, important testimony to break down, but I can't do it right now. I have to take a break, so you're going to have to wait on the other side when I'll be joined by my guest, Ron Zambrano, and also a surprise guest for you. Stay tuned. You'll have to figure out who it is when we come back. For coming back to the Law&Crime Network. I'm Linda Kenny Bodden. Well, I have my guest with me, Ron Zambrano, as you know, as we discuss the YNW Melly trial. And I'm also joined with the host of Defense Diaries podcast, Bob Mata. Welcome, Bob. And Ron, thank you very much for staying. Let me go right to you first, though, Ron, since you've been with me for the last hour. The medical examiner testimony was that one of the bullets that she was talking about, the brain, obviously, just a terrible situation, obviously, from one of the victims. He was alive because of all the bleeding, but then she said that another wound indicated that he had been deceased. But I'm not sure how you tell deceased when supposedly the drive-by occurs, soon thereafter to set up a motive for the alleged hit by Melly against Sakchaser and Juvy, according to the prosecution. Can you break that down for me?
Not easily, because it doesn't make sense for the theory that the prosecution's saying, right? What the prosecution saying is like this was premeditated and there was a plan and things are going to happen at the same time and they're going to set it all up. All it does is create more questions, I think, that the prosecution has to explain because it's their burden that I don't think they have good answers to. The jury's going to hear this and say, well, someone shot this guy afterwards. Who was it? And I don't think the jury's convinced that it was anybody that the prosecution's saying it was.
Yeah, and Bob Mata, as you all know, my husband is a forensic pathologist, and I would certainly hire one if I were the defense in this case to say, well, don't you have to take some slides around the wound area to see if there was some bleeding? How can you tell this was, ante-mortem bleeding or peri-mortem bleeding or post-mortem bleeding unless you actually look under the microscope to see whether there was some blood activity, if indeed all the blood was being pumped out of the heart and not to the rest of the body? What are your thoughts? Because I know you handled a lot of forensic cases.
Yeah, no, and I agree. And ultimately, what it boils down to is, does the jury get it? It's one thing to put an ME up there or a forensic pathologist up there and have them kind of pontificate about what their findings are. And if you've got a jury that's just sitting there with a glazed over look in their eyes, and you're looking at them as the attorney while you're doing a direct or a cross either way, and you see that it's just not hitting home, it really doesn't do much anyway, and with her testimony, I understood what she was saying only by way of, like you said, I've tried a lot of cases with forensics in it, especially from ME sides and forensic pathologists. And, I see what she's saying, but I don't know that it's going to strike the chord that they're hoping that it will with the jury. And obviously it's always been their theory that, that the drive-by aspect of it was a sham, that he was, that both of them were killed by Melly in the car. And then in order to make it look like it wasn't them, they staged the drive-by. So I don't know if it struck like they wanted it to, just because of the ability for the jury to be able to understand what they're talking about.
Now, Bob, you're going to be staying on with Michael Bryan, so I want to direct the last question to you, Ron Zambrano. We have about 30 seconds. Has the prosecution put the gun, no matter what the situation, in YNW Melly, Jamell Demons' hands?
I don't think so. This is so circumstantial. They're asking the jury to make so many leaps of faith, so many assumptions of fact, to agree with all the inferences. I just don't think so. These poor gentlemen were killed, and from what we've seen, the Nelly liked them, and they looked up to him, and I don't think they anticipated that coming through in the trial.
Yeah, it does appear that. So, Bob Mott, as I said, you're staying on. Michael Bryan will be taking over the seat. You're all in good hands. Ron Zambrano, I want to thank you very much for staying with me. This is the Law&Crime Network. We'll continue our coverage of YNW Melly trial, and I will see you next Monday.
And welcome to the Law&Crime Network. I'm Michael Bryan. Good to have you along here midweek. If you've been watching the Melly trial, which of course is the trial in which Mr. Jamell Demons is accused of killing a couple of his rap buddies there in Fort Lauderdale, Florida. You've probably seen a little banner on the bottom says, hey, Florida versus Demons will be back Monday. And you're thinking, come on, that was from last week. They forgot to change the banner. No. It's an interesting series of events taking place down there in the courtroom and in the courthouse, and most of it having nothing to do with the testimony or the evidence in the trial. So let me bring up to speed on where we are, and then we're going to check with somebody who really knows the details. Basically, one of the defense attorneys got ill. There's at least 3 on the team that I can tell from seeing the trial unfold. So that left 2, but the judge decided 2 just wasn't enough, and so they called it for the day and for tomorrow. And Friday's always dark. So that little banner you saw, our crack production staff and producers got that right. They will be resuming on Monday. So I just wish we had somebody in the courtroom that could tell us how that all unfolded, what the vibe was like. Oh, we do. Terry Austin is down there, and now she's going to join us live as we talk about these developments, again, that have very little to do with the merits of the case, but interesting nonetheless. And I might have an opinion or two about the decision not to go forward when only 2 of the attorneys are left, but I'll save that for the moment. Terry, what happened down there? What was the reaction?
Well, Michael, as you might tell, around me, it's very quiet. It's usually a little bit noisy, and that's because this courtroom has emptied out for the day. We started out this morning with a motion by the defense to keep out some messages that were talking about a gun, and the judge decided, yes, you're right, keep that out, it's not relevant. And then we had Mark Moretti back on the stand, and he testified for a while. And then we had a lunch break. And after the lunch break, we found out that Raven Liberty, you're right, there are 3 attorneys for the defense. We have David Howard, Stuart Adelson, and Raven Liberty. And she apparently was not feeling well. And the judge decided because of that, that we would not just adjourn for the day, but we would adjourn until Monday. He made sure that Melly understand the ramification of having your trial adjourned until Monday, meaning that no one's going to be in court. You're going to have to go back to your cell for a while. We're not going to be in this courtroom. And he said, yes, I understand. But I think part of the reason the judge made that decision is because the team expressed a need to have everyone in that courtroom. They've split up what they're doing in terms of which witnesses they are doing the cross on. And I think they just want all 3 of them there for the duration of the trial. So nothing today, nothing tomorrow, because as you said, it's dark on Fridays, and we will resume back on Monday.
Okay, so, we were waiting so long after the whatever that week was last week for the trial to get back, and now this quick stutter. What concerns me most, Terry, and give me your take on this, having seen their faces and their body language, this is not good for the jury. They don't like this. They're the most important audience. I would love to have had a judge who at some point said, oh, one of your team is ill, why don't you take some time off? No, I can't remember having a judge that would have done that. The judge would have said, your client is adequately represented. You got 2 out of 3 people here. I better hear something more than, and I'm sorry she's ill and I hope she feels better. But we're moving forward because this jury is being inconvenienced. Did you get a sense they felt like this is a pain?
I think what the judge was thinking about, Michael, is more holistically, because if you recall, we had some testimony this morning of Mark Moretti, and you did not see the prosecutor, Christine Bradley, up there doing the direct examination of Mark Moretti. You saw Camille Smith, who is the other prosecutor, and that was because Christine Bradley was losing her voice. So I think he took that into account. She's been working all of these weeks and up on her feet and talking. And then, there was some talk about someone else on one of the teams having a headache. So I think in totality, he thought, look, I'm going to give both teams a rest. I'll give this jury a rest. There was some rumor, and it has not been confirmed, that someone on the jury might have been exhausted. So I think the judge was taking into consideration the entire situation, and he was giving us all a break. It has been exhausting watching this testimony, reading these Instagram messages into the record, listening to all of the phone cell dialogue and the messaging between the different phones. So I think the judge was ready to give everyone not only a break to recover, but a break to rest as well from all of the grueling testimony that we've been hearing.
All right. Well, you're certainly more accommodating than I am, and I appreciate that. Give me your take on this. When I would try a case, a surprise a day was kind of my motto, a surprise a day. This case seems to be, hey, mistrial motion a day. So what's the latest on that front?
Well, it's true. There is something going on every day. The mistrial was because the messages being read back and forth between Detective Moretti, now remember, he's the lead detective, and Camille Smith, they were playing roles. The detective was basically reading everything from the 9807 or 9806, not looking at my notes, but that's the phone that's supposed to be attributed to YNW Melly and his mom. And so they were reading messages back and forth, and a lot of those messages had to do with minor disputes between the 2 of them, and some of them were inflammatory. And what the defense argued this morning or this afternoon was, look, some of these messages are derogatory. I think the prosecution is putting these messages in not to establish ownership of the phone, because that's been done by the prosecution through other messages and through other, witnesses that have gone on the stand. But the fact that they were putting it in to inflame that jury, for that jury to see messages where he might not be saying really positive or respectful things to his mother. And so he made a motion for a mistrial. This was David Howard. He made a motion for a mistrial, and the judge listened to his argument. The state really had nothing in response. I think the state probably knew how the judge was going to rule on it. The judge had already allowed the messages in, so for a motion for a mistrial to be made, I think you can anticipate if the judge is letting it in, he's not going to rule for a mistrial. He immediately said, motion, you're not going to win this motion, denied, and so the trial went on.
Yeah. So it seems to me you're just adding that to the list of potential appellate issues if there is a conviction in this case. I'm thinking it over and I'm thinking, A, what's the relevance of even any sort of back and forth with his mom if you're really already acknowledging the phone was connected somehow to the defendant Melly? What's the point of reading the text messages that have nothing to do with that night, or who was shooting, or who was being shot, or what the drive-by, if it happened, was all like? How did the judge, if at all, rationalize that?
Well, the judge actually did say, look, I've let all of these messages in because you're trying to establish the phone ownership, but he did disallow messages about a gun. He said that's taking it a step too far. I think he's being very lenient with the prosecution, allowing this ongoing and never-ending reading of these messages just to establish the phone ownership. And so he did draw the line, and I think he has been drawing the line at anything that he thinks is completely irrelevant. The talk about the gun in these messages was subsequent to the incident, totally irrelevant, and he thought it was inflammatory, and he said it's not coming in. He has also left out other issues, particularly as it relates to, the gun or other violence or words in a video, because he's focusing on what he thinks is relevant. But he's let in a lot of messages as well, and I think he wants to give the prosecution a chance to put on their case without stifling them in any way, shape, or form. So I actually see Judge Murphy as making sure he is looking at both sides of this situation, making sure that evidence is getting in that should get in, but excluding that evidence that he thinks is more prejudicial than probative.
Yeah, not an easy job. It's easy for me to say, hey, you should have done this, should have done that. He's the guy sitting there with the robe on. He's doing the weighing. I'm pretty sure I won't be wearing a black robe anytime soon. But my gut feeling is, the jury. What does the jury really need to come to an ultimate decision? And I guess they're going to get to think about that for the next few days. So thank you, Terry, for checking in. Are you coming home? Are you going to go hang out at the beach for a while? What's the plan?
Well, I did ask someone back at home office to check in flights for tonight, so it's still undetermined. But my plan is to try to come back to New York.
All right, you can rest up then, because I guarantee you'll be back there when they get back to it next week. Am I right?
Right, that's
okay.
right. I'll be back Monday morning, first thing.
Very good. Always appreciate the stuff, Terry. Really have a safe trip, and we'll see you next time. Thanks again.
Thanks, Michael.
You bet.
Thanks.
Okay, let's take a break. And we'll bring up to speed on, the Melly case has been underway for the last 2.5 days, and there's some interesting stuff happening, so we'll get into that when we come right back. Stay where you are. Back to Law and Crime, continuing our coverage of the Melly murder trial down in Florida. This is a death penalty case. Today, court taking an unexpected turn. A couple of the lawyers feeling sick. One of them so much so that she just said, I can't continue. So we wish her well. Hopefully she'll be back at it soon. But the judge said, let's just take a break. So we're not going to come back tomorrow, which would normally be their last day of the week, and they're off on Fridays normally. So we'll see you on Monday, everybody in the jury. So what we're doing is recapping a little bit of what happened today. A lot of discussion taking place outside the presence of the jury. Watch this.
Yes, Judge.
You're ready to go?
Yeah, I'm going to check on them. I know a couple of them were using the restroom.
Maybe we have a few things to discuss first. Good morning.
All right, let's get on the record, please. In the state of Florida versus Demons, president and defendant, his counsel, and assistant state attorneys. Jury's in the jury. Yes, sir.
With respect to, there is, did you label it? Not quite sure what label is reflected in the record. State's proposed exhibit. But it is what appears to be a 121-page document reflecting extractions from the 9807 phone that are purportedly the discussions between that phone and Jamie King. We have already interposed our objection with respect to laying an adequate foundation for the introduction of this or any such exchange of text communications. We think that the state has not laid the adequate foundation. However, we also want to renew our objection to the fact that of this 121-page document, I think the state intends to assert relevancy as to a few of the pages, which renders all the other pages irrelevant and therefore inadmissible. There are instances in which the state has indicated that they believe their exchanges which provide context for that which they want to refer to, which is fine. That would make them relevant for context. But everything else coming in for the jury to just peruse through 120 pages of an exchange between the 9807 number and Jamie King is irrelevant, it's prejudicial, it's inadmissible. Beyond that, at page 52 of the exhibit, the court yesterday had indicated that the state should get rid of the reference to what purports to be a request from the 9807 number of Ms. King that said previously, get me a Glock.
That was after the murder in question, my recollection of it.
That is correct.
Do you want to show the judge so he can see in context?
Yes, I'll hand it up in a second.
Here, we can put it on the screen. So they can.
So that.
Aaron, if you recall, there was, after this, it included trips that Ms. King made to a gun store to purchase firearms. She sent pictures of various firearms to the defendant. Aaron, I remind you, he was 19 years old at the time and an adjudicated delinquent for a firearms-related offense, so he was not allowed to possess any weapons.
Okay. That being neither here nor there. With respect to the argument that we're making now and the objection we're making, if the court sees right above that it says bring Mariah, and then it says okay, and then that previously said get me a Glock, like go now. If it's going to be out, then everything's out. But now it's saying get me, which is an entirely different thing. Now it's saying come and pick me up. And in the same way that messages might be included in order to give context, messages have to be excluded as to not give improper context. This is now saying, representing to the jury that he's asking to be picked up here. And we think that's inadmissible. The very next page, his next statement is, it's get me, and then his next statement is like now, then it says, I'll pay you, which is demonstrating some necessary urgency for him to be picked up and the fact that he'll pay for it to be done. I'm not sure how that'll be contemplated misunderstood by the jury the context of the incident, notwithstanding the data involved. But we object to any redaction which will give a direct misunderstanding to the jury, a misimpression as to the communication that took place. You can't turn it from get me to a block to get me. That's turning from get me a gun to pick me up. It should all be wrong if it's out. We can't deliberately mislead the jury.
Madam State.
Your Honor, I complied with Your Honor's request or order to take out references to any firearms on that in the possession or the request of the defendant. In terms of the messages, that is what he said. It doesn't say what it was a gun or anything of that. They can say, they can put in get me item, whatever they want in terms of to make it clear in context. He's asking her to buy something, but does not say what it is.
Thank you. All done?
Yes, Your Honor.
Take it out, just believe that. I mean, it's a firearm after the alleged incident in question, which the defendant's charged with. There's no connection with this element of the case. I'm allowing a lot of these text messages in just to show care, custody, control, and ownership of the phone. That's what it has always been about. Why I let these messages in. You can look at the message in its context, circumstantial evidence as to who owns the phone. All right, and who's using the phone, who's controlling the phone. And therefore, I allowed them in. But this is something talking about guns that happened after it. It shouldn't be there. I sustain the objection. Take it out.
Redacted additional message on
I didn't hear you. I didn't hear you. I'm sorry.
So, in light of the fact that I'm losing my voice, my intention is to publish this in its entirety. So I would ask that with the Kershaw Court and the grace of defense to let Ms. Smith help with the publishing of this.
Sure. So, no issue. You don't have an objection to that, do you?
No, sir.
That's fine.
For the sake of scheduling and efficiency, Your Honor, I'm not quite sure. I'm of the impression that this pedometer evidence that we object to and to which my motion to exclude pertains is about to come up in this session. And so I'm not sure if the court has had a chance to review the motion and the law that has been cited in support of it, but it might be time to have that discussion. Either that or I'd like the state to be admonished not to seek to introduce that information until the matter is resolved.
I guess why is the motion filed July 9th? We're 2-3 months into trial already, and you filed July 9th.
As opposed to when?
Prior to trial starting. Well, hey, Judge, we have a hearing. This is demand for speedy trial. And you're in the middle of trial, the closing portion of the state's case. You're filing a motion saying, you know something, let's take a step back. None of this evidence should be admissible. All this should have been done before trial started.
I understand. But let me refresh the court's recollection as to the actual sequence, because the court also made a reference to at the close of the state's case. This information and this objection was brought to the court's attention 2 weeks ago, at which, and I provided the court with case law. I read the relevant matters into the record, and the court took the material back, came back and said, this is too much for me to read. This should have been a Daubert motion. This is not a Daubert motion. A Daubert motion is precipitated when the state offers opinion testimony through a purported expert, at which time it triggers the defense if they have an objection to the expert's introduction of opinion testimony to file a Daubert challenging that. What this is, and as a matter of fact, when we first saw this information, and the state, we were sitting down in the state attorney's office and they were playing this stuff on a screen, and I told the state, I'm like, you can't introduce information from data that was on a text or a phone without authenticating it. I just made that statement. But it is not incumbent upon the defense to try to prepare the state for the introduction of evidence. I didn't even have to alert her to the fact that I thought it was inadmissible without authentication. But when the state purports to or attempts to introduce evidence, at that time, it becomes right as to whether or not it is properly authenticated. I alerted her probably a year before trial. But beyond that, it is not incumbent upon us to piece through the state's case and try to perfect their deficiencies in providing proper foundation for the admission of evidence. When they admit the evidence, if it's not admissible for lack of foundation, that's when the objection is right. Lack of foundation. Then the court rules on the foundation. And the fact that the state is of the position that they can introduce whatever comes off of a phone from whatever app without any foundation is a burden that they carry, and if they fail to meet it, then the evidence is inadmissible. It's not, well, the defense should have told you that this is how you should have done it, which I did, first of all. And second of all, I did alert to the court, and it does not make it inadmissible. It's not incumbent upon me to say, get an expert so I can determine whether or not that expert is sufficient and thereby file a Daubert motion. This is not a Daubert issue. This is an authentication foundation issue. And if they do not have and if that foundation has to be laid by an expert, it doesn't thereby transpose it and all of a sudden turn it into a Daubert issue. If that's what they need to put it in, that's what they need to put it in. If they don't, they don't. But it's incumbent upon the court to make a ruling at the time that evidence is being introduced. This is not a Daubert motion. This is lack of foundation. The courts are clear. You have to establish foundation for this kind of evidence in order to put it in. You can't just, and as I said in my motion, it should not escape the court's attention that the only case that the state found to rely upon was a case out of Wisconsin, which with all due respect completely misses the point. It says, Fitbit's around for a while and everybody thinks it's reliable. So what? As I said in my motion, horoscopes have been around for a while. A lot of people think they're reliable. It doesn't make it admissible. The question is whether or not their acceptance of reliability is well-founded. And that must be established in order for it to be introduced. The state has failed to do so, and it's inadmissible judgment rejected.
You start talking about acceptable reliability. That sounds like a Daubert motion to me. What's the state's position?
This is not a type of information that requires any sort of expert opinion. This is not outside the scope of a regular juror's ability to understand. It shows that there was activity and that the phone was moving around at 4 a.m. It shows that the phone was moving around again at 4:40 a.m. This is corroborated by multiple sources on the phone, and pedometers, I think the first case I cited was paid to the court, but pedometers have been in use since 1967. This is nothing new or novel that requires any additional testimony whatsoever. Based on the data, the state would submit that the activity data is well within the purview of any juror and would be admissible.
Your Honor, just one retort. There are two components, and we're conflating issues. Expert testimony is admissible, opinion testimony, when it helps to a jury to understand.
So David Howard getting a little exercise there. The judge challenged him, saying, why are we talking about this stuff, which is the admission of certain expert testimony now, and why this was not handled before the trial began? Why? He's saying, well, I'll tell you why, because we're responding to what the prosecution has done. The word that comes to mind is messy. There's just a lot of messiness in this trial, and it's really keeping it from moving right along, as I'm sure this jury would like. But hey, trials are living, breathing things, as I say. This one maybe just happens to be on a respirator. Okay, joining me to talk about this case and what's happening at the moment, Matthew Matty Mangino is here. He is a former prosecutor. He's in the Pennsylvania area there. He does criminal defense now. And Bob Mata is here, criminal defense diaries guy. Good to have you both. So, Matt, Today, pulling the plug on the case as quickly as the judge seemed to do, and as I guess as comfortable as he was in doing it, surprised me. What are your thoughts?
Well, it is surprising that the court would, delay trial for another day and then, through the weekend, because they're typically black on Friday and there's no trial. But I think what the judge is doing here is, hey, he's 4 weeks into this trial. He wants to be careful that he doesn't set up some sort of appellate issue by forcing the defense to go forward without one of their attorneys. You don't want to try a case like this twice. The judge doesn't want to get overturned. I'm sure the prosecution would be more than happy to agree to that because they don't want to try this case twice on some appellate issue. So I think the judge is being cautious, and it's probably the appropriate thing to do because of how much time they've already spent in trial and how much more time is going to be spent there.
Yeah, you start doing the math here. What are we, day 14 after 5 weeks, 4 plus? I mean, it tells you that we're getting in maybe 3 days a week at best. It kind of reminds me of the Merritt case out of California, which just continued like a bad miniseries. Bob, you probably sat there with co-counsel and maybe had some hiccups where your co-counsel wasn't available. Have you ever gotten the day off, or has the judge in most of your cases said, you can do this?
Typically, they've had us power through. I had a 6-week trial, or an anticipated 6-week trial, and one of my co-counsels was removed from the case about two days before trial, and the judge didn't grant us a continuance. He's like, you got enough lawyers, move forward. The problem is when you have one of your attorneys that is going to be handling specifically expert testimony, and if it's kind of a difficult area, whether it be DNA or forensic data type stuff, and you've had one of the attorneys kind of digging into it, because look, that's why we hire experts. I am not a scientist. I did not go to medical school. I'm not trained in forensic science. That's why I hire a forensic pathologist or somebody in the field that I need to be able to learn from in order to be able to properly direct or cross-examination or during cross-examination. Like I need that person. So if I've had a lawyer on my team that's been preparing for that and they're removed, it puts us seriously at a real disadvantage, because trying to catch up where it may have taken that lawyer months and months to kind of get comfortable to where they're going to be able to go in court and make cogent arguments and have things explained to the jury so that the jury can understand. It can be kind of a devastating move, but I agree. I think that the judge is probably trying to err on the side of caution. And yesterday was more like a sidebar sprinkled with trial.
Yeah, and again, juries love that. They love when they're cut out of everything and they're in their back room somewhere, just twiddling their thumbs, wondering what the heck's going on out there. Aren't we the ones that should be hearing this stuff? So I'm sure that's probably what they took into account was, hey, I'm guessing they're talking really about the cross-examination of Moretti, the witness on the stand now. The prosecution was about to wrap up with this law enforcement witness, and so whoever has focused on that, and I'm guessing it must be Raven Liberty. She's the one who fell ill, and the judge cut him a break. Doesn't always happen. It doesn't always happen. Let's take a break here. We will look at some of that testimony. He's been on the stand day and a half, so we'll catch you up to speed on his portion of the Melly trial right after this. So those darn cell phones, I mean, they really keep raising their heads or their screens in this case. And really over the last day or so, we've been talking a lot about them through the detective Moretti, who's been testifying for the prosecution. In between sidebars, there have been many of those. And the question became, among other things, what of these text messages from this phone comes in? Now, if the phone's already been connected to Jamell Demons, that's not really disputed, then what's all this stuff coming in for? What's it relevant for? Is it too prejudicial? Does it show the defendant as kind of a mean son at times? it's really a question as to why it should have come in, but it did. So let's go into court now and look at some of Moretti's testimony as it relates to these texts.
Publishing, page 11. Phone number ending in 6942, sent September 11, 2018 at 11:54 p.m. You're my heartbeat. I cry all the time. I miss you so much, but I know I have to let you grow up.
Phone number 9807, sent 9/11/2018, 11:55 p.m. No need to cry. You fit to be a millionaire.
Phone number 6942, sent 9/11/2018, 11:56 p.m. You deserve it. You're so talented. We played your music all night. Same phone number, sent September 14th, 2018 at 6:15 p.m. I love you, kid.
Phone number 9807, sent 9/14/2018. Love you too. I see you be chillin'. I love that. Keep doing you. Phone number 9807, sent 9/14/2018 at 6:15 p.m. Everything gonna be in place.
Publishing, page 50. Phone number 6942, message sent 10/23/2018 at 11:17 a.m. I will. Same phone number, message sent same date at 4:09:18 p.m. You look so happy. I love you.
Phone 9807, sent 10/23/2018, 4:13 p.m. I am Ma, love you.
Phone number 6942, sent 10/23/2018, 4:31 p.m. blank message. Same phone number, sent 10/24/2018, 1:02 a.m. Are you okay?
Phone 9807, sent 10/24/2018 at 1:02 a.m. Yeah, why low?
Phone number 6942, message sent 10/24/2018, 1:03 a.m. You was wild on your live. Who pissed you off? I don't like seeing you upset. Publishing, page 51. Phone number ending in 6942, sent October 24, 2018 at 1:56 a.m. I love you, get some rest. 10/26/2018, 5:16 a.m. Send me your location. Same phone number continues. October 26th at 5:17 a.m. I'm in Stewart. Same phone number continues on the same date at 5:47 a.m. I love you so much.
Phone 9807, sent 10/27/2018, 3:40 a.m. A location was sent.
Publishing, page 52. Phone number 6942, message sent 10/27/18 at 3:40 a.m. Love you. Same phone number, message sent same date at 3:23 p.m. I'm at your gate. I'm going to get the trash.
Phone 9807, sent 10/28/2018, 10:33 a.m. Bring Mariah.
Phone number 6942, message sent October 28, 2018, 11:22 a.m. Okay. Detective, you can skip that next message and move on to the final message on the page.
Phone 9807, sent 10/28/2018 to 2:09 p.m. Like, go now.
Publishing, page 53. Phone number 6942, message sent on October 28th, 2018, 2:17 p.m. Okay, what's wrong?
Phone 9807, sent 10/28/2018 to 22 p.m. I'll pay you. Phone 9807, same date at 2:22 p.m. when you get down here.
Phone number 6942, sent 10/28/18 at 2:22 p.m. Okay. Same phone number, same date. Sent at 2:23 p.m. I'm waiting on track to cash at me the 1,000. Same phone number, same date at 2:23:40 p.m. Is someone threatening you? Publishing, page 54.
From 9807, 10/28/2018 to 2:23 p.m., no mom. Phone number 9807, 10/28/2018 to 2:23 p.m., I'm not scared. From 9807, 10/28/2018 to 2:24 p.m., just listen.
From 6942, October 28, 2018 at 2:24:06 p.m. Okay, I want you safe. Same phone number, same date at 2:24:28 p.m. You're covered.
From 9807, 10/28/2018 at 2:24 p.m., I know.
Publishing page 55.
From 9807, sent 10/28/2018 to 2:24 p.m. Still need to protect myself.
Phone number 6942, sent October 28, 2018 at 2:53 p.m. FaceTime me.
From 9807 at 10/28/2018 at 3:06 p.m. J. Finn ascended. From 9807, 10/28/2018 at 3:06 p.m. He fit and ascend 500.
Phone number 6942, message sent October 28 at 3:06 p.m. Okay. Same phone number, message sent same date at 3:06:23 p.m. Okay.
I think I heard one of those texts was sent at 3:42 a.m. Is that right? If I text my mom at 3:42 a.m., I don't want to tell you what the return text would look like. Sometimes, the information you give to a jury can be received in a very different way than you intended, and I think that might be happening here. And there's something very interesting about the dynamic between mother and son, which I definitely want to talk about with my guests, and we will do that right after a quick break. Back to Law and Crime. We just heard and saw some testimony of texts that were allegedly done between Jamell Demons' mom and himself, on a device attached to him. And let's put aside whether or not that should have been introduced or not, whether it was relevant or not. It's in. The jury saw these text messages, got to decide for themselves what, if anything, it means. How does it get them closer to determining whether the defendant killed Anthony Williams, killed Christopher Thomas Jr.? That's debatable. But what I want to talk to Matthew Matty Mangino and Bob Mata about, my guests here, guys, is the ages of the participants in these texts. The mom's only 14 years older than the son. So he's 19 at the time. Remember, this was a 2018 crime. So he's younger then. It was a little later than the actual crime, as I recall, but he was still younger. She's only 14 years older, and I think that's a weird dynamic in and of itself. Do you think, Bob, I'll start with you, that plays out in these text exchanges? Does it mean anything? Does it help the jury in any way?
I think, first and foremost, it establishes that not only is there a parental relationship, but I think that there's a friendship relationship, especially when mother and son are that close in age. I think that, and especially in light of the fact that he became famous, through his rap career, I wouldn't be surprised if she had a hand in managing him early on. It's kind of the way it goes. So that relationship is definitely different than your typical parent-child relationship. In terms of whether it's landing home with the jury, I think what they're trying to show is that, look, we know that Melly had this phone in his possession because why would anybody else be texting his mother at near 3 a.m? You know what I'm saying? So I don't know that it's so much the context of what's being said in the text themselves as much as the fact that there was texts between son and mother going on at that period of time, because no one else would be doing that, right?
And Matty, there's also these texts that are not very flattering, where Jamell Demons is using the B word and talking to his mom. I don't know. Is the prosecution thinking that's going to somehow make him less likable, more guilty? It is so irrelevant, the fact that he might curse at his mom, that that necessarily means he killed 2 of his friends. It just doesn't make any sense to me. I think the prosecution thought there might be a little bonus in getting that kind of information in front of the jury.
Well, I definitely think that the prosecution, not only wanted to establish a foundation, authentication, through these messages to show that he was the person who was sending these messages. But it also helps that he says some things that a lot of people are going to feel uncomfortable with, especially these jurors. Some of these jurors are going to find it offensive that you call your mother the B word. Now, is it a slam dunk? Does this all of a sudden say, well, geez, if this guy could call his mother names like that and be disrespectful to his mother, he could have killed his friends? I don't think so. But let's not forget that these trials are about, credibility, believability, somebody that you, could almost empathize with in a situation. And if you don't have any direct contact, any understanding of how this person thinks, these language could be quite offensive and can turn you off toward the defendant. And any little thing, is going to help in a prosecution in which it's all circumstantial evidence.
Yep.
So I can see what the prosecution is trying to do here.
Yeah, never underestimate likability. And so if you're hearing these, these exchanges between mom and son that don't make him very likable, hey, it can't hurt, right, Bob?
Yeah, I guess, but I mean, we're waiting for the defense case in chief here, and I would not be at all surprised if his mother takes the stand on behalf of her, on behalf of her son. And I think at that point, the defense will pretty clearly demonstrate that this woman adores her kid, and she didn't take any offense to it. So thereby, the jury shouldn't either. That's just the way that they speak with each other in a more casual and, obviously, like you said, there's going to be jurors that are going to be like, "Wow, that's a kind of a rough way to talk to your parent."
Yeah,
but
he's just
I
a
think
gangster.
mom comes out,
Yeah.
right. But we'll see how it plays out.
Okay, lightning round here, guys. Let me start with you, Maddie. This delay, who's it helped more? Prosecution, defense?
Well, I think it helps the defense to a certain extent because they can prepare.
All right, lightning round. It's a lightning round. Bob, what do you think? Prosecution or defense?
Same, defense. All that prep time.
I'm going to thank and excuse Mr. Matty Mangino. Appreciate it, buddy. Bob sticking around. We'll be right back to Law and Crime. Stay where you are. And welcome to Law and Crime. I'm Michael Bryant. This is where I would love to be saying, let's go live into the Fort Lauderdale court to talk more about and watch the Jamell Demons case unfold. But there has been a bit of a hiccup there in the case in which the rapper YNW Melly, his real name is Jamell Demons. He's the 24-year-old accused of killing his friends. There are all these rappers working together in this special collective, and two of them were shot on this October night, 26th in 2018. Christopher Thomas Jr., Sakchaser, also Juvy. I think Christopher is Juvy, and Sakchaser is Anthony Williams. They're shot dead. And so he's now in trial for their murders, although he says, this was a drive-by. I really had nothing to do with it, just lucky to have survived. So today's unexpected turn, a couple of lawyers ill, one of them to the point she couldn't continue. That was defense attorney Raven Liberty. And the judge said, okay, well, let's just take a break, put it on pause. And that's where we are. So not only will they be off the rest of today, tomorrow, normally off on Friday anyway, back at it on Monday. So they were busy this week. They did get some stuff done. Amongst other things, the mistrial motion. I'm not keeping track real specifically. I think this is a fourth or fifth, maybe, mistrial motion by the defense. This has to do with some of the evidence that was allowed, and it was quite the discussion. So let's go in and watch this unfold.
None of the mothers on that jury who may be inclined to convict just because they've heard irrelevant, unrelated conversations between Mr. Demons and his mother, where he's calling her the B word and all sorts and manner of disrespect that is clearly off-putting to any mother. And under the pretext that they're trying to prove this phone belongs and is being used by Mr. Demons, the state is offering in reams and reams, tons and tons of inadmissible evidence that is irrelevant to this case. There is a point at which They sat there for 2 hours showing 530-something photographs. They introduced a jail call, and it seems like in the mission of proving that it's his phone, it's a license to put in all manner of evidence that is prejudicial and irrelevant. And we think that Mr. Demons' image, his character has been assassinated and irreparably tainted by the manner in which he's conversing with his mother, and the mothers sitting on that jury are now tainted in their impression of him and the manner in which they will render judgment. So we move for a mistrial on that ground and ask that the court put a stop to this if it is not going to grant that mistrial.
So just before the top of the hour, we saw some of those text messages that defense counsel David Howard is now talking about, saying, look, you know, he's calling his mom the B word and it's making him look like, like a gangster when he's talking to his mom. That's not helping in terms of this jury finding an answer to the ultimate question, but it is prejudicing this jury against my guy, especially if there's some moms in the box there that are going to be watching this unfold. So that was the focus of that particular motion. Denied, out of hand. The judge denied it very quickly. Joining me to talk about this case as we kind of break it down from the last couple of days, I have Natalie Whittingham Burrell. She is here, and Bob Mata continues to be with us here. He's the criminal defense attorney in the Chicago area and the host of the podcast Defense Diaries. Thank you both for being here. So, Natalie, let me ask you, we've been talking about the impact of these texts, and, you know, is it really just a lot of hoo-ha over nothing? Or is there really some suggestion here that what is read within these texts could prejudice the jury to the point where, that mistrial motion was well thought out?
I think that the defense is on to something here. There is a cumulative effect between the text messages and the social media, the Snapchat, where the state is showing that Mr. Demons is engaging in a certain lifestyle that the average person does not engage in, maybe using language or acting in a way that the average person does not act. And then, of course, something that is, I think, an anathema to everyone, cursing at your own mother. It could prejudice the jury. It could inflame their passions. And I can see the court side of why they would not grant a mistrial based on this, because it's not being introduced for that purpose. It's being introduced to show the identity of who the messages are coming from. But it is preserved now for appeal, and the defense is doing what they're supposed to do, pointing out the fact that it is prejudicing their client, and then they have, if he is convicted, a way to try and appeal it because the issue is preserved because they've objected.
Yeah, and I think the list, they're adding things to their post-conviction list. If there is a conviction, they're going to have a lot of appellate issues, and this is just one of another. Bob, it seems like we were just talking, the other day about, hey, the prosecution was going to finish strong. We heard from the medical examiners. Then we heard from their shooting reconstructionist, and we were very impressed with that, even though we thought the prosecution might have had a slow start. I think they're bogging down again, and I don't know, where's the crescendo to the case?
I agree, and we were talking about it last week. To me, that was the end. That was the fitting end, because you had some pretty powerful evidence come in, at least in terms of putting him in the car and it appearing that the shots came from within the car. I mean, to me, that's your end game right there. Now we've gone through 2 full days of these text messages coming in, with a jury having to sit in the box after 5 weeks of coming to that courthouse, and now just being tortured with, Elmos of screenshot after screenshot after screenshot after screenshot of these text messages. And they're sitting there wondering, like, we've got three attorneys in here trying to figure out what is the context. And obviously they're doing it as a sheep in a wolf's clothing, or a wolf in sheep's clothing. And, in terms of getting the fact that, look, this was Melly's phone, but what the point was of counsel for his motion for mistrial was like, look, they're getting in all this other stuff by way of just trying to prove that this was his phone and he had it in his hands. They're getting in tons and tons of evidence. So I don't know, the way that they put this together is befuddling to me, and I think it could end up biting them in the end. We'll see, but it's strange.
Yeah, I just keep thinking of the word messy. It just seems to be a little messy, and your audience doesn't like messy. The jury likes things handed to them, kind of bite by bite in the way that the meal should be presented. And it's a bouillabaisse of something. I'm not sure where it's going. Okay, let's look now at some of the detective who was used to get the foundation for these texts and sat there for the last day and a half as it unfolded. Here's some of his testimony.
Okay, Detective Meridian, approach and show you what's in label that states quintuple Q for identification purposes. Do you recognize that document?
Yes.
How do you recognize that document?
It is the data that was extracted from the phone regarding the Apple Health data, the discussed patient on the day.
And does that data fairly and accurately represent the data that's on the phone that is now in evidence?
Yes, ma'am.
How do you know that?
I personally verified it by opening up the device and manually scrolling through that specific data to verify how many steps were taken on what date, what time.
In terms of the GPS points and things that are on that phone as well, did you verify those?
Yes, ma'am.
You could explain the start time and the end time.
It's when the phone reads or detects that there's movement, so it starts, it creates a start timestamp, which is already converted from UTC to our present time zone, Eastern Standard Time. And when the phone detects that it's no longer moving or in activity, then it stops. In which then you see the last launch 10/29/2018, 5:40. In Eastern Standard Time. You see a little parentheses where UTC -4. That's just telling me that the phone already converted from UTC to Eastern Standard Time.
So when I want to go to October 26th for the start time, so going to entry number 43. If you could be so kind as to read the start time, date, and the end time.
Okay, the start time was 10/26/2018, 12:29 a.m. And the end time was 10/26/2018 at 12:47 a.m.
Does at that point the device record steps or movement?
Yes, ma'am.
And does it record a distance?
Yes, ma'am.
So continuing forward. To October 26th, the start time 2:57 a.m. to 3:04 a.m.
From 10/26/2018 to 57, it started registering movement. It recorded 5 steps, traveling 4 meters, and the end time was 10/26/2018 at 3:04 a.m.
Going to number October 26, 2018, 3:12 a.m., entry number 48 from this data.
That was the start time, and then the end time was 10/26/2018, 3:19 a.m., which the device detected 38 steps, traveling 28 meters.
Going on to number 14. I'm sorry. To number 49.
The start time where the device detected movement, it was 10/26/2018 at 3:19 a.m. And in the end time when it no longer detected movement, it was 10/26/2018 at 3:35 a.m. It detected 70 steps, traveling 33.34 meters.
Going on to number 50.
The start time was at 10/26/2018 at 3:46 a.m. and the end time was 10/26/2018 at 4:02 a.m. The device detected and recorded 70 steps, traveling 40.93 meters.
And on number 51.
The start time of the detection of movement was 10/26/2018, 4:20 a.m. And the end time was 10/26/2018 at 4:48 a.m. Total of 1,397 steps were detected. A total of 947 meters was recorded.
In terms of the social media accounts that you reviewed on this case, did you look at other people's as well? I know you've spoken about Mr. Hedgepath.
Yes.
And reviewing Mr. Hedgepath's Twitter account, you mentioned that you thought there was a photo that was published.
There was a photo. It was an image of what would appear to be like crosshairs from a reticle scope, and it said something in the nature of "we aiming at you," and it said "diss track YNW Melly," and then in the caption it made reference to the Jeep.
So you've had a chance to review that. I don't have to pull it up for you to refresh your memory. Thank you. Detective Moretti, in terms of the timing on that diss track that came out, how long after the homicide was it?
I believe the release date was going to be November 2nd.
And for the contents of that song, did you review those?
No, ma'am.
Was there any other evidence other than one song lyric that tied David Hedgepath to Miramar on October 26th of 2018?
Nothing.
Every time I hear one of these experts talk about what our phones have in them, in this case the Apple phone and the Apple Health app within the phone, you just want to take a hammer to it because there is nothing you're doing that isn't recorded in some way somehow. That of course assumes that the phone to which Jamell Demons is attached was actually with him when all these things were happening. We have to make that assumption. The prosecution certainly is, and I think they're counting on the jury making that assumption. Natalie, beyond that, there's that gap in time from roughly 2:17 when they left the studio to 4-something when they went to the hospital. And that is the period within which this expert is talking about these many steps taken by Melly. What do you make of that? Where are they going?
They're going to make the argument, the prosecution, that Melly was orchestrating this crime at the time. That's why he's making all those steps. And of course, the defense in rebuttal in their closing argument, they're going to be saying, look, he could have been doing anything. He could have been on his way home. He could have, gotten out of the car and, ran away. Those steps show that he was also the victim of the shooting because now they're kind of wedded to this drive-by shooting story. But it just helps to paint the picture for the prosecution. I guess if he was dead still at the time that the shooting is supposed to be happening, it's unlikely that he would have been shooting someone and then shooting a car. But either way, it's kind of neutral evidence because it doesn't show you what the person's doing. It just shows you that they're moving. Yeah, and it has to be a piece that the prosecution can then tie to the rest of their story. If you don't believe the whole story, then this doesn't mean much to you. Bob, again, I always get back to, maybe he left his phone in the car. It wasn't attached to him at the time, and one of the other occupants then picked it up and was doing the moving around that the prosecution is now attributing to Melly. It's possible.
Absolutely. I mean, it's just like Natalie was saying. I mean, the fact of the matter is we have no idea what he was doing, and acting like 71 steps is some kind of massive amount of steps. I mean, if they had me, like when I'm on a phone call, I'm pacing around constantly. I probably have 5,000 steps during an hour-long conversation because I'm walking around the whole time. I mean, the fact of the matter is we just don't know what he was doing, and that's a bigger problem for the state because it's their burden than it is for the defense. And ultimately, whether or not they're going to get the jury to buy it, is going to have to be the patchwork of all the evidence that they presented, which brings us back to our earlier point of have they done it in a cogent manner where the jury's going to get it? Because at the end of the day, all of this is done for the benefit of a jury. It's not done for the judge. It's not done for the defendant. It's all done to tell a story to the jury, and ultimately they're going to have to either buy the state's theory or they're going to have to buy the defense's theory, and that's what it's going to boil down to.
Yeah, and if they may never get as far as considering the defense alternative. If the prosecution doesn't convince them, their story is actually what happened that night. So why do we pace around when we're on the phone like that? What's the psychology behind that? I'm not sure. Okay, let's take a break. Another unanswered question here. We'll come right back, talk more about this case out of Florida in just a minute. So if you liked Detective Moretti yesterday and today, you're going to love him on Monday when he's back, because they are dark in the Jamell Demons case. Until then, one of the attorneys for the defense fell ill, the judge giving everybody the days off to hopefully get healthy and get back at it on Monday. So he's back on the stand. This is, of course, the case in which the defendant is accused of killing his two rapper friends. And we want to look at some more of his testimony, which includes, the most interesting part of this testimony is his laying the foundation for a documentary that was done about Jamell, which included Sakchaser and Juvy, the two that killed in this case. Very interesting stuff. And producer Elizabeth, who is, she's done all things Melly, she's digging deep here. She says it's about a 20-minute documentary, but they showed about 2 minutes to the jury, which you are about to see. Watch this and the rest of this testimony from the detective.
So I'm going to go to November 30th of 2018. Did you go to Cocoa Beach?
Yes, ma'am.
Why'd you go to Cocoa Beach without saying what was said?
I went there to meet an individual witness in this case who was concerned for the safety of one of their children.
Without saying what she said or what they said, what was the demeanor of this witness?
She was very fearful for one of her children's safety.
And so who was this witness that you met with on November 30th of 2018?
Felicia Holmes.
I want to go forward to December 4th of 2000, December 4th or December 5th, please correct me if I'm wrong, of 2018, were you made aware of a documentary that was published by the defendant?
December 4th, yes, ma'am.
And this documentary, what platform was it on?
YouTube.
Was that publicly accessible?
Yes, ma'am.
Did you review that documentary?
Yes, ma'am.
The defendant's record label published this video?
Yes, ma'am.
At this time, you're on the state with offer states Triple X, States 98.
Any objection?
No, sir.
I am your single. I don't care who the fuck you like. I'm your favorite single. I don't care who it is. I am them. I watched every video they did, every mistake they made, every good thing they did, every sound they made. I know that shit. I know how to do it.
Detective Moretti, after you saw this video, I want to segue now into some of the other online investigations and other people that you looked at. Did you solely focus your homicide investigation on this defendant?
No.
So let's talk a little bit about an individual by the name of Robert Colburn. Who was Robert Colburn?
Mr. Colburn was a young 15-year-old kid. He posted something stupid on social media.
Objection to the word stupid. He doesn't know what it is. I'm sorry.
One or two words. No speaking.
Objection hearsay.
Thank you. Sustained.
So in terms of the post on social media by Mr. Colburn, did you view it?
Yes, ma'am.
And did he have a specific Instagram handle or name that he was using?
Yes.
And what was that?
Could I refer my notes?
If you need to refresh your recollection, please do. What was the Instagram name of Mr. Colburn at that time?
It was Brackwoods. BRACKWOODZ.
And at some point, did you speak with Mr. Colburn?
Yes.
And in terms of when you interviewed him, how long after the homicide was passed?
It was a day or two after the homicide that I think it was actually that day, that evening, he made an inappropriate comment online.
Objection.
Okay. And when you say,
She made a comment on law, sustain.
so without going into what was said on that, did you find or locate any location data that placed Mr. Colburn in Miramar on October 26, 2018?
No.
Did you find any casings that matched the homicide scene in Mr. Colburn's vehicle?
No.
Did you find anything else other than the online posting, which we can't get into the content of, that Mr. Colburn did that would show he was involved in this homicide?
Absolutely not.
Okay, so clearly the most interesting part of this testimony is that video, the documentary, the condensed version there, the Reader's Digest version, just a couple of minutes. And if at the end you could not read what that little postscript said, and it was driving you crazy, as it was for me when I first saw it, it said, 4 days after the completion of this film, YNW Melly and his friends were the targets of a drive-by shooting. So that's what it says. Oh, you can see it better there. That's much better. And so the question becomes, Natalie, Bob, what is the impact of this little mini documentary, number one, and that postscript, number two? Natalie, what do you think?
I think maybe to humanize the decedents in the case, the two victims. But in turn, it kind of also humanizes YNW Melly. I'm not quite sure why the prosecution is using that. And then maybe tying in the whole, this is the story that YNW Melly is sticking to, that they were the victims of a drive-by shooting and that he was present at the time of the drive-by shooting. So it might be going to that as well, saying that this is his story. This is what he even put in a documentary. Even if you never heard from him, this is his version of events, and we have thoroughly debunked it. But outside of that, it makes everyone involved look very human and very sweet when they just had text messages that made people look like they might be bad people.
Yeah, I think that's interesting, and it's going to depend on each individual juror's perception of this lifestyle, I guess, Bob. This could cut the other way, don't you think?
100%. I mean, it's just like Natalie said. I mean, like you're actually getting to humanize people that, you may have no idea how people live in terms of other areas, in terms of other neighborhoods, in terms of other cultures. And I think it's actually very helpful to the defense because it gives you kind of like an inside tour, behind the curtain tour of the humanity of these people, that these are actually human beings and that they all had their own lives and that they were all sweet kids. And, I don't know why the state put this evidence on, to be honest with you, other than when she tried to tie it in to develop this theory with Moretti on the stand that he didn't develop tunnel vision as to Melly and that he actually did look into some other potential suspects aside from just Melly. But I mean, it seems like a weird way to go about getting to that. So I don't know.
Yeah, and Natalie, I could see, that last postscript is a little self-serving. Hey, see, this whole drive-by shooting thing was, not just a figment. But I have to think the prosecution wanted this in thinking, like the text messages, it would put their the defendant, in a bad light. Not a good light, in a bad light. I have to assume that's what they thought. What do you think?
It just doesn't. It doesn't put them in a bad light. It shows them working on their music, talking to each other, maybe them holding, cigarettes or blunts in their hand. Maybe they have some old-fashioned way of thinking that people are going to see that negatively, but we know that times are changing as far as that's concerned. And it showed them interacting with each other. It didn't show any tension. It didn't show that there was this motive that they're going for, that there was some type of tension about gang membership or money, royalties or ownership. They're friends, they're getting along. And I think it goes more towards the defense side of things, which is saying, what reason would YNW Melly have to commit this crime? Other than the postscript, I really don't see the purpose of showing them in a humanized way if you're the prosecution. This is maybe something I would think the defense would play.
Yeah, that's what I think is so fascinating. I mentioned it earlier. Sometimes the evidence presented has unintended consequences. Maybe they just weren't reading it right. Very interesting. And I would love to talk to the jury after the fact and see what their thoughts were on these very specific pieces of evidence. I don't know if that's going to happen or not, but we got a long way to go because the defense hasn't even begun their case yet. We'll take a break. We'll come back, talk more about the Melly case. It is a double homicide. It is a death penalty case. We'll be back. Back again covering the Melly case out of Fort Lauderdale, Florida. They are dark today, tomorrow, Friday, back at it Monday. Had some illness in one of the legal teams. So we've been looking at some of the testimony of the witnesses who have taken the stand this week. Remember, one of the key issues in this case is where was Jamell Demons at the time of the shootings? He says he wasn't even in the car we see him get in from video when he leaves the studio at about 2-ish or so on the morning that this took place. So where did he go? Where was he? Who could shed light on that? Well, maybe one of the folks in the other car. You'll see 2 cars parked together in that video. One's a red car, and the guy on the stand earlier in this case named Trevian Glass was one of the people in that red car. Maybe he can shed some light on exactly what happened after they left the studio. So let's watch some of his testimony.
So let's go back to October 26th of 2018. What were you doing like for work?
I wasn't working at all.
All right. Were you involved in the music business at all?
Kind of, sort of.
And how so?
Making beats.
All right. And when you were making beats, were you working with a specific group or music group or people?
One person to be particular, but yeah, supposed to be in a group.
All right. Let's start by saying this. What group was it?
YNW.
All right. And when you said one person specifically, who was that person?
Juvy.
Okay. And can you tell the members of Juvy's real name?
Christopher Thomas.
And how long had you known Christopher Thomas, who you refer to as Juvy?
Over a decade.
Okay. And this is back in October. And did you know somebody by the name of Anthony Williams who went by Sakchaser?
Yeah.
And how long had you known Sakchaser?
A couple years.
Publishing 10/26/2018, beginning at timestamp 2/17/42. Mr. Glass, you recognize the 2 individuals in this screen pause at 2/17/47.
Do I recognize the back of the head?
Yes, you recognize them.
I just see it back of the head.
Okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52?
Still back of the head.
Do you see an individual standing next to a red vehicle?
Yeah, that's cool.
Okay, you just said that's who?
Cool.
All right. And what is Kobe's real name?
That's what I know about Kobe.
All right. Would anything refresh your recollection as to his legal name?
I don't know.
If I were to show you your prior statement, would that refresh your recollection?
Good.
Permission to approach the witness?
Right.
Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. As your memory is refreshed as to the legal name of Kobe?
Yeah.
And what is Kobe's legal name?
Objection.
What's your objection?
Sorry, I was wrong.
Jacob Mills.
All right, I'm going to continue to publish date 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual?
Not really, no.
Okay. How about the individual that is standing at the gray Jeep?
That's sad.
Okay. I'm going to continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep?
I see him, yeah.
Do you recognize him?
That's AD.
Okay. And again, I'm going to ask you for AD's legal name.
I know his last name, Davis.
Okay. Would looking at your statement refresh your recollection as to his legal name?
I guess so.
Honor permission to approach.
Can I same statement?
Yes, Judge. What is AD's legal name?
Adrian Davis.
Mr. Glass, let me know if I need to rewind the video, but you had a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts?
That's me.
Okay. Continuing to publish. I'm pausing the video at 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket?
Say it again.
Do you see that person on the video?
I see the back of his head.
Do you see the back of the head of the person wearing the jeans jacket?
Correct.
Was that person the same person that you previously identified in states?
Sustain, rephrase it.
Okay. We previously looked in state 72 at an individual you identified as Melly.
Objection.
Sustain.
Do you see the jacket in states 72, image number 3? The front of that jacket?
Yeah.
You see that jacket in states image 1 of state 72.
I see the same thing y'all see.
We spoke about this, Mr. Glass.
I understand that.
You ask questions, all right?
I'm asking questions, Mr. Glass, and I'm just asking you to respond if you have knowledge. Is that jacket that was in image number 1 and image number 3 the jacket that Melly was wearing on October 26th of 2018?
To the best of my knowledge.
To the best of your knowledge, yes or no?
Yes.
Publishing state 7. And then go. Okay. Back to state 7, timestamp 2:18:41. The individual that's on screen wearing a jacket and it appears to be something across his back. Who is that individual?
Objection, ask and answer.
Overruled.
Mr. Glass, you can respond.
I see the same person as last time.
Okay, and can you tell us who that same person is?
So Trevion Glass, he's in charge of the beats, as I understand it, in working at the studio there. But it sounds like Mr. Glass is a bit of a pain. That's horrible even for me. But he's not helping out as much as I'm sure the prosecution would like. But this is critical info about who was in what vehicle, when, and where. At least it's a starting point at 2:17 in the morning. After they left and before the drop-off of 2 dead men at the hospital, a couple hours passed. That's the time period that is a big blur. Taking a break, talking to my expert panel about that when we come right back. Welcome back to Law and Crime. Again, continuing our discussion of the Fort Lauderdale case against Jamell Demons. Just heard from a very interesting witness. You get the witness you get, and I'm sure the prosecution enjoyed Trevion Glass, what he might bring to the mix. He was very important in helping understand who left the studio in October, the 26th, 2018, about 2:17 in the morning. There they are. He's putting each person in their positions in the cars. He's the guy, one of the guys getting in the red vehicle there. But beyond that, I don't know. Natalie Whittingham Burrell is here. Also, Bob Motta. Guys, thanks for sticking around and watching this performance of this guy. I'm just going to ask you, Natalie, what do you think, and did he help the prosecution?
Well, he helped to establish that it was Jamell Demons who got into the back seat of the vehicle. And then, the prosecution is going to build on the fact that their expert says that the victims were shot from the back seat of the vehicle. But that's pretty much it. He doesn't put himself at the scene of the shooting. He doesn't say that he knows or doesn't know who the shooter is. And he's highly hesitant and does not want to be there. Like many of the civilian witnesses that the prosecution has called, they seem like they've kind of been browbeaten into being there for whatever reasons. And so that could cut one of two ways. It could cut in favor of the prosecution because the jury might think, Mr. Demons is somehow threatening to people or people are afraid of him. Or it could cut to the way of the prosecution doesn't have a case, so they need to badger people to get them to testify. You won't know until the jury goes back there to deliberate.
That's interesting, yeah. And I think, Bob, one of the tidbits from Mr. Glass was, I think near the end of his testimony, he really regretted that he hadn't smoked that day. That was kind of a big concern that he didn't get that done in time. I guess out of respect for the court, but maybe he would have been more lucid if he had. He was, as Natalie suggests, hesitant at the very least. I don't know. Would the jury hold that against the prosecution? What do you think?
I don't know. I loved his testimony. I mean, clearly he was subpoenaed. He was not there willfully. He was there against his will, I'm sure. And I actually loved that part of the testimony. I think she was asking him how often he smokes or when he smokes, and his answer is when I smoke. Like that whole part of that testimony I thought was great. Ultimately, I think how that's going to play off to the jury is going to be, it was evident that he didn't want to be there, and that like if he's going to be construed as being a rat, that's not him. That's not what he does. So they were really having to try to extract information out of him. And I think that plays to the defense, honestly. I mean, it's one of those situations where if you had a witness there who knew something and was dying to tell the jury, well, you'd know it. This had the opposite effect of that. So at the end of the day, we'll see what the jury does.
Natalie, I think this kind of, points out the prosecution's weakness, one of them, and that is, okay, we all can see who's getting in the car. It's great that we have a name for the people to get in. What the heck happened after they left and before the people died? I mean, that's still, it's a black hole, and I don't see anything coming along to fill that in.
The prosecution's key witness is to say who was in the car at the time of the shooting. They want you to jump to a conclusion that YNW Melly was in the backseat of the car at the time of the shooting because you see him getting into the car. But what firm, concrete evidence do they have that he was the one that was there at the time of the shooting, or that he was a shooter, because they don't have a gun? And I think that the best evidence for them is not only their reconstruction, but the story that it was a drive-by. And we'll have to see in the defense case.
That's the tough, to me, that is just so difficult. And unfortunately, we got to wait till Monday now to see that continue to play out. But I'm going to thank and excuse Natalie, Bob. Always a pleasure to have you guys along, and I look forward to seeing you the next time. That's going to do it for me, Michael Bryant. Hey, try to do the right thing. We'll see you next time right here on Law and Crime. Have a great evening.